Ladies and gentlemen, are we good to go? Yep. Is the microphone working? Court reporter can hear. Respondents, are you still organizing yourselves there? Are you still organizing yourselves there? Sure. Okay, ladies and gentlemen, welcome. It's good to have you all here and nice to meet you all in person after the various discussions and meetings that we've had online over the last few years. Welcome to Paris. Let's start off with some introductions. Members of the tribunal, you know, but for sake of the court reporter, I'll just introduce us all. I'm Daniel Bethlehem. I'm presiding in these proceedings. To my left is Andres Jana. To my right is Zachary Douglas. We've got the ICSID Tribunal Secretary, Oladameji Ojo, to my left, and we've got the Assistant to the Tribunal, Professor Philip Webb, to my right. And we have the court reporter, Anne-Marie Stollard, who's with us as well. Let me turn claimants to you to introduce your team, and Mr. Anway, I believe that I'm going to be calling upon you and then you are going to allocate tasks on your side.
Thank you, Mr. Chairman. My name is Stephen Anway from Squire Patton Boggs. And with your leave, I'll ask each of the claimants' team members to introduce themselves.
Good morning. My name is Rostislav Pekash from Squire Patton Boggs.
Morning. My name is Maciej Pustajs from Squire Patton Boggs as well.
My name is Helena Shvandova, also from Squire Patton Boggs.
Good morning. My name is Nenad Stankovic from Stankovic and Partners.
I'm Bill Rand from Vancouver.
And Broshko from Vancouver.
Eugene Broshko.
Good morning. My name is Igor Markievich from Melbourne.
Welcome to all of you. Ms. Mihaj, would you like to introduce your team?
Good morning to everyone. My name is Senka Mihaj from Mihajlic Milanovic. I'm one of the counsels for the respondent. And I would like firstly to present the representatives of the State Attorney Office of the Republic of Serbia. Today we have with us Ms. Olivera Stanimirovic, State Attorney of the Republic of Serbia. We also have Mr. Marinko Chobanin, Ms. Violeta Maglov, and Ms. Milena Babic, also from State Attorney Office of the Republic of Serbia. And then together with me, we have counsels of Republic of Serbia. These are Mr. Moritz Keller from Clifford Chance, Mr. Vladimir Đerić from Mikija Janković Bogdanović law firm. Then we have Ms. Sara Lemoyne from Clifford Chance, Monica Dale, also from Clifford Chance. Then I think that there is my dear colleague, Muhammad Tulic, also from Clifford Chance. Then there is Ms. Kristina Petronijević from Mikija Janković Bogdanović law firm from Belgrade. And then we have Ms. Marija Alhaj and Sara Stojković from Mihajlic Milanovic law firm from Belgrade. Thank you.
Thank you very much and welcome to you all. And thank you from the tribunal to the parties for your cooperation in good spirits to get to us the electronic bundles in time and to the proceedings to this point. Before I raise any issues, let me just turn to each party and inquire whether you've got any housekeeping issues that you would like to raise with the tribunal at this stage. Claimants?
Not for the claimants, Mr. President.
Respondents?
Not for the respondents.
Thank you. Then let me just make sure that we are all collectively on the same page and inquire of you specifically whether there are any issues relating to the availability of your witnesses over the course of next week that we might usefully be apprised of at this stage, including whether since the procedural order was transmitted to you, whether you had any further thoughts about the timing in the hearing schedule relating to the witnesses that we might usefully be aware of at this stage.
We have no difficulties with our witnesses or experts or any timing related issues.
Right, and your witnesses and experts will be available as per the procedural order in a period both before and after they are due to testify in case timing dictates.
They will, Mr. President.
Ms. Mihaj.
Same for the respondent, the witnesses will appear as agreed in the procedural order.
Great, thank you very much. For today's proceedings, which are just the opening submissions of each side, in accordance with the procedural order, each party has 3 hours. Those 3 hours for today, but for today only, will include tribunal questions. Expect us not to be shy, but expect us also to be reasonably disciplined in the sense that we will not push you into lengthy answers to take up time that might otherwise be allocated, but do also be very much aware, as you will have been from the pre-hearing call, that the tribunal regards Friday afternoon next week as a rather important period. I think I intimated on behalf of the tribunal our curiosity that each side has wished to forego formal closing statements, but we are going to signal questions that arise as we go along and encourage you to engage with those questions, if not on the spot, then certainly in the course of the closing session Friday next week. So please do be alert to that. So that's paragraph 18. The tribunal secretary will keep time. As we get to the witness examination next week, of course, the tribunal time will be its own time rather than the time allocated to each party. And I note simply for the record that in accordance with paragraph 18 of PO6, this is on the basis of the parties' agreement, the claimants will have a total of 14.6 hours and the respondent a total of 16.6 hours to allocate as you see fit. We'll move shortly to opening presentations. I note that we have from the claimant demonstratives which were sent around at some seemingly very early hour, but I'm not quite sure of the time zone this morning. So we've got demonstratives for the claimant. I believe that the opening presentation itself is due to be circulated. Is that correct? Yes. It has been circulated. Okay, it hasn't come through to us. It's just coming. Well, with that said, unless there are any further issues that either party would like to raise, we'll move to the opening submissions. Let me also just check whether my colleagues have any issues that they'd like to raise. Not at this point. Well, let's make sure that we get those opening presentations before you kick off, and then Mr. Anwar, I'll give the microphone to you. What we are receiving now, can I just be clear? These are the demonstratives that were sent. Or, this is the opening statement. I'm sorry. It includes the demonstratives. Okay. We don't have this yet in soft copy, do we? You have just forwarded. Thank you very much. Well, Mr. Anway, I think over to you.
Thank you, Mr. President and distinguished members of the tribunal. On behalf of the claimants, we'd like to thank you for the careful time and attention you've paid to this matter. It is an honor to be before you today. Our opening statement will be divided into the following 5 sections, which you'll see on slide 2. First, I will provide our case in chief. Second, I'll walk you through each of Serbia's 4 major defenses on the merits. Third, with your leave, Mr. President, I'll pass the floor to Mr. Pekash, who will address Serbia's violations of the treaties at issue. Fourth, Mr. Pekash will then show you that you have jurisdiction to adjudicate these breaches. And finally, Mr. Pekash will conclude our presentation with admissibility. With that, members of the tribunal, I turn to our case in chief. Members of the tribunal, we would respectfully submit that this is a textbook case of indirect expropriation. The claimant's Serbian company, Obnova, has used certain buildings in Belgrade and has had the legal right to use the land on which those buildings were constructed for over 75 years uninterrupted. And the claimants in this case invested in Obnova for the purpose of developing that land. But in 2013, Serbia rezoned that land, which took away claimants' ability to develop it. And it has refused to pay any compensation whatsoever. We will show you during this hearing, members of the tribunal, that Serbia's taking violated Serbian law, the Cyprus-Serbian Bilateral Investment Treaty, and the Canadian-Serbian Bilateral Investment Treaty. As you can see on slide 4, the buildings and land at issue are located in central Belgrade during and near the Danube River. They are located on a street called Duvnaska, which means Danube Street in Serbian. These properties at issue are located on the northern side of the street, and the addresses on that northern side of the street are odd numbered. So 17, then 19, then 21, then 23, Duvnaska Street. And the addresses at issue in this case are 17, 19, and 23 because someone else owns 21. On slide 5, you'll see an aerial picture of 17 and 19 Duvnaska Street. And you can see 15 buildings that Obnova has built on this property. On the next slide, you'll see an aerial picture of 23 Duvnaska Street and the 9 buildings that Obnova has built on this property. Again, it is undisputed that Obnova has used this land and the buildings on both of these premises uninterrupted for 75 years. Now, Obnova was first created in 1948 during communist times. And when it was first created, it had a different name, Otpad, but it was the same entity. Shortly after the fall of communism in 2003, Serbia underwent a process to privatize its state-owned assets. And Obnova was one such asset. Now, upon being privatized, Obnova was transformed from a socially owned enterprise into a joint stock company. The privatization only allowed the purchaser to acquire 70% of the shares in Obnova, and the remaining 30% went to the employees. On the 12th of September 2003, the privatization agency concluded the privatization agreement for Obnova with a Serbian national. And you can see here on slide 8 the reference to that 70% share. And at the bottom, under the heading conclusion of the agreement, it states that by concluding this agreement, the buyer shall, acquired the right to manage and participate in the profit, as well as the right to a part of the liquidation value in proportion to the amount of the purchased capital. Now, what are the legal effects of Obnova being privatized in 2003? Well, I want to distinguish right here at the outset between the buildings on the one hand and the land on the other hand, because the legal effect between them is different after the 2003 privatization. Let's focus first on the buildings. The buildings at issue became the private property of Obnova when it was privatized. That is to say, Obnova's right to use the buildings at 1719 and 23 Duvnaska Street were in fact all listed on the privatization documents specifically. And upon privatization in 2003, they automatically converted into Obnova's full private ownership. Now let's talk about the land. The land after 2003 remained in state ownership. However, Obnova retained what's called the right of use over the land. Now, I confess, as someone that did not grow up in former Yugoslavia, this concept was foreign to me. It may be to some of the members of the tribunal as well, and many of the legal principles that you'll be hearing from us today, I don't think are usual or common to at least some people from different legal backgrounds. But this notion of a right of use is something that both parties' legal experts agree upon. And we will be talking about it in some detail today. This right of use over the land included the right to exclude third-party users from using the land. And now I come to a crucially important point on slide 10, and that is that both parties' legal experts on Serbian law agree that in 2003, this right of use over the land was the Serbian surrogate to private ownership. And here on slide 11, you can see where Serbia's own legal expert, Professor Jovanovic, admits the point. And I think it's worth reading in full. And I quote, "This right of use was a property right. 1, a right over the property. 2, an absolute right that had the legal effect against all third parties. Everyone was obligated to respect and not disturb the holder of the right of use in its possession, use, and disposal of the property. And 3, a right that legal practice and legal science regarded as a surrogate to the ownership right." I just want to say here at the outset, members of the tribunal, that we agree with this conclusion from Serbia's legal expert. And indeed, our own Serbian legal expert agrees with this proposition, which you can see on slide 12. This point is now common ground between the parties. All right. 10 days after Obnova was privatized.
Sarah, may I just stop you for a sort of brief question? And maybe that this is something that we'll come to next week. But would you comment on whether Obnova's privatization was unique in any way? In other words, was this simply a standard privatization that applied across the sector, or was there something exceptional about it?
Mr. Chairman, that was a standard procedure.
Can I just follow up with a question? Is it your case that privatization can confer title to something which didn't exist prior to the privatization? So, for example, if Obnova didn't have ownership rights over buildings, was it possible for that title to be granted in the privatization process? In other words, isn't it still required to do an analysis of what rights, precise rights Obnova had in relation to those buildings before the privatization, because privatization couldn't be constituted with those rights? Is that accepted, or is that still disputed?
The answer is more nuanced. The privatization did confer ownership rights on the basis of the right of use over the buildings that Obnova had prior to privatization. So the privatization transformed the right of use over the buildings into ownership rights over the buildings. It did not transform the right of use over the land, because at that time, construction land had to be in the ownership of Serbia under then applicable Serbian legislation. That changed only later on.
On your case, privatization had a sort of dual function. It privatized the shares, but it also had the effect of transforming rights that the company had to particular assets.
Correct.
And just coming back to the question about whether it was a standard privatization or exceptional, and you indicated that it was a standard privatization. Do we see, and again, this may be something that you'll come on to, a sort of similar process of endeavoring to clarify rights across this sector, or was this something in your experience that was particular to Obnova?
That is also something we see across the sector. We will come to it later. The let's say level of registration and status of rights to the land was in a bad shape, shall we say, in Serbia at the time. It is admitted that, for example, as of 2022, there are still 2 million buildings in Serbia which do lack some permits. And obviously, compared to the size of Serbia, 2 million buildings is a very large percentage.
Thank you. So we'll get to this when we come to the experts.
May I come back a little bit to the issue of the privatization, and just to say this legal concepts are not unfamiliar to someone coming from civil law. So that as I understood your position is, Obnova has certain rights over the buildings at the moment of the privatization. The privatization doesn't create, change those rights, except for that those rights become property rights as opposed to right of use. Am I correct, or there's some constitutive element in the privatization process as well?
I would say there's a transformative element. So what Serbia inherited from communist times was right of use as surrogate for ownership, as we saw it, the experts agree on it. And Serbia was then gradually transforming this surrogate of ownership into ownership. May have been a change of vocabulary, and the effect of privatization was with respect to the buildings to transform the surrogate into ownership.
And that transformation, and I understand your position, is ex lege.
Correct. I believe that the ex lege character of the transformation is not disputed either.
We're going to fast forward only 10 days after Obnova was privatized. So now on the 22nd of September 2003 in the timeline, the city of Belgrade published a regulation plan. We've defined it as the 2003 RP. Some people call it the master plan. And it zoned the property at issue and the surrounding areas. Now, I want to be clear at the outset, and we'll come back to this later in our opening statement today. But the 2003 RP, or the master plan, was the higher level planning document under Serbian law. The lower level planning document, which we'll come to several years from now in the timeline, is a more detailed plan called a detailed regulation plan, or what we've defined as DRP. And the key point I just want to emphasize here at the outset is this DRP is subordinate to the 2003 RP, and most importantly, that the DRP, the detailed plan, must be in line with the higher RP. That is to say, it must be in accordance with the master plan. And I will show you the provision of law that states that explicitly in a moment. So what we have now in 2003, 10 days after privatization, is the 2003 RP, which zoned the property at issue in the surrounding areas. And let's look at that zoning document, which you'll see on slide 15. The 2003 RP, now on your screen, zoned the land at issue in this case for commercial zones and city centers. And you can see that from the legend on the right side of the map. Right here, we've circled it. It's in red, commercial zones and city centers. And we'll have an arrow that points directly to the property at issue. It's also marked by name on your screen, Omniva, and you'll see it's red. And therefore, this 2003 RP zoned the property at issue in this case for commercial zones and city centers. I want to call one other thing to your attention from this slide, and that is an area directly across the street from Omniva's property. It's to the south of the street, and it has a different color, you'll notice, in blue. The legend on the right side of the map states that this lot, across the street from the Omniva property at issue in this case, is for traffic and roads. Now, in fact, and this becomes important later, members of the tribunal, for decades before this 2003 RP and long after, the city of Belgrade used this land, and it used it for a bus depot. Okay, and we'll come back to why that's so important in a moment. Now, back to the red areas of this map. What did commercial zones and city centers mean? The next slide shows us. This is section 4.5 of the 2003 RP, which states that commercial zones and city centers mean, and I quote, we have it underlined here in red, commercial facilities, and then skipping down with possible housing on higher floors. In other words, the red zones zone the area not just for commercial use, but also certain residential use as well.
What weight, again, you're going to come back onto this, but what weight is to be given to the word possible housing on higher floors, particularly when you view that in the context of your cases, I understand it, that the DRP has to be faithful to the DP.
The way we understood the phrase possible was that it was permitted.
Permitted, but subject to the granular regulation that would follow, because presumably permitted also admits of the possibility of may not be permitted.
So that relates the possible housing on higher floors is only whether it's a purely commercial building or a building which on the higher floors would have some residential premises as well. We do not believe that greater granularity beyond the a specific building permit would have been required.
Thank you.
All right, so we now have at this point in the chronology the 2003 RP and the privatization that occurred 10 days earlier, which we respectfully submit created the following situation by the end of September 2003. And that is that Omniva now owns the buildings. It has the right of use over the land, which both parties' legal experts agree is the Serbian surrogate to ownership, and a 2003 RP stating that this property was zoned for commercial and certain residential purposes, and importantly, not for traffic infrastructure purposes. And it's in that environment that Mr. William Rand, who's here with us today, decides to invest in Omniva because of its development potential. Now, who is Mr. Rand? Mr. Rand is a businessman from Vancouver, Canada. He has a significant and diversified portfolio of investments in the mining and gas sector, technology, real estate across Canada, the United States, Italy, and of course, Serbia. In 2005, when Mr. Rand made this investment, and I think this is a crucially important fact, Belgrade was one of the last remaining major centers in Europe with an undeveloped waterfront. And Mr. Rand, as he's testified in his witness statement, and we'll show you where he does testify to this effect, believed that at some point there would be major development in the area. He didn't know when, but he was willing to be patient. As he testified, now up on your screen, Obnova's premises at Duvnaska 17 through 19 and 23 was the primary reason I was interested in acquiring Obnova. I visited both locations and believe that the locations represented a very interesting real estate investment with the potential for a significant increase in value due to their location in the city center of Belgrade, near the Danube riverbank in the port of Belgrade. Furthermore, I was advised that according to the then applicable master plan, that's the 2003 RP, Obnova's premises were zoned for residential and commercial development. And Mr. Rand, we would submit, was prescient indeed. What you see here, members of the tribunal, is a video to which our expert, Mr. Richard Hearn from NARA, linked to his expert report, and it shows you now, just in a few seconds, it's not long at all, what is now going on in the Belgrade waterfront. The development that Mr. Rand foresaw is now coming to fruition. But unfortunately, the claimants, as I will now show you, have had their right to be part of that development stripped from them with no compensation. And to understand the full extent of the legal right that Serbia took from the claimants, we need to discuss an important event that happened 4 years later in 2009. In 2009, Serbia amended its law on planning and construction. And as a result of that amendment, Obnova acquired the right to convert its right of use over the land into private ownership. Now, from a legal perspective, this was the most important remaining step to unlocking the development potential of the location. I want to be clear that this right to convert the land into ownership by virtue of this 2009 amendment attaches by virtue of the buildings on the land. That is, if one has ownership over the buildings, as Obnova did after privatization in 2003, then under the 2009 amendment, it automatically has a right to convert its right of use over the land into private ownership. This is the law itself on slide 22. And it states, quote, the right of use over construction land can be converted into a proof of title. Now, this right and the creation of it by virtue of the 2009 amendment dramatically increased the value of the properties at issue in this arbitration, because it meant that Obnova could apply for conversion of all the land necessary for the ordinary use of its buildings, which you see here. And as our Serbian legal expert confirms on slide 24, Obnova could apply for conversion of all the land on Duvnaska 17 to 19 and 23. If it did so, Obnova would have to pay a conversion fee. We'll come back to that in a moment. Now, as Mr. Rand testifies now on slide 26, Obnova was not in a rush to convert its right of use over the land. Mr. Rand testifies, quote, as I had anticipated, Serbia's economic transformation resulted in a legislative change that allowed Obnova and other privatized companies to acquire ownership over the state-owned land that they were using. While I certainly recognize this change as a positive development, I was in no rush and believed that the situation would improve further, especially with respect to the then obligation to pay a fee for the conversion of the right of use over the land to ownership. And I would note, members of the tribunal, that conversion fee was not insignificant. And again, we'll come back to that topic. All right, let's fast forward now another 3 years from 2009 to 2012. In April 2012, Mr. Rand, as the beneficial owner of the Obnova shares, changed the ownership structure to include Kalemegdan as the nominal and direct beneficial owner of Obnova and Coropi as the indirect beneficial owner. Now, he changed this ownership structure for tax planning purposes based on advice he received from Thorstenson's, the leading tax law firm in Canada. And in fact, there's a memo in the record from the law firm regarding Mr. Rand's investments, other investments indeed, in Serbia, and providing that tax advice. The following slides provide a summary of that reorganization. In particular, in April 2012, at Mr. Rand's direction, the Serbian national that was nominally holding the shares contributed the Obnova shares to the capital of Kalemegdan. You can see that here from the minutes of a board of directors meeting of Kalemegdan dated 26 April 2012. Just pausing here. At this point in time, Kalemegdan is the registered and direct beneficial owner of 70% of the Obnova shares, and thus is an investor in Obnova protected by the Serbian-Cyprus bilateral investment treaty. Kalemegdan provided consideration for that investment because it issued its own shares in exchange for them. And again, you see evidence of that too on slide 29, again taken from the minutes of the same board of directors meeting. So to summarize, now on slide 30, Coropi, a Cyprus entity, is the indirect beneficial owner of Obnova, and Kalemegdan is the nominal direct beneficial owner of Obnova. And this means that in 2012, Coropi and Kalemegdan, two Cypriot companies, have 70% of the beneficial ownership in Obnova, which now owns the buildings at issue and has a right under the 2009 amendment to convert its use of right over the land into ownership. The zoning of the area is still governed by the 2003 RP, which zoned the land for commercial and residential use. In other words, if we just pause here, everything is going along exactly as Mr. Rand had planned. But everything changes in 2013 when Serbia enacts the detailed regulation plan, what we call, and I introduced earlier, is the 2013 DRP. The 2013 DRP stripped away Obnova's right to convert the, quote, right of use of land into ownership. And let me explain how it did so. As I noted earlier, the DRP, now the 2013 one, was the lower level planning document under Serbian law, and therefore it was required to be in line with the higher level 2003 RP. I told you I'd show you the law that states that it must be in compliance with the higher level RP. You now see that on slide 33. It is Article 33 on slide 33 from the Law on Planning and Construction, and it states that the document of the narrower area must be in accordance with the document of the wider area, i.e. with the 2003 RP. And not only that, but as you can see on slide 34, when the city first decided to adopt a draft of the 2013 DRP, which was years earlier, it acknowledged this hierarchy and stated that the DRP must be, quote, in accordance with the conditions presented in the general plan of the budget of 2021, which is a different reference, but refers to the same document, to the 2003 RP. In other words, not only does the law require it, but the city itself acknowledged in its decision to later publish the 2013 DRP that it must be in line with the 2003 RP. And now I come to the key point. Serbia violated Article 33 of the Law on Planning and Construction, which I just showed you, as well as its own commitment to follow that law, which is now up on your screen. And it did so because the 2013 DRP contradicts the 2003 RP. Now, why? Well, I showed you that the 2003 RP had zoned the land at issue for commercial and residential use. You saw it was marked red. But in 2013, the DRP, which is now up on your slide 35, rezoned the land for public use, in particular, traffic infrastructure. This image that you see on your screen is in the 2013 DRP. And you'll note from the caption at the bottom of this image that it is now zoned for a, quote, new terminal at Duvnaska Street. In particular, a bus terminal, which would be used as a bus loop. Now, what do I mean by a bus loop? I mean that this is the last stop on the route of a bus, and that the bus literally has to turn around, loop around on a paved path to be constructed on Omniva's property so that it can turn around and drive back on the same route from whence it came and go the opposite direction. The areas around this paved loop would, of course, contain additional facilities to be constructed, which were related to the bus terminal. And these buses are trolleys that need an overhead track. That is overhead wires that power the trolley buses. The tribunal, I'm sure, has seen these overhead wires that power trolleys in Central European cities like Prague and Berlin and Vienna. And as the following slide shows, this bus loop plan in the 2013 DRP encompasses almost the entirety of the land at issue in the case, and this is undisputed. And now I come to the key issue of why this stripped Omniva of its right to convert the land into ownership. The first bullet point on this slide 37 discusses the contradiction that we talked about before. But here's the new point. Picking up on the second bullet point, the law on planning and construction excludes public land such as traffic infrastructure from being able to be converted into ownership. And because the 2013 DRP rezoned the land for public use, in direct contradiction of the 2003 RP, it stripped Omniva of its conversion right under the 2009 amendment. And here on slide 38 is the legal provision that says once the property is zoned as public use, the conversion right cannot apply. And it states, and I quote, "The subject of conversion cannot be land that is designated by a special law as land that cannot be alienated from public state ownership. Land envisioned for the construction of public interest buildings and for the development of public purpose areas." That is from Article 48 of the Law on Planning and Construction. And consequently, the effect of the 2013 DRP was to take away the conversion right owned by Omniva. And this in turn makes it impossible for the Cypriot claimants or for Omniva itself to develop the land. And not only does it take away Omniva's right to convert the land into private ownership, it also impairs Omniva's ownership of the buildings that it privately owns, because it means that Omniva is not even able to do anything with the existing buildings that would require a new building permit. In effect, with the issuance of the 2013 DRP, Serbia declared that Omniva couldn't do anything with the properties at issue other than wait for the city of Belgrade to bulldoze the property and expel the occupants of the buildings. And if you don't believe me, I will tell you that in fact, the city tried to do exactly that. We're fast forwarding a few years in the timeline, but as claimant's witness, who's here with us today, Mr. Igor Markicevic, testifies, the city of Belgrade representatives from the land directorate showed up with, quote, heavy machinery to demolish Omniva's buildings. And then on slide 40, he goes on, after I pointed, let me start from the beginning. At that moment, I saw that the journalist whom I had called earlier had arrived and was walking toward us. After I pointed this out to the land directorate's representatives and explained to them who the journalist was, they panicked and immediately, within approximately 20 seconds, got into their cars and drove away. Members of the tribunal, it is our belief that the only thing that has stopped the city from bringing back those bulldozers is this arbitration.
Be clear, and again, this is something that we'll come back to in detail next week, but I'll just be clear as to when the expectations arose with regard to the entitlement of your clients. Did that expectation arise in 2003, or did it arise in 2009 with the law on planning and construction, or some other date?
We need to distinguish between buildings and the land. Mr. Enway is now discussing the conversion right. So the conversion right was created in 2009 under the legislative amendment of the law on construction and planning. So that was the constitutive moment for that right. It had not existed earlier. The right to the buildings, fundamentally, it arose back in the 1950s when the buildings were built, because that's the time when Obnova acquired what was then the right of use over the buildings as surrogate for private ownership, the same way as if I constructed a building today, I would become the owner of that building because I live in a system which does not have right of use. But in communist Yugoslavia in 1950s, all they could get was this right of use. And then in 2003, by operation of law and the fact that Obnova was privatized, this surrogate of ownership transformed into real private ownership.
Yes, I understand that. I think my point is slightly different. I mean, you took us, Mr. Anway took us to the rezoning, or the slide 16, where you highlighted city centres, which aside from commercial facilities with the possibility of housing on the higher floors, we have 2003, and that seemed to have sparked, if you like, the sort of the business and commercial interest on the part of your clients, because this was focusing on the prospect of use for commercial purposes. So that's 2003. But then we have the 2009 planning law, which talks about converted into proof of title. So I'm just trying to be clear in my own mind as to when the expectation of commercial use arose on the part of those who acquired. Was it 2003? Was it 2009? Was it subsequently? Because your case is that the DRP in 2013 then in effect varied the 2003 zoning. So it must have arisen at some time before then on your case. So can you just be precise about when that expectation arose?
So the expectation with respect to the use of the land arises from the 2003 RP and the 2009 conversion right, and makes it easier for the owner of the building to proceed with the actual development, because it was at least theoretically possible for the owner of the building to change the nature of the building on the basis of the right of use it had over the land on which the building was built. But the process is much easier when it's not right of use, but ownership with respect to the land.
Is it just made it easier, or does the 2009 conversion right on your case in effect create the expectation? In other words, I'm trying to sort of explore the possibility whether 2003 and the commercial acquisition subsequent to that was in effect a commercial punt, a business punt. There are going to be changes, but without the right to conversion that came in 2009, that would never have been realized.
I believe we cannot put it this way. There was a possibility to realize it, but let's say a more difficult one.
Okay, thank you.
We had just left off with the 2013 DRP.
I'm sorry, Stephen, there's something wrong with the transcript. It stops, at least over here.
Sorry? Okay.
Yes, indeed. Yes, I think we all had some internet connectivity problems at the beginning, but we are, so let's just pause for a moment. Presumably have the recording of the. Well, let's just see if this is something that is easily fixed, because I think we would like to have the transcript. Just while we're waiting to see whether this can be fixed, I mean, let me in particular put this to respondent. If we cannot fix this transcription point at this stage, would you be content to proceed without the live transcript on the basis that this is all being recorded and the transcript will be produced?
Yes, yes, of course, we agree.
Okay, let's just see if we can have a technician. We'll wait just 2 minutes, and otherwise we will continue. I think as soon as Mr. Hodger comes back in, we'll recommence. There seems to be a more fundamental problem, but nothing is being lost from the record. Well, Dimitri, we're just going to continue. Nothing's being lost from the record. Mr. Anway, I think we will give you an additional 5 minutes for this break, but go ahead.
We're grateful. Thank you. All right, where we left off was the 2013 DRP. Now I'd like to fast forward 2 more years to another important event. So now we're in 2015. And in 2015, the city of Belgrade rezones its own property. Now, you'll recall when I showed you the 2003 RP, the city had zoned in that document its own property. I said it was directly across the street, just to the south in blue, which meant it was for traffic purposes. And I told you that's because for decades before and after, that property was used as a bus depot. In 2015, the city rezoned that plot of land, which it itself used, to be residential rather than for public traffic infrastructure. In other words, after having taken the land from the Obnova site and rezoned it from commercial and residential to public and traffic infrastructure, it's now done the exact opposite with its own property, which previously was zoned and used for public traffic infrastructure, and it's now rezoned it for residential use. As a result, the value of the city's land increased dramatically, and the value of the land over which Obnova has the right of use disappeared. Now, at least initially after this rezoning, the land directorate treated Obnova as the owner of the buildings, in direct contradiction to what Serbia argues in this arbitration. And we know this, as you see on slide 42, because in February of 2016, it sent a letter to Obnova informing it that it had initiated proceedings related to the planned construction of the bus loop. And as part of the proceedings, Obnova's buildings were supposed to be demolished. The land directorate did not assert that the buildings at Duvnaska did not belong to Obnova, as Serbia asserts in this arbitration. The city never invoked the alleged contractual right to have Obnova vacate its premises and demolish its buildings, as Serbia argues in this arbitration. And the city didn't consider that the buildings were being used by a company called Luka Belgrade, as Serbia does in this arbitration. And we'll come back to Luka Belgrade later. It argued none of that in this letter. In 2017, Mr. Erinn Broshko, also of Vancouver, Canada, and also who's with us today, invested in Obnova. He did so by acquiring, through his Serbian company Maple Leaf Investment, what we call MLI, 10% of the Obnova shares. Now, I want to be clear, this was not part of the 70% we discussed earlier. Recall that I told you the other 30% went to the employees, and it was from that 30% that he purchased his 10%. And picking up on the second bullet point here, Mr. Broshko made this investment believing that despite the 2013 DRP, Obnova still represented a promising investment opportunity because either the 2013 DRP would be withdrawn or that Obnova would be provided compensation for the expropriation. And contrary to Serbia's contention in this arbitration, Mr. Broshko's investment in Obnova was made independently of Mr. Rand. And on the next slide, you'll see testimony from both of these individuals to that effect. All right, now after Mr. Broshko makes this investment, the land directorate sends another letter.
Excuse me, so just to be clear, going back to your slide 43, in terms of Mr. Broshko's belief, it was that the 2003 DRP would be resolved either in favor of development or in favor of compensation.
Correct.
So bottom line is Mr. Broshko's investment of 10% within these two options, but the bottom line would be that the compensation would be presumably somewhere in excess of his 10% investment. Otherwise, it would not have made commercial sense to purchase the 10%.
Yes, Mr. Chairman, Mr. Broshko is a fact witness in this arbitration next week.
I understand. You're addressing the point. I just want to make sure that I understand what slide 43
That's
actually
correct.
says. Thank you.
So picking up on slide 45, after Mr. Broshko made his investment, the land directorate sends another letter dated the 19th of February, 2018. Again, which presumes that Obnova was the owner of the buildings. And you can see that letter on this slide where the land directorate contemplates the quote, question of compensation. But on August 31st, 2021, the land directorate rejected the request for compensation, stating that the land was owned by the city. And on that basis concluded, quote, your allegations that the expropriation was thus effectively carried out are unfounded, since both objects and parcels are legally registered as public property by the city of Belgrade. Now, there's one key fact that I want to review before I conclude the timeline relating to our case in chief. And that is that on the 4th of August, 2023, the law was changed again to eliminate the conversion fee and to make conversion automatic. In other words, privatized companies no longer needed to pay the conversion fee in order to convert their right of use over the land into ownership. That's in Article 93 of the Law on Planning and Construction. The registration of the newly acquired ownership is made by the cadaster ex officio, that is, without the need for the new owner to even file a request. Obnova, however, could not benefit from these changes because of the 2013 DRP and the fact that it rezoned the land for the bus loop. Now, I have one final point I want to make before I conclude our case in chief. You have seen Serbia argue in its papers, you may hear it again today, that the claimants here are seeking a windfall. If we hear that again today, I'd ask you to remember this. Now on slide 48. After this arbitration was filed and following Serbia's counter memorial, the claimants made a settlement offer to Serbia, which didn't request any monetary compensation at all, not even the legal fees associated with this arbitration, which by that point were approaching $1 million. The settlement offer was simply for Serbia to allow us to develop the property, which we submit we have the legal right to do. That settlement offer is now up on your screen. What was Serbia's response to claimant's good faith settlement offer? It didn't even bother to respond.
Don't we need to know what your clients paid for the various rights to know whether or not we're talking about it? Where do we end up with it? I know there's been a debate between the parties, but it's not entirely clear to me at this point.
So
our consideration.
Yeah, our point is that this now windfall actually depends on what one understands by windfall. There's no legal definition by windfall. So if the idea is, did the land appreciate a lot as a result of the legislative changes which happened in the 2000s and then 2010 and finally in 2023? The answer is yes. But the point about windfall is not that the claimant is, or the claimants are moving away from normal business and just trying to get monetary compensation for something they alleged they acquired over the time following, at the moment and following their investment. They are not shying away from just earning their money and realizing that the windfall, if you want to call it that way, in normal business life.
The point is that we don't know what was paid for investments in the first place.
I know I don't know if that information is or is not on the record. We definitely know how much Mr. Broshko paid for his investment. And I'm sure that if the tribunal wishes to ask the witnesses how much they have paid for the investment, they will be happy to provide the answer.
Mr. Bekas, can I just ask you about this settlement letter? which is interesting. It's at C 697. I'm curious that it was a settlement letter that was not made as is typical in settlements discussions on a without prejudice basis, and that we are now seeing it in the record. So it may be speculated that this was a settlement offer that was made for the record of the arbitration rather than to achieve a settlement, because all of a sudden we are seeing it in September 2023. And in terms of the settlement offer on page 3 of that letter, I mean, it appears to be saying claimants will withdraw the proceedings and waive any claim for costs if, in fact, you give us what we're asking for in the proceedings. Is that correct? Am I reading this correctly?
So this, from the perspective of, if we use public international terminology, we are asking for restitution here in this settlement. In the arbitration, we are claiming monetary damages, so this is not the same thing.
Yes, I'm not putting it in terms of the legal nuance of whether this is restitution or whether it is a claim for damages. It just appears, I'm reading from the letter here, claimant's preferred course of action would still be to develop Obnova's land rather than to seek recourse against Serbia in investment arbitration. If Serbia agrees to alter the relevant regulations, recognize Obnova's ownership. So essentially, what you are seeking through this letter is to be made whole, to return to the status quo ante, which
Yes.
it may be that the arbitration is proceeding on the assumption that that will never happen, and therefore you seeking compensation. But this is not a letter which says, you know, we are prepared to reach a compromise or anything like that. It's saying to the respondent, give us what we wanted right from the beginning and we will withdraw the arbitration. And it's not made on a without prejudice basis. In other words, hidden from the eyes of the tribunal. It's made with the intent, perhaps, or the expectation that it would be put in front of the tribunal. I just want to be clear about that, and the respondent will no doubt come.
So yes, it is. We are asking to be given back what we believe was taken from us. And yes, this is a transparent offer. The primary purpose of that offer was to get what was taken away from us, but with the understanding that this may be used in the arbitration by both sides. That's why it's not a without prejudice letter.
So that the point that Mr. Amro made about the respondent not having responded, there's I just put it in these terms, there's a sort of whiff of tactics about this on both sides. You've written a letter saying, make us whole. Respondent involved in these proceedings has simply decided not to respond. I'm just wondering whether there is anything more that we take away from it, because Mr. Amro, you seem to be sort of suggesting that we need to keep this sharply in mind when we hear from the respondent.
So again, the point we want to address is that in the counter memorial, it was alleged that we are trying to get a windfall in the sense of getting more money than what we would have been able to make in real life.
Okay, thank you.
The only other point I'd make, Mr. President, in response to your question is, although the offer was made on not made on a without prejudice basis, there was nothing that precluded Serbia from responding with a confidential counteroffer or a without prejudice counteroffer in that respect, which my only comment was to note that did not happen.
Thank you.
All right, that takes me to the end of the timeline for our case in chief. I would just like to pause here at the end and note that many of the facts I just described to you, if not the majority of them, are undisputed. Serbia does not dispute the existence and content of the 2003 RP. It doesn't dispute the existence, content, and legal effect of the 2013 DRP. It admits it did not even consider its own land for the location of the bus loop, despite it already being a bus depot. It admits that it rezoned its own land for residential purposes in 2015, and it does not dispute that no compensation was ever provided. Instead, its entire merits defense seems to rise and fall on a single proposition, which is that Obnova has no rights to the buildings that it built and the land on which those buildings sit. And in the next section, to which we're about to turn, It offers 4 key defenses in support of that single proposition. What I'd like to do, members of the tribunal, is to take you through each of those 4 key defenses, summarize our response to them, and I suspect at the end of that presentation, it may be an appropriate time for a break, but of course, I'm in the tribunal's hands. So turning now to the second major section of our opening statement, the 4 defenses on the merits fail, and we'll take each one in turn. The first defense that was offered is that we have not proved the existence of Obnova's buildings or what they are made of. On the next slide, slide 52, you can see where Serbia made this allegation. Members of the tribunal, I would respectfully say that this is not a credible argument. I've already shown you the aerial photos of those buildings. Here they are again on slide 53 and 54. The 15 buildings at Dubnaska 17 to 19, the 9 buildings at Dubnaska 23. And this is the key point. There has been no suggestion that these aerial photos are anything other than accurate, nor has there been any suggestion that these aerial photos are outdated. But in any event, and to put the matter to rest once and for all, we engaged a construction engineer who personally visited these properties, verified the buildings exist, and concluded they are brick and mortar buildings. And here on slide 55 is where he said so. Now, after we put this evidence into the record, Serbia's own construction expert also confirmed the existence of these buildings. Here on slide 56, you'll see a picture of one of the office buildings. This is on 17 and 19 Duvnaska Street, for which a construction permit was issued in 1953, and I'll come back to that. And again, this comes from Serbia itself, so this too is now undisputed. The next slide shows you the inside of that building. This is slide 57. Still other buildings on the property you'll see on slide 58. Other buildings from the same property on slide 59. Slide 60 shows you buildings from 23 Duvnaska Street, 3 of them. Remember, there are a total of 9. And not only do we have pictures outside, inside, and above the properties from both parties' experts, but we also have the building permits pursuant to which these buildings were constructed. And I'm going to show you those building permits in connection with a different defense Serbia raises momentarily. In short, again, this is not a serious argument, and we invite Serbia to confirm during its opening statement today whether it still maintains this argument. So that's their first defense. The second defense is that the buildings were not built by Obnova because they predate the creation of Obnova in 1948. And here on slide 62 is where you see Serbia make this argument. Well, we know this cannot be correct because the building permits pursuant to which the buildings were built on 1719 Duvnaska Street all post-date 1948. In other words, they post-date the creation of Obnova. On slide 63, you'll see the first building permit, and it's dated 31 October 1949, 1 year after Obnova was created. It's issued in the name of Optad, which I told you is a different name for the same entity, Obnova. Slide 64, another building permit dated 21 April 1953, issued to Obnova. Slide 65, another building permit dated 22 March 1954, issued to Obnova. Slide 66, another building permit dated 31 May 1954, issued to Obnova. Another one, 29 July 1954, Obnova. 2 November 1954, slide 68, issued to Obnova. Another one, 24 December 1954, issued to Obnova. And it wasn't just building permits. 30 May 1956, an occupancy permit for the main office building, permit of which was granted in 1953, also issued to Obnova. Members of the tribunal, none of these building permits predate the creation of Obnova in 1948. Indeed, the only evidence on which Serbia relies credibly, or purports to rely credibly for this proposition is the infamous R43, which Serbia put into the record with its counter memorial. And I'd like to spend several minutes to talk about that document. R43 is a memorandum from the Serbian Belgrade Cadastre, which Serbia requested for the purpose of this arbitration. Now, unfortunately, the person who created this document from the Cadastre, her name is on the screen, has not been made available to us as a witness in this arbitration. So we can't ask her, nor can you, any questions about it. We, in fact, were so keen on cross-examining this individual that we wrote, and this is from our reply, 61, paragraph 61, now on slide 71. To be clear, claimants would be very eager for the opportunity to cross-examine the author. And yet, when Serbia filed its rejoinder, it did not put forth her or anyone else as a witness. So the best I can do, members of the tribunal, is to dissect the many suspicious and very concerning, indeed troubling, parts of this document. Now, to understand how troubling this is, please understand that Serbia relies on this document, again, a memorandum, which includes snippets of map sketches pictured throughout it, for the proposition that the buildings at issue were already built in 1946, 2 years before Obnovo was created in 48. This document is riddled with misrepresentations, errors, and omissions. Let's start with this. To understand these documents, particularly the map sketches, we have to know that the Cadastre Office uses two different colors of ink. The first is black, which is when the map is originally sketched, and the second is red, which is used when the map is updated over time. You can see on slide 72 an extract from the Cadastre rulebook explaining the black ink, red ink rules, and you'll see below it where Serbia admits that information marked in black represents the property when the map is first sketched. All right, now against that backdrop, we can immediately tell that R43 does not show the state of the property in 1946. How can we tell that? Three different, entirely independent reasons. First, and I direct your attention to slide 73, which will have a little motion on it. It shows the main office building. That building wasn't built until the 1950s. In fact, I showed you the building permit for it. It was 1953. The occupancy permit came a few years later. So this map cannot be from 1946. The building didn't even exist then, and therefore could not have predated Obnova's creation. Number two, the name of the street written in black ink as Dubnaska Street. Prior to 1948, that street was not named Dubnaska. It had a different name. Unless there be any doubt, we have a letter from the relevant body in Serbia, the Secretary of Culture, who confirmed that the road had a different name before 1948. So again, this map cannot be from 1946. The road name didn't exist then. Third, R43, which supposedly came from 1946, it's pictured on the left-hand side of your screen, shows buildings that are completely missing from a later in time map, such as the one you see on your right from 1949. Let me restate that. On the left-hand side, you're seeing R43, which according to Serbia is from 1946, where you see all sorts of buildings, which by the way still exist today, when on the actual map from 1949, it shows they haven't been built yet. Yet again, these snippets from R43 of sketch maps cannot possibly represent the property in 1946 and therefore could not have predated Obnova's creation. But there are many other sketches that show the same thing. I go on. On this slide, now 76, we see the front right part of the property filled with buildings in R43, supposedly from 1946. But on the right-hand side of the slide, we see the same area according to the 1949 map, which shows those buildings had not even been constructed yet. Still more evidence that R43 is not what Serbia told the tribunal it is. Now on slide 77. Now, let me give you the background of this document. We asked for the full sketch of the map that had been used in R43, and we were provided this in document production. We put it in the record as C577, and yet again, it shows buildings that when you compare it to a later map, here the 1948 map, show the buildings haven't even been built yet, and therefore could not have predated Obnova's creation. And now, or I should say after that, we confronted Serbia about these problems with R43. We asked to cross-examine the author of this document. We were denied that opportunity, as has been the tribunal. But we also asked Serbia a series of questions about this document that, upon our insistence, caused them to go back to the cadastre. And when they did, the cadastre responded with a letter, which is shown on slide 78. Referring to R43, the cadastre told Serbia that the sketches in fact show, and I quote, changes that have occurred on it during the revision survey in 1966 and 67. In effect, what Serbia told you was a map showing the state of affairs in 46 was a map 20 years later, well after Obnova had been created. And so what was Serbia's response to all of this when they filed their rejoinder? They provided a different map. This one is R199, now on the left side of your screen. And they say, look, this shows Obnova's main office building existed in 47, and we have it circled in red. But that too is wrong. The red circle here on a map from 1947 is not Obnova's office building. It's an older building that was demolished and replaced by Obnova before its main office building was constructed in 53. I showed you the building permit for that. And we know this because on the 47 map, the left-hand side of your screen, the building on the left is larger than the building on the right. You'll see the one on the left is in black, the one on the right is in red. And if you look at the notice of cadastre on the right-hand side of the screen, which shows the actual main office building, which was built later after the first one was demolished, that the shape of the buildings is exactly the opposite. The one on the right is larger than the one on the left. Members of the tribunal, my point is this. When you hear Serbia pointing to a sketched map at any point in these proceedings, please proceed with caution. None of the buildings at issue were constructed prior to Obnova's creation in 1948. Serbia's third merits defense, that Obnova has been using its premises solely based on historic lease agreements with the city or a Serbian company called Luka Belgrade. And again, I wade into at least legal principles that to my common law mind sound somewhat unfamiliar, but I also understand this is largely agreed between the experts. Here on slide 81 is where Serbia makes this argument. All right, I will warn the tribunal in advance, this gets a little complicated. Again, it's a defense they raise, not our case in chief. But I think it's important to go through this carefully. Point number one, it is true that in 1953, Obnova and the municipality concluded a lease agreement. That's true. Here's a picture of it on slide 82. The lease did not have a defined term. Article 4 of that lease from 1953 stated that after the lease was over, again, it was an undefined term, the buildings would have to be removed. Now, that may sound strange again to my common law mind, but I understand in communist Serbia that was not uncommon. When later building permits were issued, it repeated similar language tracking the 1953 lease. But notice this lease is a civil law instrument. It's a contract between two parties. It doesn't have public law implications beyond that. Once the lease is over, the obligation to remove the property is over, because the obligation to remove the property at the end of the lease is only contained in the lease itself. Now,
Building permits that you referred us to all say that the building's for temporary use. Isn't there a parallel there?
As our legal experts explain, this is the same. The building permit does not create an independent obligation. The building permit merely restates an obligation which exists under the lease agreement. Therefore, what Mr. Enway said, once the obligation under the lease agreement ceases to exist for any reason, then the obligation is no more. The obligation cannot survive on the basis that the building permit refers to it.
So I understand, so that you get the construction permit to build something for temporary use. If the lease agreement expires, then ex ante it becomes a building that is being constructed for permanent use.
I'm not sure about the ex ante, but upon the moment I no longer have the obligation to demolish, then the building is permanent. Yes.
okay. So as I noted, we acknowledge a lease agreement signed in 1953. That lease agreement terminated no later than November 1961. What you see up on slide 83 in terms of the extract is from our legal experts report. Why did it terminate? It terminated because on that date, the state established Pristanishta, later named Luka Belgrade, which is a socially owned enterprise that had the right of use over the land. In effect, members of the tribunal, there was a new landlord. And under Serbian law at the time, when there is a change in the landlord, again in communist times, the old lease automatically terminates and a new one must be signed. And indeed, one was. On the 18th of January, 1962, Obnova concluded a new lease agreement with Pristanishta, or what was later known as Luka Belgrade. Importantly, in that new lease agreement, there was no mention of the buildings having to be removed at the end of the lease or of them being temporary. In fact, as you can see on slide 84, they were called fixed assets. But then something else happens. In 1965, the law changes, and it changes in a way that makes the lease agreements a thing of the past with respect to the property at issue. Here on this slide, 85, you will see the leading treatise on the right of use of construction land in social ownership. 1985. Both parties' experts rely on this treatise. That's how authoritative it is. And it states, in the third stage, which began on April 6, 1965, the circle of holders of the right to build and the permanent right of use was expanded to social legal entities. And then down below, it was considered that the right of use that social legal entities had on construction land and social ownership derives from the right to erecting permanent construction facilities on the land. This is the same right of use that I described earlier survived the 2003 privatization with respect to the land. And you'll notice it's talking about a permanent right of use. Everything I described earlier about what survived the 2003 privatization in terms of the right of use to the land on which the buildings were built is this same concept, the permanent right of use. And after this change of law, Obnova now had a right of use over the land and did not need a lease anymore. And you don't need to just take my word for it. or our experts, which I'll come to in a moment, is I'll show you post 1965, when this law was enacted, there is not a single document in this record that relates to the property at issue that is called a lease. Not a single document in the record after 1965 that is called a lease. You've been told otherwise by the other side, and I'm going to walk you through each one of those documents to show you that. And that's because once Obnova has the right of use over the land, which it now has under this 1965 law, the notion of a lease becomes utterly irrelevant. It doesn't need it, and it never signed any subsequent lease with regard to the property at issue in this case.
Can I just ask, does that mean that at that point in time, in your case, Luka Beograd had no subsisting rights over the land?
I am going to come, Professor Douglas, to a slide that directly addresses the relationship between Obnova's right over the land and Luka Belgrade's in 3 or 4 slides, if that's okay. Okay.
Sorry?
Yep.
So if I understood correctly, up to 1965, Obnova owned or have the right of use of the buildings. Someone else has the right of use of the land. Right? Of the land. And therefore, a lease agreement was necessary.
That's correct.
In order to use the land.
Prior to 1965, yes.
Prior to 1965. 1965, together with the right of use of the buildings, they also acquired the right of use of the land. What we will call similar to an usufructo, or which is the legal figure coming from where you have the right, you don't have the nominal ownership, but you have the right of use, the benefits and use the land as you were.
Yes, because of their pre-existing right of use over the buildings, they also acquired this permanent right of use over the land, which was one of 4 forms of right of use which existed in then socialist Yugoslavia.
Sorry, may I just clarify? This exchange has left me a little bit confused. Mr. Jana has said, so if I understood correctly, up to 1965, Obnova owned or had the right to use the right of use of the buildings. I'm not sure that the transcript here quite captures it, but others had the right of use of the land. Are you in fact saying, and you seem to accept it, are you in fact saying that there were 2 competing rights of use? Or is it, as I had thought I understood it, that there was a right of use of the buildings which was distinct from the ownership of the land? It's not that there was another competing right of use of the land. And I'm not quite sure how a competing right of use of the land would work if there was already a right of use in respect to the buildings.
The rights of use were not competing. So basically, because of the Marxist ideology in Yugoslavia at the time, everything had to be owned by the state or to be in social ownership. The situation, so if we take that layer out and focus just on the right of use as surrogate of ownership, it was a situation where the surrogate of ownership for the building had a different holder than the surrogate for ownership for the land, which again is something which came to be in socialist Yugoslavia. Before that, it was not possible. In Yugoslavia, it was and still is possible for the owner of the building not to be the same person as the owner of the land. And then the owner of the building has to have some private law title to use to have the building on the land.
Again, I want to ensure that I understand this correctly, because this in fact is not peculiar to Serbian law then. I mean, for example, in the United Kingdom, you may have ownership of the land, and you may have what is termed a lease in respect of the property that's built on that land, and that lease could be anything from a passing lease for a few days or whatever to 999 years. But effectively, if you are the leaseholder for that 999 years, you can't say that you own the land because someone else is the owner of the land. What I'm just trying to clarify is this exchange that you had with Mr. Jana. Were there two competing rights of use, whether the right of use was a surrogate for ownership or not, or was it a right of use in respect of the buildings, which was distinct from the ownership of the land? Is that a correct understanding?
Prior to 1965, it was the latter.
Thank you very much.
I left off members of the tribunal with the 1965 change in law. I would simply point the tribunal to an excerpt from our Serbian legal expert who, as you see here, testifies that the permanent right of use was acquired ex lege by every entity that had the right of use over the building. Now, I come to your question, Professor Douglas. It is true that Luga Belgrade also had a right of use over the land, but, and this I'm sure will be the discussion or a point of discussion with our legal experts. Our legal expert opines, as you can see from slide 87, that in the event of conflict between a permanent right of use, which is attached to use or ownership of buildings, that of course is Obnova's right, and the right of use of the construction land as emanation of social ownership, that of course is what Luka Belgrade had, the permanent right of use prevailed. In other words, Obnova's permanent right of use after the 1965 law prevailed over Luka Belgrade's use.
Clearly, does that mean that Luka Belgrade's interest in the property completely extinguishes at that point?
It exists, but it has no practical meaning because it is the permanent right of use prevails.
So this is where I mean,
Yeah.
we'll explore the exit. So I have a difficulty. I can understand how you have a right of use of right, and then someone else has a contractual right under a lease, under a civil law system, civil common law, different leaseholder has a property right. But I can see under the civil law system, you have a use of right, the use of right holder leases the land that gives the lessee a contractual. But where I have difficulty is where you have two rights of use over the same thing.
Yeah.
But I'm sure we'll explore.
No, but that's why we have the hierarchy of the rights. And to explain that, we are in a communist economy. So at the end of the day, what matters is the phone call from the district secretary of the Communist Party. So we are describing nice legal concepts of how it was at the time. But Luka is what? It's the state. It's called socially owned enterprise, but it's the state. Obnova is what? Socially owned enterprise, the state. The building authority is the state. So the parallels we may draw with a situation in a normal free market economy have their limitations.
All right, now to simplify this discussion and putting aside those legal issues that will of course be the subject of the expert testimony next week, we have provided this timeline to you, which simply shows the 53 lease, the fact that it terminated in 61, the new lease was signed in 62, which makes no mention of the buildings being temporary or any obligation to remove them or demolish them, and then the 65 law by which Obnova acquired the ex lege permanent right of use over the land at Duvnaska 17 through 19. And consequently, and now I come to the discussion I foreshadowed earlier about whether any document after 65 even mentions the word lease relating to this land. The conclusion on this slide, if we just go back for a minute, is after 1965, and precisely because Obnova now has the right of use, the permanent right of use over the land, it had no need to and did not conclude any lease agreements for the land. Now, if we go to the next slide, Serbia has put forth 11 agreements in this record, which in some capacity they suggest are lease agreements. We have each one of them on this slide. 9 of those 11, which you see below the purple line, are services agreement. They are not lease agreements. And I'll come back to the service component of it in a moment. And the 2 that are lease agreements, as you can see here, predate 1965. Now, something I want to warn you of, if you look, for example, at Serbia's list of exhibits, they will use the word lease in many, if not all, of these 9 agreements listed here. If you hear that today, members of the tribunal, please ask to see the document. The title of these 9 documents do not contain the word lease, and the content of these 9 documents do not contain the word lease. The representation on the list of exhibits that these are lease agreements is Serbia simply putting that word into the index of exhibits. They are not found in any of these documents. Now, go to the next slide. We've been told that we need lease agreements for both buildings, or property at issue is subject to lease agreements for both buildings and land. Putting aside what I just said, which is an independent problem, that is none of these agreements were leases after 1965. There's an additional problem with this lease argument, and that is that none of the leases, none of the agreements, the services agreements, none of those 11 documents relate to any buildings at all. So when you hear today that the buildings were governed by some lease, please understand that none of the documents, even if they were lease agreements, pertain to any buildings. What about the land? None of the 11 documents, again, this is a totally independent problem, in addition to the other problems I've just identified with this position, appear to even relate to the premises at issue in this case. Now, we're dealing with documents that are 75 years old in some cases. But you can just tell, for example, now on slide 92, one of the agreements that Serbia relies upon pertains to parcel 12.6. It's undisputed, members of the tribunal, parcel 12.6 is not part of the land at issue. Now on slide 92. Slide 93, it refers to the port area. The port area, which you can see on this map, is not part of the property at issue in this case. Slide 94, another agreement refers to the use of the railway. The railway is not part of the property at issue in this case. Slide. In sum, and this is the conclusion to this third defense that Serbia has raised, none of the agreements after 1965 are lease agreements. And number 2, even if they were, none relate to any buildings, and they don't even appear to relate to the land at issue in this case. Next slide. And yep.
May I just sort of clarify? And I think I understand your point, but just to be absolutely clear, you are saying with regards to all of these exhibits, you know, R12, R13, the others that you've shown here, that the absence of the word lease in those documents is, as it were, dispositive of the content of the document. That an agreement is separate from a lease agreement, and although you haven't put it in these terms, and the word lease does not seem to appear, at least in the documents that I'm looking at the moment, but you appear to be suggesting that the respondent, in their reference in their submissions, because this is not, you're not making this as a translation point, is as we're trying to provide a little bit of impetus to the appreciation that these documents were lease agreements.
It's not just the absence of the word lease, although that too I think is indicative. But if you actually read the content of those agreements and their service agreements, many of them refer, for example, to the transportation of goods, for example, through the railway to the port and so forth. So it's not just the title of the documents or the absence of the word lease on which we rely, it's the actual content of the documents themselves.
Right, so I understand that, and I'm not resolved in my own mind, you know, how much weight rests on this, but I'm looking for example, at the moment at R12, and at Article 20 of R12, it says, Obnova undertakes not to sublet the space in any form to other parties. Now, that is the kind of provision that you would expect to see in a lease agreement. So I'm really just wondering whether what you are in fact inviting the tribunal to do in due course is to sort of work their way through each of these clauses in each of these documents in sort of in laborious detail and say, well, actually, this in fact is a lease agreement or it's not a lease agreement. How much weight rests on this particular point that you make?
Oh, we are discussing all these issues because they relate to Serbia's defenses. At the end of the day, we believe what is important is the status as of the date of the adoption of the 2013 DRP. It is Serbia which says that these old agreements are relevant. We say they are not. I don't know if that answers your question, but we note that the agreements are not what Serbia says they are.
Well, I understand your point, and I understand that you've got the alternative argument that even if they were lease agreements, so I understand that fully. But for example, and I come back to Article 20 of R12, where it says Obnova undertakes not to sublet the space in any form to other parties. I mean, this appears to be some kind of rein on Obnova's entitlement. So I'm wondering, and we will no doubt hear from the respondents on this in due course, as to whether this was some form of limitation of Obnova's rights.
That would be so in principle, yes, this is a limitation of Obnova's rights with respect to what is the object of the lease of the alleged lease. And our position is that it's definitely not the buildings, because each of these agreements specifies very clearly that it relates to open space, not to any buildings. And with respect to the land, our belief, but we are asking to interpret something which was concluded long before we came into the picture, is that it relates to area further close to the port area where the railway is, for example, as Mr. Enway showed it to you, and where it would make sense to speak of transportation services as scrap metal was brought by trucks and then put on rails, which brought it to the port and then further away on the river on a boat. So with respect to that part of the land, yes, this Article 20 seems to suggest that Obnova was not authorized to sublease it. We just note that the agreement does not say in any place that Obnova was leasing that land. But this is a document drafted in 1985 between parties, which we have no contact.
Thank you, and I understand that this deals with the historical stuff and it's addressing the respondents for defenses as you've characterized them. So let me just ask you, I mean, we are now approaching the point at which we should be taking a break. I don't want to sort of stop you at an inopportune moment if there is a clear point at which you would like to stop. And I also note that you are a good deal less than halfway through your slides, but halfway through your time. Not all of that can be put down to the tribunal's inquiry.
Indeed. I probably have another 10 to 15 minutes, so I'm in your hands. I'm happy to take a break now if you'd like me to wrap up.
I think if the court reporter is content to proceed, it would be useful to draw a line under this. So, and she's indicating that that we should proceed. So let's proceed, and maybe I will lead by example and try and be a little bit restrained in the course of the next 10 minutes.
Well, and I'll try to pick up the pace a little. We now turn to the final topic in my presentation and the fourth defense that Serbia has raised, and that is that Obnova does not have any rights to its premises because its buildings are temporary. And we, of course, have touched on this topic in the discussion of the three other defenses. But on slide 97, you'll see one of the paragraphs in which Serbia makes this argument. Again, I come back to the 1965 law. We've already looked at this slide. I won't reread it into the record, but if we go back, this again establishes the permanent right of use, not a temporary right of use, but a permanent right of use over the land at Duvnaska 17 through 19. And on the next slide, we see where our expert concludes that that right accrued ex lege to Obnova. The next slide. Now, there are really two arguments that are being made here. One is that it's the buildings physically that are temporary. They're somehow temporary in nature. They're not, for example, brick and mortar buildings. There's a second argument, which is that it's the building permits that are somehow temporary. And I want to take each one of those in turn. I don't think we need to spend much time on the first one. We've been through it before. And if you go back to the slide we just had up, slide 100, these are all the pictures that you've seen. We could show you more, but clearly these are not temporary buildings. This is not like you have a canopy, for example. These are brick and mortar buildings. They are by no means temporary. We then turn to the issue of whether the permits themselves could be temporary. And our legal experts, and I'm sure this will be the subject of discussion next week when they testify, have made clear that Serbian law does not or did not even allow for the issuance of temporary permits before 1997. Consequently, Obnova's permits issued in the 40s and 50s could not have been temporary. We've already talked about the fact that the temporary use in the building permits was really reflective of the 1953 lease and its mention of a similar principle. That the 1953 lease was simply a civil law instrument, a contract between two parties that could not have public law implications, and that the obligation to remove or demolish the buildings upon request ceased to exist when that 53 lease agreement ceased to apply, which we noted was in 1961 at the latest. Next slide. Now, I come to, I think, what really is the nail in the coffin on this argument, and that is the cadastre map from 1966 puts this issue to bed. It disproves the argument that Obnova's buildings are temporary. Why? Because it lists on the map that Obnova is the quote unquote user. If we could go back, please. A company like Obnova cannot be a user of the land so identified in the cadastre map if its buildings on the land are temporary. Now, let's go to the 66 map. The 66 map from the cadastre identifies Obnova as the user of the land at Duvnaska 17 through 19. We've identified here where on the map it lists Obnova as the user. It doesn't use the word lessee, which is a different word in Serbian, as you can see from the text on the right. Obnova received this map directly from the cadastre after it requested information about the historical changes of lot plan 47. That's the lot on which Duvnaska 17 through 19 are located. And even according to Serbia, this map was prepared by the cadastre itself in 66. Now, go to the next slide. Another very troubling thing about a document that Serbia presented in this arbitration. It too presented the same map to the tribunal, but it cropped out the word user, Obnova. You can see from the comparison of R43 and the full version on C329 that Obnova is listed as the user. And if we go to the next slide, the cadastre map also identifies Obnova as the user of the land at Duvnaska 23. Again, not lessee, user. Next slide. I want to make a slight distinction here. As we noted, the buildings to which Obnova had the rights on 17 through 19 Duvnaska were acquired because it had the permits to build the buildings. The land initially, the rights to the land initially at 23 Duvnaska were obtained differently. Not through building permits. At the time, it was not as regulated, shall we say, but through adverse possession. And this slide explains that in good faith, it had occupied that premises for more than 20 years. The phrase in Serbia is acquisitive prescription, which to my common law mind means adverse possession. And once it acquired the rights through adverse possession, its legal rights to the land in Duvnaska 23 are now the same as its legal rights to the land on Duvnaska 17 through 19. But the point is, on the map I just showed you on the prior slide, Obnova is listed as the user of Duvnaska 23 according to the map. Now, if we go forward, I just want to end with one final legal point, and that is Obnova's right of use over the buildings transformed into ownership even without registration in the cadastre. This is from our Serbian legal expert report, but this is not a disputed point. In fact, Serbia does not dispute, you see here, this is from Serbia's rejoinder, that a registration in the cadastre is not required for the right of use to transform into ownership. And I'm not going to read through this slide in the interest of time, but it simply notes that both parties' experts agree that Serbian law recognizes unregistered ownership. And consequently, members of the tribunal, all four of the defenses that have been offered on the merits fail. I want to end with one final point. Where are Serbia's witnesses? Members of the tribunal, we all have many years of experience in international arbitration. I can rarely remember a case where a side has not put forward a single witness with so many issues on which those witnesses should be testifying. There is not a single fact witness that Serbia has offered in this case. Where are the witnesses from the city of Belgrade, from the land registry, from the land directorate, from the cadastre, from the Secretariat for Urban Planning and Construction? And these are important issues. Let's walk through one of them. Actually, indeed, let's walk through each of them one by one. Nope. Next slide. Okay. So we're not going to walk through each one of them one by one in the interest of time, but suffice it to say that these were important factual issues, and we respectfully submit that the reason why Serbia has not put forward witnesses is because had it done so, those witnesses would not be able to defend the actions that Serbia has taken in this case. So with that, Mr. President, and with appreciation for your indulgence, I have concluded the first two sections of our opening statement, and after our break would respectfully ask for your leave to turn the floor over to Mr. Pekash.
Thank you very much. Before we break, let me just turn to my colleagues and see whether there are any questions that you'd like to raise at this point. Well, then let's take our break. I'm not going to be sort of precise in terms of the 30 minutes. Let's try and reconvene at 10 to the hour, if that works for you. Thank you very much.
Thank you.
So, Mr. Pekash, I believe we are turning to you. We're on page 112 of 234. And I think, according to our Tribunal Secretary, you've used up 140, you've used up 1 hour, sort of 40, so about an hour 20, which will take us through to our scheduled lunch break at 1:15. Yep. Over to you.
Yes, Mr. Chairman, thank you very much. I will address three topics, as Mr. Enway said. The first one is Serbia's violations of the treaty. And I will start by the expropriation standard under the Cypriot Serbia BIT, which relates to the 2013 BIT, the DRP. We submit that the proper analytical framework to analyze whether the 2013 DRP constituted an expropriation or not is to look at what rights Obnova had immediately before the adoption of the 2013 DRP and compare it to the rights that Obnova had immediately after the adoption of the 2013 DRP. and then to look into the issues of legality of that expropriation. And our submission is that the facts very clearly show, first, that the adoption of the 2013 DRP did constitute an expropriation, and that that expropriation was unlawful. So the rights which Obnova had immediately prior to the adoption of the DRP are, first, it was the owner of its buildings at both addresses at Dunavska. It had the right of use over the land at both addresses at Dunavska, and it also had the right to convert its right of use into ownership. Mr. Anway already explained how it came to be. The effect of the adoption of the 2013 DRP was, with respect to Obnova's ownership right to its buildings, that ownership right was restricted because Obnova was expressly precluded from developing its premises in any way. That prohibition is spelled out expressly in the 2013 DRP. With respect to the right of use over the land.
Sorry, can I just stop you? It is spelt out expressly. Don't you mean, just following on from what Mr. Anway had to say, that it is a consequence of the DRP? I'm not going to put it in terms of rezoning, but it didn't say you shall not develop. It said this is the use of the land.
No, so there are two things. So there's the use of the land for these purposes, and also there is a clause which states that from this moment on nothing can happen with the land. No, to keep it in a limbo until it is eventually taken, like physically taken. So I'm referring to this other position, but then obviously there also is the fact that the land is zoned for something else. With respect to the conversion right, that came to nothing because, as Mr. Anway explained, the 2009 law on planning and construction, which created the conversion right, again, expressly precludes conversion of the right of use over land designated for construction of objects serving a public purpose. And this is what Obnova's land became upon the adoption of the 2013 DRP. And Obnova also lost the right to obtain missing permits for its buildings at these locations. So I mentioned earlier, there's 2 million buildings in Serbia which are missing some permits. There is a special procedure put in place called the legalization procedure for these buildings to obtain these permits. And that procedure is not available for buildings built on land zoned for public purposes. We submit that under public international law, measures precluding reasonable exploitation of an investor's property amount to its indirect expropriation. The 2013 DRP constitutes a de facto expropriation also under Serbian law. Serbian courts have repeatedly confirmed that a rezoning decision that designates land for public use represents a de facto expropriation and must be compensated. That is important with respect to the second breach that we are invoking, which is the refusal to pay any compensation. So that right arises under Serbian law, independently of the protections that investors may have under their VITs.
And just going back to your previous slide, just so that the point is not lost, you are relying on the Santa Elena appreciation of what you contend was indirect expropriation.
Yeah, correct. Yes.
Right.
So this is with respect to the effects. Now let's look into the issue of whether the expropriation was legal or not. We submit it was not lawful because it did not meet any of the 4 requirements that we find under public international law, and more specifically under Article 5 of the Cyprus-Serbia VIT. Serbia failed to show that the expropriation was in public interest. Serbia did not follow due process of law. The expropriation was discriminatory, and Serbia did not pay any compensation.
And before you get there, just going back to that provision, I presume, I know, but you are relying on the language in the first sentence, or subjected to measures having in effect equivalent to expropriation.
Yes, we are claiming indirect expropriation, or a direct expropriation of certain rights, which then translates into indirect expropriation of the investment in its entirety. So we submit that the expropriation is not in public interest because it is unlawful even under Serbian law. And it is unlawful because of the conflict with the 2003 regulation plan, and then also a subsequent regulation plan from 2016. As Mr. Enway explained, the conflict resides in the fact that the higher level regulation plans zone the land as commercial zones and city centers, and the DRP does not respect the hierarchy and changes the zoning into traffic and traffic areas. Mr. Enway already showed you that the problem, so here we have again a picture from the 2003 regulation plan which zones Obnova's land for commercial zones and city centers. And on the next slide, we have the result of the 2013 DRP. That's the picture on the left. Now, Serbia does not deny that this conflict exists, but states that this actually is not a real conflict, because all that the 2003 RP says is that the commercial and residential use is just the predominant use within a block, and therefore up to 49% of that block can also be used for other purposes without conflicting with the zoning in the 2003 RP. Well, we say that this rule is spelled out correctly, but this is not what Serbia did with the 2013 RP, because if we look at both the 2013 DRP and then the version of the DRP adopted in 2015, we can, which is what you see on the right side, we can see that Obnova's land is located within block 45. And this block 45 is taken up for public use entirely. So there is not 49% of the block which would still be, 50% of the block which would still be used for commercial and residential use. What we can see in white on the right side is the bus loop. So this is coded for traffic and related infrastructure. What is in green are green areas, and what is in gray is some other public infrastructures such as a fire station. So the entire block is taken for public purposes. 0% of the block is for commercial and residential purposes. So this reference to the 50% rule is completely inapplicable here. Another independent reason is that public international law. Yeah.
Can you come back? The white area together with the green area. Can you very simply, in schematic way, show to me where is 17, 19, where is 23?
Mm-hmm.
And
so
I
here,
would assume in the middle is 21?
Yes, so 1719 is the the mainly white area to the west and north of the number 45.
Okay, where you see this gray, like the buildings, I assume. Right?
Yes, yeah, that's the area. Thank you. And then this is 21, so this is not subject to us. And then for 23, we do not have this picture here. For 23, actually, the issue is not so much that the bus loop itself would be placed there, but that the Dunavska street would be enlarged. And that enlargement would take more than 50% of Obnova's land. It would take more than 50% of Obnova's land. There, buildings have to be demolished and so on. It's a very small land plot. It's 1,000 meters squared only. So if we take one half of that, it's destroyed.
So for doing the enlargement, you need to use the property and obviously demolish the buildings.
Yes.
And that's more than 60%.
Yeah,
50%.
Yeah, we do not have the block analysis for 23 here. I'm just showing it for 17 to 19. But we can revert to that during cross-dimensional.
And just a question I was wondering, plot 21 is privately owned, is publicly owned?
It has the same status, so we understand that the owners are in similar problems with Serbia as we are.
Is there anything on the record that goes to that?
No.
Because
I was answering the question.
I mean, I asked you the question right at the beginning as to whether this was a normal privatization where others are affected. You said then you thought others were affected, and you're now saying that this seems to be testimony by counsel that in respect to plot 21, you understand that the owners are in a similar position.
Correct.
But we don't have anything on the record. This is
No,
just
no,
your,
we don't.
as it were, your evidence.
Yes, that's my answer to the arbitrator's question.
Thank you.
And I was answering specifically with respect to the DRP and its consequences. Not necessarily, we are not aware of the details of the privatization of the company which operates at 20. Okay, so the other independent issue which is important is the requirement for proportionality as part of the analysis of legality of expropriation. So here we rely on the case in Casinos Austria versus the Argentine Republic, where the tribunal stated that state measures that are disproportionate from the perspective of international law cannot qualify as legitimate exercises of the host state's police powers that fall outside the concept of indirect expropriations. And then further down, the tribunal explained that proportionality requires that a host state's measures first pursues a legitimate goal, public purpose, second is suitable to achieve that goal, third is necessary to achieve that goal in the sense that less intrusive but equally feasible and effective measures do not exist, and four is proportionate stricto sensu. What we are talking about here is especially the third point, the feasibility of other less intrusive but equally feasible and effective measures. As you know from Mr. Enway, right across the street, there is a much larger land plot, which is already used for traffic and roads. And it had been so used for at least 20 years. We did ask about the use of the land, and we were told that it started at the very latest in the 2000s. We then even went to Google Earth images, and we could see the bus loop. You can see it on the left side. It's the picture from November 2000. So the bus loop was already there.
Where in Article 5 do you locate proportionality, the proportionality requirement?
No.
You referred us to the Argentine Republic case. I'm not quite sure from the transcript which it is, but where in Article 5 do you locate proportionality?
So the case we referred to is Casinos Austria International versus Argentina. This is not expressly spelled out in Article 5 of the Cyprus BIT.
So if it's not expressly spelled out, where would you locate it? Or are you simply saying that as a matter of interpretative custom, if you like, that we have to understand that, because I see measures taken in the public interest, expropriation shall be made with due process of law on a non-discriminatory basis.
So this is at the beginning of paragraph 351 of the Casinos Austria decision. The tribunal considers that they don't say, but they must be referring to customary public international law. They say that the tribunal considers that the principle of proportionality is a recognized limitation on the exercise of the host state's regulatory and police powers. with respect to indirect.
I understand that I'm not questioning that case. I haven't gone back to have a look at the BIT in that case to see whether there was a hook in the treaty. So I'm simply trying to identify whether you have a hook in Article 5 in which you say references proportionality, or whether you are drawing proportionality from the ether of the law. If I could put it in those
No,
terms.
we are drawing proportionality from customary public international law.
Okay, thank you very much.
And as we know, on 28 December 2015, the city of Belgrade updated the DRP and rezoned the city's bus depot land plot for residential development. Why that is important? Well, that is important because it shows that in 2013, the city must have thought already at that time that it did not need the land for the bus depot, which is located there. Therefore, the city had its own land zoned appropriately for traffic infrastructure, and nothing prevented the city from placing the bus loop there. And that would have been a much less intrusive option, obviously, because the city would not be expropriating anything. It would be just using its own land for the purpose of the bus. Next point, Serbia failed to grant Cypriot claimants due process. It is undisputed, actually, that Serbia never conducted any proceedings that could lead to a lawful expropriation and calculation of compensation due to obnova. All that the city did is that on 5 September 2012, the city of Belgrade, which is after the investment by the Cypriot claimants, the city of Belgrade presented a draft of the detailed regulation plan for public inspection. The city was obliged to publish the information in newspapers. Curiously, the city picked 2 tabloids to do that. We took the pictures of these tabloids, we put them on the slide. I will not translate to you what they say. If you are interested, you can use Google Translate. These are not newspapers which are followed by the business community, shall we say. Unsurprisingly, only one person submitted any comments during the public inspection process. We submit, Serbia certainly did not encourage people to be aware of the fact that the DRP was available for comments by picking the 2 tabloids. But in any event, the public inspection process, we say, is irrelevant because it's not a process that would have given Obnova any effective means to dispute the 2013 DRP. The legal obligations of the city only relate to the fact that they had to consider complaints and adopt a conclusion on each submitted complaint, either accepting or rejecting it. Obnova's complaint during the public inspection of the draft would have been futile because the city did not have an obligation to accept Obnova's objections, and Serbia's post-2013 conduct shows that nothing would have changed even if Obnova had voiced any complaints at the time. And most importantly, Obnova's objections against the 2013 DRP would not have led to any compensation. This is a different process. After the plan was adopted, Obnova had, again, no effective means to dispute it. So this is on that basis that we conclude that due process was not followed. Serbia also acted in arbitrary and discriminatory manner when adopting the 2013 DRP. We are referring here to the Loder case versus the Czech Republic for a definition of arbitrariness. According to that tribunal, arbitrary means depending on individual discretion, founded on prejudice or preference rather than on reason or fact. And then for discrimination, we refer to Saluka versus the Czech Republic, the tribunal there held that discrimination exists if similar cases are treated differently and without reasonable justification. We submit that the decision was arbitrary because Serbia adopted the 2013 DRP without any explanation of why the bus loop needed to be located specifically on Obnova's premises, especially given the fact that the city already had its own land just across the street. The DRP does not even purport to present any analysis of alternative locations, any analysis of why that location was the best and only possible. And we submit that the DRP is also discriminatory, fundamentally for the same reason, because we don't know why Obnova's land was picked, and we just note that there are other land plots in the area, some of them owned by Serbia, which were not selected for that function without just any explanation. Then when I come to the last element of lawfulness of an expropriation, which is the payment of compensation, it is undisputed that no compensation was paid. So fundamentally, what is Serbia's defense? Well, Serbia's defense is that Obnova was not expropriated because it did not have any rights. And to get there, Serbia argues that Obnova's buildings are temporary objects that cannot be subject of property rights. At this juncture, we need to make a distinction between two arguments which are sometimes used interchangeably. And it's easy to address one instead of addressing the other. And this is what I also did in answer to Professor Douglas's question. There's one question is whether the building is permanent or not, and another question whether the building permit is permanent or not. The question whether a building is permanent or not depends on the physical characteristics of the building. And as Mr. Anway explained there and showed to you on all of his slides, it is clear that with respect to their physical characteristics, the buildings built at both premises are permanent.
By permanent, you mean really a sort of physical structure of bricks and mortar or wood, in contrast to a tent, something like that.
Correct, or a kiosk, or some temporary bridge, while the main bridge is being under reconstruction, or something.
Or the Eiffel Tower, temporary.
Exactly. Yes, we do have the Eiffel Tower, which is I would say it's a permanent building actually, which was built for purposes which were thought to be temporary at the time. I wonder how a French building office would fare if it suggested it needed to be torn down.
In fact, I'll tell the tribunal that comment was part of my presentation this morning I overlooked, which was when the Eiffel Tower was built, it was in fact a temporary structure, quote unquote.
But the short point is presumably that the distinction between permanent and temporary is to avoid the circumstance of someone intruding into the land, setting up a tent and saying, I've got, or setting up a shanty or whatever, and saying, I have a, but whether it's intended to be pulled down in 10 years' time and replaced with a better building is not the yardstick.
Yeah, exactly. Okay, so there can be no doubt, we say, that the buildings are permanent. And that also is the relevant legal assessment. In one decision of its own constitutional court that Serbia just chose to ignore in this arbitration completely, it is stated very clearly that under Serbian law, so now I'm taking that, no longer looking only at the physical characteristics of the building, but overall, when under Serbian law, we hear temporary building, that can refer only to smaller prefabricated buildings that are placed in public areas, kiosks, summer gardens, mobile stalls, etc. Only these buildings can be labeled as temporary buildings within the meaning of Serbian law. This is what the Serbian Constitutional Court held on the 22nd of June 2010. So that means that because of their physical characteristics, Obnova's buildings cannot be labeled as temporary buildings under Serbian law. Further, Obnova's buildings at Dunavska 1719 are registered in the real estate cadastre, and it is actually with the ownership of city by mistake. And it is undisputed that only permanent buildings can be so registered in the cadastre with their user or owner. So Serbia's own cadastre recognizes that these are permanent buildings. Otherwise, they would not be inscribed in the registry with the city of Belgrade as their user and later owner. Mr. Anway already explained that what Serbia refers to argue that the buildings or the permits on the basis of which they were built were only temporary is the civil law obligation to demolish the buildings, which Obnova had back in the 50s under the 1953 lease agreement with the municipality Stari Grad. This obligation is referred to in the building permits from the 50s, but the lease agreement ceased to apply at the very latest in 1961, when the municipality of Stari Grad granted the right of use over the land at Dunavska to Pristaništa Beograd, now called Luka Beograd. The lease agreement terminated after the transfer of the object of the lease by operation of law, and the then Serbian law change in landlord meant automatic termination of the lease agreement. Serbia actually recognizes that the 1953 agreement ceased to apply in 1961 at the latest. And Obnova's lease then entered into a lease agreement with Luka Beograd in 1962, and that lease agreement no longer included the obligation to demolish the buildings. So that obligation to demolish disappeared in 62. And then in 65, because Obnova was the user of the buildings, and the buildings are permanent and were permanent at that time, it also acquired the permanent right of use over the land.
If the obligation to demolish had survived, taking your case, would you accept that the fact of an obligation to demolish would make the buildings temporary?
No, we would not, because we would say that what matters is the characteristics of the building, and that would have created a situation where there is the right of use over permanent right of use over the land, but independently from that, an obligation to demolish as a contractual obligation, and which was to be enforced or not by the person holding the right.
Thank you.
So this is the expropriation analysis. Now I will go quicker through the analysis of the other standards of protection, because we all know that they overlap to a large extent, and we also know that expropriation is the standard the most demanding for the investor to meet. So we rely on the various formulations of the FET standard, for example, as in the case of Rumeli versus Kazakhstan, which mentioned that
could you locate, before you get to the jurisprudence, could you locate it in the treaty, please? What provisions you are relying on?
We don't have that on the slide.
I mean, I presume you're locating it in
we will
Article 2.
give you a reference to specific article.
Because the jurisprudence is really going to be appreciated in the light of the provisions of this particular treaty.
Yes.
These particular.
But, our point is that when it comes to the FET standard, the formulation is the same everywhere. So here, let's go back. The standard requires Serbia to act in a transparent manner, in good faith, cannot act arbitrarily, grossly unfairly. Its conduct cannot lack due process, cannot be discriminatory, and so on. We also know that the FET standard protects claimants' legitimate expectations. The 2013 DRP breached the FET standard fundamentally for the same reasons for which it constituted an indirect expropriation. So I'll not go into these details, but you have them on the slide. The FET standard was also breached with respect to the refusal to compensate Obnova for the expropriation of its property, because claimants legitimately expected, on the basis of Serbian law and the recognition of rezoning as a de facto expropriation under Serbian law, that Obnova would be compensated after the adoption of the 2013 DRP. Now, let's look at what reasons the Land Directorate provided for rejecting the request for compensation. It first stated that Obnova's buildings were built on the basis of temporary construction approvals, and Obnova is obliged to demolish them at the request of the People's Committee of the City of Belgrade without the right to compensation. So here they use the present tense, is obliged to demolish them at the request. So just to make one fact straight, no such request was ever made. The city has never come to Obnova to say, you know what, we are the owner of the land. And you know what, you have an obligation to demolish, so please do so now. That never happened. Now we are in the procedures, the reference is made to a right which the city itself never exercised at the very least. And we regret that we don't have a witness from the city who would enlighten us a little bit with respect to what the city thought about it. But in any event, the construction permits for Obnova's buildings are not temporary, and they could not have been temporary because the applicable regulations back in the 50s did not allow for the issuance of temporary construction permits. That became a possibility only in 1997. The obligation to demolish the buildings ceased to exist with the lease agreement. And then Serbia's reasoning is contradicted by the fact that the buildings are registered in the ownership of the city in the cadastre. Because the legal argument Serbia used is that temporary objects are not immovables, thus they cannot be subject of property rights. Then how come they are in the cadastre? Inscribed as subject to the property right of the city. And I will address that in a minute. So we say it's untenable to say that these objects are not immovables, which cannot be subject to property rights, when Serbia itself registers a property right on the buildings. And Mr. Anway showed you that this was registered even in the 60s with respect on the cadastral maps. I also referred already to the Constitutional Court decision, which says what a temporary object may be under Serbian law.
Just on that, I mean, you said that the respondent ignored it completely. That's not entirely correct. They did deal with it both pleadings. And what they say is that it relates to a specific provision of law planning construction, which came into force in 2003. So that I think their position is that it's a decision which relates to a narrow point under quite a late piece of legislation and doesn't provide a general definition.
Well, yeah, so okay, I take the point. So the answer is that this is the only definition available. And so in the 50s, there was no definition, permits were not even possible. The concept was introduced in 97 and later years. And this is how it is to be interpreted under Serbian law. There's no concept such as, oh, there's some legacy definition which the buildings would carry over from the 50s, because there was no such definition at the time. And also there's no rule which would allow them to carry over the prior definition contradicting the new definition.
So when the construction permits say temporary use in capital letters, what significance can we give to that?
Well, this reflects the civil law obligation.
So the entity issuing the construction permit checks what rights you have over the land, and on that basis,
yes.
So there's a
exactly. And then when the rights to the land change, then So in other words, like if the city, let's say that the city decided to release, and write, we will never ask you to demolish the building. The buildings would not need a new building permit, and the buildings are already built. The building permit is there. Doesn't matter what the building permit says. What matters is the civil law title. Okay, thank you. The second reason given by the Land Directorate is that it is not possible to positively identify objects built under temporary approvals. This is borderline disingenuous arguments because basically the state says, because we are not able to make sense on paperwork which the state did 70 years ago, we are going to hold it against you, Obnova, and say that you've been a squatter there for 70 years. In any event, the Land Directorate did not even attempt to reconcile Obnova's permits with its existing buildings. It did not approach Obnova to resolve the alleged issue. And in this arbitration, the question is moot, actually, because Serbia concedes that the office building at Dunavska 17 to 19 matches the respective building permits. And Obnova's right of use over the office building was sufficient for Obnova to acquire the permanent right of use to the entire land plot at Dunavska 17, 19 in 1995. 65, sorry. The third reason advanced by the Directorate is that Obnova's legalization request had been rejected in 2018. So legalization requests are requests to issue some permits which were missing from the 50s and 60s. So again, it is questionable to what extent the state should rely on the fact that it itself failed to issue missing permits to a socially owned enterprise 50 or 60 years ago. But fundamentally, the reason why the legalization requests were rejected in 2018 is the 2013 DRP, because the 2013 DRP zoned the land for public use, and buildings built on land zoned for public use cannot be issued the missing permits. The legalization procedure is not available for them. So we are asking to be compensated for the 2013 DRP. And they say, because of the effect of the 2013 DRP, we cannot compensate you. That cannot be true. That cannot be right. Fourth, Obnova's buildings allegedly could not be regarded as the subject of privatization. This is a completely bogus reason. The subject of privatization under Serbian law is the shares, but this has strictly no impact on the ownership or other rights to the buildings. Fifth reason, based on a 1975 agreement between the city and Luka Belgrade, the ownership over Obnova's premises was registered in favor of the city of Belgrade in 2003. That is correct. But the registration of the city did not affect the existence and or scope of Obnova's rights because Serbian law recognizes and protects unregistered ownership. This is undisputed between the experts. Because of the dire state of records in Serbia, it is unfortunately quite common that someone is registered and someone else is the real owner, and Serbian law perfectly protects the real owner. Further, the basis for the registration mentioned here is a 1975 agreement between the city and Luka Beograd. It should be undisputed that Serbian courts have repeatedly held that the 1975 agreement never entered into force. Then if you look at the text of the agreement, it did not refer to Obnova's buildings and thus did not transfer any rights to these buildings. And it could not have, because the buildings were constructed in the 1950s, and at that time, Luka did not even exist, but Obnova did, and Obnova acquired its right of use to the buildings upon their construction. And also, in real life, nothing changed because the city never asserted ownership rights over Obnova's buildings in any way. It did not ask for rent to be paid. It didn't ask Obnova to vacate the premises, nothing. Then with respect to Dunavska 23, the Land Directorate advanced only one reason, and that is that one building at Dunavska 23 is not included in the planned location for the construction of the terminal and on which the company compressor is registered as the holder of the right of use. But that is not true. The fact that the land plot is affected by the DRP is confirmed by data from the Land Directorate's own website. The Secretariat for Legalization previously refused to legalize Obnova's buildings on this land plot precisely because of the DRP, as I explained a while ago. And then the Land Directorate also entirely ignored the fact that Obnova has 4 other buildings at Dunavska 23. So that was just another bogus reason. Serbia also cannot excuse its conduct by the Serbian court's rejection of Obnova's ownership claim on 22nd September 2022. And here, in the interest of time, the reasons given there overlap to some extent with the reasons given by the Land Directorate. So I will just skip to the following slide, where the Court of Appeal in Belgrade rejected Obnova's appeal. I invite the tribunal to read the decision. The decision does not provide any legal reasoning on a number of fundamental legal points, such as its finding that Obnova's buildings are temporary, which squarely contradicts the Constitutional Court decision I have shown you. There's no definition of temporary permits or temporary buildings provided in the appellate decision, and so on. Obnova challenged the decision before the Supreme Court of Serbia, and the challenge is pending. In this arbitration, Serbia came with some more arguments. It argues that claimants could not have expected compensation for the 2013 DRP, which cannot stand because under Serbian law, the obligation to compensate for such de facto expropriation clearly exists. Second, that the Land Directorate is not competent to decide on compensation for alleged expropriation. And third, that Serbia is not responsible for the actions of the Land Directorate. So on the following slide, I have just the quote of our expert explaining the de facto expropriation and its consequences in terms of compensation. The same expert, Mr. Milosevic, explains that the Land Directorate was authorized to respond to the request for compensation, and in any event, the request for compensation was sent also to other authorities, but the Land Directorate was the only one which bothered to answer. And on the following slide, we have an analysis of the attribution of the conduct of the Land Directorate to Serbia, which in the interest of time, I will ask the tribunal just to read. It summarizes our arguments made in the submissions. Now, when it comes to impairment.
Stop you just to put a point. Is it your case, just so I understand clearly, that all of the issues and objections that you had to the 2013 DRP were aired before the Serbian courts, but rejected by the Serbian courts?
No.
No. Because there is this lingering issue in the shadows of whether your claim is in actuality a denial of justice claim, and you've taken us to the decisions of the appellate courts. And I'd just like to be clear what you are saying about those decisions of the appellate courts. Are they wrong? Was there a flaw in the process? Were there issues that the courts did not get to before because the claimants did not have an opportunity to put them to the courts?
No, yeah. We are not formulating a denial of justice claim here. And this is because if we go back to slide 149, the appellate decision was issued only on 7 December 2023. This arbitration was well underway at the time. And obviously we cannot formulate any claims with respect to a first instance decision which is subject to an appeal. So we did not formulate and never intended to formulate a denial of justice claim.
Well, I mean, that's not altogether surprising because the threshold for denial of justice claim is much higher.
Correct.
But I would just like to be clear what you are saying the tribunal's role is with regard to these domestic courts decisions, whether you are saying to us that they are wrong and that we have some kind of an oversight responsibility? And if so, what is that oversight responsibility as regards these domestic court decisions?
No, you're always to decide whether or not there was an expropriation and violation of other standards under the BIT. And we mentioned these decisions as facts. And we mentioned them because Serbia relies on them in its defense.
But you're mentioning them as facts in part because you're saying there was no due process, but presumably, although you haven't expressed it here in these terms, that there is an Article 5, paragraph 2 point, but you also go back to Article 2 and sort of the FET point that's sort of embedded in Article 2. I mean, the tribunal at some point, without anticipating which way we might go, but at some point the tribunal is going to have to grapple with our role vis-a-vis the domestic courts, the domestic court decisions. It's not an appellate role. It's obviously a role that would arise if you had made a denial of justice claim. And I'm just trying to tie down precisely what you are saying our role is with regard to domestic court decisions. And of course, there are cases out there, some of which you've cited, some of which the respondent has cited, not all of which though. So.
Yeah. So we are not asking you to make any determination with respect to these decisions. We mentioned these decisions only because Serbia invokes them. But we would say procedurally, these decisions are unimportant.
Thank you.
Footnote to that, though. I mean, we are to some extent having to decide precisely the same issues of Serbian property law. And the question is, what deference do we give to a Serbian court that's decided those issues in Serbian proceedings?
So our position is that for a public international tribunal like yours, there is no specific degree of deference to be given to the decisions reached by local courts. So you may look at the reasoning, and if you find the reasoning convincing, then you may reach the same conclusion, but not because a court said so, but because the arguments are persuasive.
So that's understood, but there is a very critical issue here in these proceedings, which is that this tribunal, before we even get to issues of law and leaving aside issues of jurisdiction and admissibility, this tribunal is going to have to make evidential decisions. And those evidential decisions are going to be based on really two streams of evidence before us. One is the factual evidence, and the other is the evidence of local law, whether it's Serbian law. We'll come on to Cypriot law in due course when we come to the jurisdictional issues. But for us, the issues of Serbian law are issues of fact. And we do not have independent expertise, so we are going to be making an assessment on the basis of the expert evidence on Serbian law. But at the end of the day, our assessment is going to be based on our appreciation of those facts. So unless you are making a denial of justice claim, obviously the issues that have been decided by the domestic courts are going to be thrown into the mix, and they may weigh on one side or the other in support of the decision, in support of the expert reports that we've got on issues of Serbian law.
But precisely because these are issues of facts, they do not, the decisions do not carry any heightened evidentiary weight. This is precisely the point. You're a public international law tribunal. So if we put in front of you a building permit and what it says, and the fact that Belgrade never claimed ownership, and expert evidence and court decision, all of them are.
Well, I'm not going to pursue this too much longer, but I am going to invite you to reflect on it, and we'll come back to this in the closing session next Friday. We are, as you correctly say, an international tribunal. We are not a tribunal of Serbian law. In circumstances in which a Serbian court reaches a judgment on what Serbian law says on the facts before them, we're going to have to take that very, very seriously. And in approaching our serious consideration of that judgment, we're obviously going to be fully informed, not simply by your submissions and the respondent submissions, but by the expert evidence on Serbian law. But it's going to be, not to put too fine a point on it, a robust tribunal that is going to say a domestic court interpreting its own law got its own law wrong. Now, that's not to say, and we will be a robust tribunal if we come to that conclusion. That's not to say that that result is out of the frame. It's not. It's absolutely in the frame. But the momentum behind a conclusion like that, to say that the domestic court got it wrong, is on the one hand denial of justice, but on the other hand, really robust evidence of domestic law that the court for some reason got it wrong, because we are not going to substitute ourselves, I suspect, as a domestic court. I mean, unless you are going to come to us with arguments to say, in fact, this is a whole de novo proceeding, and yes, you can substitute yourselves when it comes to a decision of what Serbian law actually says.
So exactly, this is a de novo proceeding, but that stems from the fact that a public international law tribunal looks at issues of domestic law as issues of fact. This is the consequence of that. Plus, it is the consequence of the fact that for quite some time, and I would say even today, because the appeal, let's call it, even though the exact name is different, before the Supreme Court is still pending. So there was like two parallel procedures at the same time with respect to certain issues. But fundamentally, this tribunal is above anything that Serbian courts may decide.
Thank you. So I serve notice. We'll come back to that next week.
Then we also invoke the standard of non-impairment, which we import by virtue of the MFN clause in Article 3.1 of the Serbia BIT, and the MFN clause in Article 5 of the Canada Serbia BIT. We note that the standard of reasonableness is closely related to, but broader than, the concept of non-arbitrariness. And we conclude that, again, for the reasons I have already provided, that standard was violated as well. There was an impairment of the investment due to the inexistence of certain rights following the adoption of the 2013 DRP, and this was not compensated. And finally, we make a claim under the umbrella clause, which is invoked by the Cypriot claimants by virtue, again, of the MFN clause. And we state that Serbia breached its obligations under the umbrella clause because it failed to comply with its obligations under Serbian law to compensate Obnova for the expropriation. So that concludes my submissions on the merits. And let's move to Serbia's jurisdictional defenses. As you have noticed, Serbia raises many jurisdictional defenses. We will take them one by one. The first defense relates to the tribunal's jurisdiction ratione personae under the Cyprus-Serbia BIT. And that boils down to what seat means under the Cyprus-Serbia BIT. And we submit it means registered office. In that respect, we refer to the holding of the tribunal in Mira Investment Fund Limited versus Republic of Serbia, which clearly stated that a company seated in Cyprus is one that is incorporated in Cyprus and maintains a registered office in the Republic of Cyprus. Serbia relies on another case, CEAC versus Montenegro. It's the same BIT. But we submit that the findings of that tribunal do not support Serbia's case, primarily because the majority in that case did not consider it necessary to determine the precise meaning of the term seat as employed in the BIT. It recognized that in vast majority of cases, a company's registered office will be at the address indicated in the certificate of registered office. And then, most importantly, it based its finding that the CEC claimant did not have a seat in Cyprus on very unusual factual circumstances, because the registered office was in a vacant private house, not accessible to public. There was no sign or brass plate indicating the registered office. The claimant showed no signs of any activities there. The registered office was not amenable to service by mail or courier, and the registered office did not host the company's books and registers. So in these very extreme circumstances, the tribunal said that the registered office was not the seat of the CEAC claimant. No such circumstances exist here. Another case that Serbia relies on is Elverly versus Romania, and that case does not support Serbia's case either. The definition of seat there was different. The seat had to be in the area of the Republic of Cyprus, which is under the jurisdiction and the control of the Republic's government. The reason why that definition was discussed in the Elverly case is that the beneficial owner of both of the claimant there was a Romanian national and thus a national of the host state, which is not something we have here. But one thing actually is interesting about the Elverly versus Romania tribunal, and that is that they expressly rejected the argument that Serbia makes in this arbitration that the seat of a company is located in the place where the ultimate power to control the company resides. Other cases also do not support Serbia's case. ATF versus Slovakia had, again, a different definition of seat. And WCV and CCL versus the Czech Republic actually has a dismissal of Serbia's argument. The tribunal there held that the problem with argument similar to the one Serbia makes here is that the term permanent seat, as used by the Czech Republic in its treaty practice, does not require that a company's central management and control be located there. So when we look into what Cypriot law says about the term seat, our expert, Mr. Georgiades, submits that under Cyprus law, seat is simply an equivalent to registered office. Interestingly, this is the same under Serbian law. Under Serbian law as well, seat is the registered office. That stems from Article 16 of the Serbian company law. It is undisputed that Kalemegdan and Coropi have their registered offices in Cyprus. And they are also, in any event, effectively managed from Cyprus. So if we use the Tenaris test, which has 3 elements, the first element is where the meetings of the board of directors take place. Well, the meetings of the board of directors of the 2 Cypriot claimants take place in Cyprus. Second, the books and records of both claimants are kept in Cyprus. And third, administrative services were and still are all provided in Cyprus by the Cypriot company HLB Cyprus Limited. Now, even if we took Serbia's incorrect approach and applied the test formulated by the CEAC majority, both Cypriot claimants would actually meet it because they have their registered office there. They have the right to use their premises there. Their meetings of directors take place in Cyprus. The majority of directors, for most of the time, were Cypriot nationals and residents, and both Cypriot claimants are tax residents in Cyprus. So we submit, there can be no doubt that both Cypriot claimants have their seat in Cyprus, and therefore the objection fails. Another objection is an objection ratione temporis. It is submitted that the dispute or relates, it falls outside the temporal scope of the Cyprus-Serbia BIT. The scope is defined in Article 12, which states that the provisions of this agreement shall apply to investments made by investors of one contracting party prior to as well as after the date of entry into force of this agreement, but it shall only apply to matters occurring after the entry into force of the present agreement. It's undisputed that the BIT entered into force on 23rd December 2005, and all breaches occurred thereafter. Because we claim the adoption of the DRP on 20 December 2013 and the refusal to provide compensation on 13 August 21. This is well after 2005. It is well accepted that the tribunal may determine whether Obnova had acquired ownership and the right of use over its premises prior to the entry into force of the BIT. That stems, among others, because Article 12 explicitly provides that it shall apply to investments made by investors of one contracting party prior to as well as after the date of entry into force of this agreement. So if Serbia now disputes the scope of the investment, it disputes a matter which under that provision may fall before the entry into force of the agreement. The agreement specifically says that it applies also to such investments. So the purpose of this Article 12 would be completely defeated if we just could say, look, because we raise an issue dating back to 1950s, no protection. This temporary scope is also confirmed in case law. It is wrong for Serbia to argue that the wrong registration of the city of Belgrade in 2003 created a permanent situation. For the reasons I already explained, and I will not go back again in the interest of time, that registration had no impact on Obnova's rights because unregistered rights are protected under Serbian law. And it did not lead to any dispute because, as I said, the city never came, now we are the owners, please vacate the premises. Importantly, Serbian authorities were clearly aware of and recognized Obnova's rights to its premises both before and after 2003. So Mr. Anway showed you the map from the 60s, which shows Obnova as the user. There are sketches from the 60s, which state the same thing. Obnova's privatization program from 2003 also has it. Another cadastral sketch from 2005, so after the inscription of the city, also states that Obnova is the owner of the buildings. And we could go on. And finally, even if a dispute existed in 2003 and 2004, that dispute would fail the triple identity test. So that disposes of the second objection.
Are you going to address us specifically on Article 22E of the Canada?
Yes, yes, it will come. Yeah. So I was addressing the Cypriot BIT, now I will move to Canada right now. So Mr. Broshko's claims are also based solely on events post-dating the entry into force of the Canada-Serbia BIT. And here is 21.2E, which states that in the case of a claim submitted under Article 21.1, no more than 3 years have elapsed from the date on which the investor first acquired or should have first acquired knowledge of the alleged breach and knowledge that the investor has incurred loss of damage thereby. So Mr. Broshko does not claim with respect to the 2013 DRP. He only claims with respect to the refusal to pay compensation, which occurred in 2021.
Isn't that the same claim, essentially?
No, this is, we submit it is not the same claim because the Serbia had never rejected the payment of compensation prior to 2021. And that obligation to pay compensation arises under Serbian law. So that obligation was created by the adoption of the 2013 DIP, and it existed, and Mr. Broshko expected that it would be honored up until the rejection of Serbia's compliance with that domestic law obligation in 2021.
So in essence, you are saying that because there is a new act, the alleged unlawful expropriation that that you say in respect of the Cypriot claimants that occurred in 2013, et cetera, if you like, was refreshed in 2018.
Now, this is not exactly what we say. What we say is that under Serbian law, the effect of the 2013 expropriation is that it gave rise to a right to compensation. We are only under Serbian law, and that right to compensation exists, but was denied in 2021. And it is the denial of this right in 2021 which constitutes the basis for Mr. Broshko's claim.
Because going back to the point on which we will hear witness evidence more in due course, which I raised earlier, just for point of clarification, Mr. Broshko had an expectation either that the 2013 DRP would be revised or that he would be compensated for his investment. So he was investing in expectation, bottom line, of compensation.
Compensation. Yeah, that's correct, but compensation under Serbian law. So he will, he said, I'm investing into a company which has a right to be compensated under Serbian law. And that right was denied in 2020.
Not a point that I'm going to pursue now, but I did see in the respondents' submissions a reference to a case in which I was presiding and which addressed exactly this, but in the context of CAFTA. That's the Berkowitz-Spence case. And this issue of when first acquired knowledge of. So I do not declare any specific focus in terms of 22(2)(e) at the moment, but it's obviously an issue which is very alert in my mind. You may wish to revisit that and come back to that next Friday if you consider it relevant.
So we covered actually that slide, which then explains the sequence of events. We submit that the 3-year time limit started to run upon Serbia's refusal to provide compensation under Serbian law. And as a result, the claim which was filed on 27 April 2022, so that was, and again, going back to that was even before the first instance decision by Serbia was issued, was filed within the 3-year time period.
I note that you have 15 minutes.
Thank you very much. Now, we are only 5 objections from the end. So the next objection is that the tribunal does not have jurisdiction ratione materia under the Cyprus-Serbia BIT. We submit that Kalemegdan's and Coropi's ownership of the Cypriot Obnova shares qualifies as an investment under the Serbia-Cyprus BIT. Kalemegdan is the registered owner of the Cypriot Obnova shares, and Coropi's beneficial ownership of the Cypriot Obnova shares is protected under the Serbia-Cyprus BIT. We also submit that the ownership of shares is sufficient proof of investment. The term invested by used in the treaty does not require Kalemegdan's active contribution. But in any event, Kalemegdan did make a contribution, as confirmed by the tribunals in Kiborax, Litop, and Westwater. Issuance of the investor's own shares against in-kind contribution of the investment into investor's capital is a contribution. This is exactly what happened in 2012. The shares in Obnova were in-kind contribution into the capital of Kalemegdan, and Kalemegdan issues its own shares in return.
That still holds when it's a related party transaction.
We do not see any reason why that would not be so, because I would say contribution of an asset into the capital of company is always a related party transaction. The person contributing the asset becomes shareholder.
Obviously no cash element.
Well, say by definition, in-kind contribution has no cash element.
But no independent valuation of the in-kind contribution. So if I understand correctly here, it was essentially a county corporation.
No, it was change in ownership. Kalemegdan obtained the shares, did not pay cash, but issued its own shares.
The value of those shares, it's not.
Well, in theory, the value of those shares would be the same as the value of the investment if the investment is the only asset of the company. But fundamentally, holding otherwise would basically mean that when shares are or any other investment is contributed in kind, there is no investment protection for such assets. And then, in line with investment arbitration case law, Kalemegdan may also rely on earlier contributions by its legal predecessors, means those who owned Obnova before them. Coropi became the beneficial owner of Kalemegdan because Mr. Obradovic held the shares in Kalemegdan in trust for Coropi. The existence of the trust is proved by the testimony of Mr. Rand and Mr. Broshko, which is sufficient under Cyprus law because a trust can be created orally. The creation of such trust is corroborated by documentary evidence, such as a letter of instructions, which was issued by Coropi to the directors of Kalemegdan on 26 March 2012, 3 days after Kalemegdan's incorporation. But in any event, in April and August 2012, Coropi concluded trust deeds with Mr. Obradovic, confirming Coropi's beneficial ownership of Kalemegdan. The protection of beneficial ownership under international law does not depend on its enforceability against third parties under the domestic law of the host state. But in any event, Serbian law recognizes beneficial ownership created under foreign law. Now let's move to the tribunal's jurisdiction ratione materia under the ICSID convention, so the Salini test. The tribunal knows that very well. Our position is that the ICSID convention actually does not provide for the Salini test, and as a result, it should not apply. But even if the Salini test were to apply, the Cypriot claimants do satisfy all conditions because there is contribution. Kalemegdan obtained the shares in exchange for its own shares. That is contribution. Kalemegdan and Coropi also afterwards contributed managerial services to Obnova, and the two trust deeds between Coropi and Mr. Obradovic explicitly refer to consideration given by Obnova, so, by Coropi, so that refers to Coropi alone. The investment also involves significant risk, which is proved by the very existence of this dispute, and in any event, the investment in shares in a company always entails an inherent risk of a decline in their value. Serbia does not even argue that Cypriot claimants' investment lacked sufficient duration. Now, claimants' investments were acquired in accordance with Serbian law. With respect to the Cypriot claimants, the argument that Serbia puts forward is that they failed to publish a mandatory takeover bid to the other shareholders of Obnova when they acquired the shares in April 2012. What happened is that under the takeover law, the prior version of the takeover law, the Serbian Exchange Commission, the SEC, published an opinion in 2007 which stated that the transfer of shares between persons acting in concert did not trigger any obligation to publish a takeover bid. The then owner of the Obnova shares, Mr. Obradovic, and then Mr. Rand and Kalemegdan and Coropi are all one group, shall we say. Therefore, they were acting in concert at the time. Under the 2007 opinion, no obligation to publish a takeover bid arose. On 4 January 2012, an amendment to the takeover law entered into force, which introduced a new exemption from the obligation to publish a takeover bid, which was defined that if after the takeover bid has been carried out, the person acquires shares of the target company by transfer between persons who acted in concert in the takeover bid. So another exemption is introduced. So on 23rd May of 2012, represented by a leading Serbian law firm, Mr. Obradović and Kalemegdan, the nominal owners of the shares which transferred, notified the SEC of the 2012 acquisition, relying on the 2007 opinion. The SEC didn't, accepted the notification, didn't require anything. Then on 17 October 2012, the SEC published an opinion which adopted a more restrictive interpretation of the takeover law than the previous opinion from 2007. And under that interpretation, the transfer did trigger an obligation to publish a takeover bid. Nothing happened in Serbia until we started this arbitration in 2022. It is only in this arbitration that Serbia claims that the investment was not acquired legally, because under the October 2012 interpretation of the January 2012 amendment, the transaction, which was duly notified in May 2012, without any reservations on the part of the SEC, should have triggered a takeover bid obligation. We submit that does not hold water. States cannot say 10 years after the facts, of which it was fully appraised, that an illegality arose. But most importantly, back in May 2012, when they notified the transaction to the Commission, the investors had no way of knowing that, 6 months later, another interpretation will be adopted under which they were supposed to launch the takeover. So they acted in good faith. Yeah.
This is not a question, but it's a marker. And I see the case is addressed in the submissions, and I appreciate the comments that have been made about it, but I would find it helpful, certainly for myself, my colleagues may do similarly, when we come to next Friday, for you to give us your views, claimants' views, on the overlap, if at all, between these proceedings and the RAND investment proceedings and the decision that was issued not so long ago by an eminent tribunal. Obviously, the factual circumstances are going to be different, but some ICSID investment claims were ruled out on the basis of the ICSID convention. And I'd just like to be clear in my own mind the extent to which you rely on this, or you disavow it, or you consider that it's not an item because of the factual circumstances. No, and the same question obviously goes to the response.
I would just very briefly note that the objection on the basis of which the RAND tribunal denied jurisdiction over the Cypriot claimants was not raised in this case. That's why we did not address it. We are addressing objections which are made.
I understand that. I'm not resolved in my own mind, so don't read anything into this question. But for example, I'm looking at paragraph 277 of that decision, and says, it follows from the foregoing discussion that the tribunal has jurisdiction Russian materia under the ICSID convention over claims brought by Mr. Rand under Canada Serbia BRT in respect of his interest in the beneficially owned shares, but lacks jurisdiction over his claims in respect of his payments for the benefit of BD Agro and his indirect shareholding in BD Agro. Now, I haven't disaggregated these issues in this one and to see how they apply there. I would like your assistance in doing so, to identify whether this is something that we should look at because it's useful, whether we shouldn't because the facts are different, or whether you think that tribunal got it wrong. But it's not for now. That's a big question, just for you to reflect on.
Thank you very much. Super briefly, we believe the facts are different, and the fundamental facts is that the RAND tribunal had to resolve the fact that both Mr. Rand and the Cypriot claimants were claiming at the same time. And the tribunal said, well, if the two of you are claiming at the same time, only Mr. Rand can claim. This is not the situation we have here. Plus, I we do take issue with the legal reasoning of the Rennes tribunal, because as far as we know, that would be the only case which somehow stated that only the UBO can claim and the intermediary companies cannot. And there are hundreds of cases where the intermediary companies are claiming, and without triggering any issues with respect to existence of an investment under the ICSID convention, even though the money they spent, had been provided by their UBO.
Thank you. Not to pursue it further, I haven't been able to locate, but in the docket, but maybe I've just missed it, the partially dissenting opinion of Marcella Cohen in that case. If it's in the docket, I'd be grateful if you could draw my attention to where it is in the docket, and if it's not, I would like one or both of the parties to produce that, please.
All right. So then the same, I'm going back to the objection regarding the legality of investment. Here, the same objection is made with respect to Mr. Broshko's acquisition, again, to state that he was required to issue a takeover bid. To simplify, that objection rests on the incorrect factual perception that Mr. Broshko was a member of the management body of Rand Investments within the meaning of Serbian law, and it's now established that he was not. But in any event, that entire discussion actually is to some extent superfluous, because the Canada-Serbia BIT does not require that investments be made in accordance with domestic law. And in any event, even if this existed under the Canada-Serbia BIT like it exists under the Cyprus-Serbia BIT, a violation of the takeover law would not deprive the tribunal of its jurisdiction under either treaty, because only violations of fundamental rules of Serbian law would deprive the tribunal of its jurisdiction, and it's not such a violation. Actually, Serbia's own expert, Professor Lepetic, concedes that a violation of the obligation to launch a takeover bid does not lead to invalidity or even voidability of the underlying transaction.
You have exhausted your time. I'm going to give you another 5 minutes.
Thank you.
And I would invite you in those 5 minutes to canter quickly through your remaining 25 or so pages, so that they are on the record and we can have a look at them rather than spend all your time going.
Okay, thank you very much, Mr. Chairman, and thank you for your indulgence. The seventh objection and final objection to jurisdiction is the requirement for Mr. Broshko to submit a waiver on behalf of Obnova. So fundamentally, we state that Mr. Broshko does not control Obnova and thus is unable to obtain a waiver from Obnova. But in any event, the absence of the waiver would not affect the tribunal's jurisdiction, also because Obnova has not sought compensation before Serbian courts. That was done on purpose. Compensation is sought before this tribunal, not before Serbian courts. And finally, Serbia's objection based on the absence of Obnova's waiver is belated, because in accordance with Rule 41 of ICSID arbitration rules, any objection that the dispute is not within the competence of the tribunal shall be made as early as possible. And that must read as superseding the ultimate limit, which is the filing of the counter memorial. But if Serbia is aware of an objection earlier than the counter memorial, it must make it as early as possible. And this is not what Serbia did in the present case. That leads me to admissibility. Fundamentally, it is argued that the claims are inadmissible because they were foreseeable at the time when the claimants made their investments. And therefore, the claimants constitute an abuse of process. So first, on legal grounds, an abuse of process can exist only if an investment is made for the sole purpose of acquiring treaty protection. That proposition we cite to René Levy versus Peru and Phoenix Action versus the Czech Republic. Alternatively, under some other line of case law, an abuse of process may occur only if a specific dispute is foreseeable with a very high probability at the time of investment. Here we refer to MNSS versus Montenegro, OC Gramercy versus Peru, and Brief Trust versus Serbia. There also is case law to the effect that arm's length market transactions do not give rise to an abuse of process at all, because they are arm's length on the market. And that applies to Mr. Broshko's claim, because Mr. Broshko acquired his shares through arm's length transactions on the market. Therefore, the question of abuse of right could arise only with respect to the Cypriot claimant's acquisition. Mr. Rand explains that he organized the involvement of the Cypriot claimants in 2012 for tax reasons, not to acquire investment protection. And the present dispute was not foreseeable at the time. I already explained why the 2003 registration actually was not significant. The same applies to Obnova's 2003 privatization program, and please, you may read the bullet points. The dispute was also not foreseeable based on Serbia's failure to respond to Obnova's 2003 request for legalization. Also not on the mere fact that the city decided to draft the DRP in 2006, because no one knew what would be in the DRP and whether it would apply to Obnova at all. And in 2008, in early 2008, Mr. Rand heard rumors about that the bus loop may be located on Obnova's premises. So Obnova wrote to the city to remind the city of its rights and requested that the bus loop be located elsewhere. The city responded by confirming that Obnova's premises were located in areas intended for commercial activities and urban centers, and instructed the Urban Planning Institute, which was bound by the city's instruction, to consider this fact as well as Obnova's letter when preparing the 2013 DRP. So based on the city's letter, we are still back in 2008, as well as the subsequent passage of time, because the restructuring took place in April 2012, Mr. Rand came to believe that there was no substance behind the rumors. One last point. There was a dispute between the parties as to what was attached to Obnova's letter at the time. The tribunal may remember that because we made submissions on this point relatively shortly before this hearing. We submit that the letter which Serbia provided into the record is a fabricated compilation of existing documents. The alleged attachments are not the actual attachments of what was sent in 2008. On the following slides, we summarize all of the reasons. They're also spelled out in our submissions on that issue, which we presented.
So on that particular point, there is nothing beyond your written submissions on this authenticity point.
No, the slides just summarize the submissions. The one thing we want to highlight, though, is that at the end of the day, Serbia admitted that they are unable to conclusively prove that the attachments were filed with the initiative. But that we submit as a problem. If they want to rely on something which was sent to them in 2008, or which they found in the archive in 2022, the easiest thing on earth is to have a witness, someone who dealt with the issue back in 2008, or in 2022, or in 2024, when they were providing the document to council or the state attorney office, and explain what happened with the document. We do not have any such witness in this arbitration. And I want to conclude with that. There are several key factual allegations which are made by Serbia with respect to what happened in 2003, 2008, 2013, and so on. And we do not see any fact witness who could explain that what Serbia argues in this arbitration were the actual considerations taken into account at the time. They are not able to explain their decisions and their disregard of Obnova's rights. And this is the reason why we are sitting here. We are here to claim before this tribunal for the protection of the investors' rights, which were completely disregarded by Serbia. You know, Obnova had been at these premises for 75 years, uninterrupted, and Serbia's case against us is that we have been squatters for all that time.
Thank you, Mr. Prakash, and to the claimants team. I think you've gone a little bit over time, 10 minutes or so over time. Respondent, I will give you the same latitude. Unless there's any housekeeping point before we break for lunch, I'm proposing to suspend the proceedings now and we'll reconvene at 2:30. And as I say, I will give you the same latitude as Claimants Council have had, and we'll recommence for your opening submissions. Okay. Thank you. Bon appetit. Is everyone ready to go? Is Mihaj your microphone? Are you getting anything? Is that working? No? Elizabeth, can you?
Okay, what?
If there's anyone in a booth, we need some assistance. Cheers. Is that working? No? Not yet. Can you hear me? Can you hear me? Still not? Can you hear me? Can you hear me? Okay. All good to go. We'll try again. Over to you.
Good afternoon to all. Dear members of the tribunal, the respondent's opening statement will be divided into 4 parts. First, I will address the key factual issues to demonstrate that Obnova did not hold any property rights over the land and the objects at Dunavska Street capable of being expropriated. Following this, my colleagues will discuss the question of jurisdiction, and Serbia will also briefly address the admissibility objection concerning abuse of process. And finally, Serbia will present its arguments related to the merits of the case, focusing on the issues of expropriation, FAT, MFN, and umbrella clause. So, when it comes to the factual background, claimant's case in this arbitration actually rests on one crucial assumption, and that is that all the way back from 1940s and 1980s, Obnova was holding property rights over the land and the objects at Dunavska 17, 19, and 23. However, the truth is that Obnova never acquired any property rights over the said real estate, and during the presentation of the factual background, I will focus on showing the factual exhibits that we have on the record that clearly lead to this conclusion. However, claimants and their real estate experts grossly misrepresent and downplay the significance of the existing documentation in the files. And I will give you only several examples, just like introduction. So, for example, they state that in late 40s and 60s, the state granted Obnova the land in Dunavska 17, 19, and 23, over which Obnova obtained the right of use as emanation of social ownership. However, they are unable to offer any documents proving this. So they state that that was usual practice for the state to grant the land without any written trace. Then claimants are also suggesting, and we also heard that today as well, that we should disregard existence of the lease agreement for various reasons, that we should ignore the parts, the whole parts of all construction permits ever issued to Obnova. And these are the parts which are saying that Obnova is allowed to construct temporary objects and that these objects must be removed. Then they also suggest that we should ignore the fact that Obnova was never inscribed in the cadastre. That is not even disputable. And finally, they suggest that we should ignore the existence of the final court decision saying and confirming that Obnova has no rights over the land and the objects in Dunavska Street. The same real estate that are subject of this arbitration. On the other hand, Serbia is suggesting otherwise, and actually we are suggesting that we follow the documents. And we submit that the documents clearly show the following. First, they show that Obnova was always just a lessee of the land in Dunavska 17, 19, and 23. And that is provided in a number of lease agreements that Obnova was concluding with the city and then later with Luka Beograd and its predecessor. And second important fact, also proven by the exhibits, is that since Obnova was just a lessee, Obnova was allowed to construct only temporary objects, as clearly stipulated in the construction permits. And Obnova was also obliged, again, explicitly in the construction permits, to remove these objects as soon as requested so by the competent authority. It goes without saying that Obnova must also remove the objects that it constructed without any permits, illegal objects that Obnova allegedly constructed, and relevant legislation. And as we already showed, and as we'll again show today, the relevant legislation requires that illegal objects are removed from the land they are constructed on. Finally, documents also show that unlike Luka Beograd, Obnova was never inscribed in the real estate register. Never. But they are suggesting that we should ignore that fact as well. And finally, we have a number of court decisions confirming that Serbian courts rejected Obnova claims, property claims related to the Dunavska. I will now provide a chronological overview of the developments related to the property at Dunavska Street. And I will start with Obnova's establishment, and I will conclude with the events leading up to early 2006, when shortly after, as claimants suggest, Mr. Obradović acquired Obnova on Mr. Rand's behalf. So as claimants already confirmed, Obnova was established in December 1948 as socially owned enterprise, and at the time, the construction land was owned by the state, and the state was allowed to allocate the land to social enterprises. So in some cases, the state indeed was granting the right of use, the right of...
No, I can clear my throat. You can breathe. It's a good way to open. Are these social enterprises essentially the state? Or do they have, I mean, obviously they have, in terms of their bureaucracy and administration, they are not central government, but are they effectively the state in the sense that, I think you said, so the state can give to social enterprises? Is the state simply giving to itself for purposes of social uses?
Well, I wouldn't say so, because all these social enterprises also had some, organs that actually was dealing with the businesses of the social enterprises. So I wouldn't say that that was the same.
And they had, if not shareholders, but employees who had and went on to have certain rights subsequently.
Of course, employees were also included in managing, at that time, the employees were included in managing the social enterprises. And at the time of privatization in Serbia, the workers of social enterprises also become the minority shareholders of the privatized entities. So I think that that is telling enough what was actually the
Yes, I understand that. I suppose what I'm trying to crystallize a little bit more clearly is that counsel for the claimants were saying, on multiple occasions, that this was, communist Serbia, and all that was needed was a telephone call from.
Of course not. You can only imagine how chaotic that would be. That would be if actually the various state authorities and the clerks working there were allowed, just to pick up the phone and says, okay, we are giving you Dunavska 1719 without any written trace. Of course, that was not like that. And actually, you will see from the expert report provided by Professor Živković and Mr. Milošević, they are suggesting something like that. But they are unable to provide any evidence of that. That is just only their statement that it was like that. No other example in that regard, no other legal authority that would confirm that. And frankly, they are, I'm afraid, too young to testify about what happened in 1940s.
Okay, thank you.
Thank you. So, as I was saying, the state was allowed to grant the right of use over the land to the social enterprise, but in some other cases, the state was only leasing the land to the social enterprises. And maybe this is a good point just for us to remember that there is a difference. We have already explained that in our submission, but maybe it's good that I repeat it now. That there is a difference between right of use and right to use. So when we are speaking about right of use, I think that both parties agree that that is actually the surrogate right of ownership right. And that in the same way as an ownership right, that the right of use is actually property right in its nature. However, the right to use that the lessee possess is a contractual right arising from the lease agreements. So the holder of the right to use under the lease agreement cannot, for example, sell the property, encumber the property, exchange the property for another property, which is something that the owner can do.
I should say I understand the point that you're making, and as you say, it's addressed in the pleadings. For myself, I'm not entirely sure that the words of and to can sustain the kind of the weight that are being given to them, because you could read either the right of use or the right to use in exactly the same way. So I think, as between the parties, at least for myself, the explanation is more useful than the headline.
I fully agree with you. I fully agree with you. Yeah. That is why I needed to explain this one more time. But there is also something which is related to this topic. When you say, for example, user. So, for example, we heard that again today from the claimants, and they are trying to mislead the tribunal while implying that the Serbian word korisnik, which is translated as user, and which is contained in the sketches that we saw today again in Claimant's Exhibit 329. That word should be translated as a person having the right of use. That is incorrect. That is incorrect. And actually, we have provided the exhibit in that regard, R183. And there it is explained that the word korisnik is described as the one who utilizes something, who uses something, and that is a quote, sorry, the one who has a right to use something. So therefore, this term pertains to a person who uses something and not who owns something. So users can equally be the owners, but also lessees. Because when I'm lessee, I'm using the property that I leased. And it wouldn't be uncommon in Serbia that you say that I'm korisnik, i.e. that I'm user of the leased property.
Your exhibit, which has just got the one-line extract in English, I mean, again, this is all going to be contextual,
Yes.
isn't it?
So in any case, the state did not grant the right of use to Obnova, as claimant suggests. And I again have to repeat that they offer no document whatsoever to prove this very important, if not crucial, fact. And instead, they provide the expert report of Professor Žiković, which I already mentioned. I already mentioned what was said in that report, and that this was said without providing any exhibits in that regard, that actually the state was giving right of use without documenting such disposal. However, as we can see from the exhibit, XU authorities actually were diligent, at least diligent enough to document disposal of the land to social enterprises. So we have a number of documents available in case files, which explain how Obnova came to use the real estate in Dunavska streets. And these documents reveal that Obnova always used the Dunavska plots as a lessee. So, first document that showed that Obnova was leasing the land already in 1949, and that was only a few months after Obnova was established. That is the document. That document is the city's approval from August 1949. And by that document, Obnova was allowed to construct a canopy. And that document mentions that Commission agrees with Obnova's request to erect the necessary canopy on the land leased to you. So it is clear that already at that time, few months after Obnova was established, it was leasing the land. There is no other explanation why would this document stated something like that. Then in a subsequent document from October 1949, the city stated that the canopy is a temporary object, which shall be demolished upon the request of the competent authority. So what is important in this document, that first of all, it confirms that the object will be temporary and that the object will be demolished after request of the competent authority. And also what is important, these documents predates 1953 lease agreements, for which claimants state that served as a ground for the demolition obligation that was included in subsequent construction permits. But now we see that we have permit that predates the lease agreement for 53 that also contained demolition obligation. Shortly after, Obnova was issued the first construction permit in 49, which again expressly allowed construction of temporary objects and contained demolition obligation. 4 years after the first construction permit, in 53, the city allowed Obnova to construct another temporary object, and the city and Obnova concluded another lease agreement for Dunavska 1719. Few months.
And I mean, just to sort of cut through this a little bit, and your case is that Mr. Rand in 2005 could not have acquired more than Obnova had.
Of course.
So that's your essential point.
Of course. So in April 1953, the city issued to Obnova second construction permit for the object that the city previously approved. And finally, in 1954, Obnova obtained 5 more construction permits for construction on parcel 47, that is in Dunavska 1719. So we have 7 construction permits that were issued to Obnova in that period, from 49 to 54. And 6 out of these 7 construction permits contain explicit reference that the objects are permanent, that the objects are temporary for temporary use, and that the owner shall be obliged to remove those objects upon the request of the competent authority without being entitled to any damages for the demolition of the objects. And indeed, there is one construction permit that is from plumbing installations that does not contain this wording, does not say that these objects are for temporary use, but this permit was issued for a plumbing installation for a temporary object. So it is obvious that plumbing installation are also temporary, since the building they are related to is temporary. Another important fact is that these 7 permits actually allowed construction of 5 objects for temporary use, and 3 of them are canopies, and 1 of them is plumbing installation for temporary objects. And as claimants mentioned already today, it is true that in 56, Obnova obtained occupancy permit for 2 objects, but this permit expressly refer to the construction permits that allowed construction of temporary objects. So occupancy permits cannot change the nature of the object constructed based on the construction permits which allowed construction of temporary objects. In fact, by referring to these construction permits, occupancy permit only confirmed temporary character of the objects. 2 years after Obnova obtained these construction permits in 1957, Lucas predecessor, the Directorate, was founded and was tasked with operations of development of the Danube Port and River Bank, where Dunavska Street is located. So having that in mind, in the following years, the Directorate was the one who was leasing the Dunavska plots to Obnova. And in 1959 and 60, these 2 companies concluded 2 lease agreements which related to both Dunavska 1719 and Dunavska 23. And true to be told, unlike the agreement from 1959, the agreement from 1960 mentions Dunavska Street, but does not specify the exact address. However, as you can see, the surface area that is leased under both of these agreements was exactly the same. And I think that clearly suggests that that's related to the same real estate. Closely after the conclusion of these 2 agreements, in November 61, the Directorate ceased to exist, and the assets of the Directorate were transferred to newly established social enterprise, Port Belgrade, or in Serbian Luka Beograd. And the city accordingly granted right of use over the undeveloped bank of the Danube River, which includes location of Dunavska Street to Luka Beograd. Thereafter, Obnova actually continued to assert its status as the lessee of Dunavska plots by establishing not less than 5 decades long relationship with Luka Beograd. And this relationship was firstly reflected in the lease agreement concluded in 62, and then in the agreement from 65. Both of these agreements related to Dunavska 1719. Something important happened in the meantime, and that was that Luka Beograd's rights over the Dunavska plots were endorsed in 66 and 68, when Luka Beograd was inscribed in the land books as the holder of the right of use over the land in Dunavska 17, 19, and 23. And importantly, Obnova never disputed this inscription. And I would say that that is telling. In the following years, the city of Belgrade adopted a new urbanistic plan, and after that, it was decided that Luka Beograd would transfer part of the undeveloped riverbanks to the city. And that transfer was agreed by the agreement concluded in 1975 between Luka Beograd and the city. And the subject of the transfer was also the land at Dunavska 17, 19, and 23. However, there is Annex 3 of that agreement which permitted Luka Beograd to continue to use this land, I quote, until the land is brought to its intended urban purpose. And that is actually the reason why Luka Beograd continued to lease the Dunavska plots even after the conclusion of 1975 agreement.
Ms. Meehan, may I just take you back to your, I think it's C160, your exhibit on slide 15. In that lease contract, it talks about the lease of fixed assets being entered into for an indefinite period of time. Are we to make anything of this reference to fixed assets rather than temporary assets? Or
Let me just, no, that's not the meaning of the word fixed asset, but let me just see the Serbian version. These are actually like main assets of the company, you know. In Serbian, it means osnovna sredstva, that is osnovna sredstva, that is translated as fixed asset. But the main assets would be, you know, land, for example, and I don't know.
But what I don't want you to do as counsel is to start testifying. So you'll give us your understanding of what it means in Serbian, and no doubt the claimants in due course, if there is anything to be made of this, we'll come back to it. I just wanted to sort of highlight the point, because as you go through your presentation, there are obviously, at least in the minds of members of the tribunal, going to be key documents that you're emphasizing and that we're picking up as we did with the claimants. So I'm just not quite sure whether to make anything of this.
No. Osnovna sredstva, the right translation is not permanent assets. It's not the correct translation.
Okay, thank you.
So after that agreement from 75 between Luka Beograd and the city, in 83, 85, and 1994, Obnova and Luka Beograd concluded 3 new lease agreements that related to Dunavska 17-19. So the agreement from 85 does not expressly refer to Dunavska 17-19, but in Article 25, which we can see on the screen, it states that it replaces the agreement from 65, and the agreement from 65 explicitly related to parcel 47. As to the agreement from 1994, unfortunately, that agreement was not available to Serbia, so that is why that agreement was not exhibited. But the existence of that agreement is acknowledged by the lease agreement from January 2000 that relates to Dunavska 17-19. I think that we can also see that on the screen. Yes, Article 16 suggests that there was the agreement from 15 March 1994 that is to apply after the conclusion of the lease agreement in 2000. And that is probably not the only agreement that existed, but that Serbia was unable to obtain and submit in this case, in this arbitration. So as to Dunavska 23, we do not have lease agreements in our files that are concluded between 1960 and 2000. However, that does not mean that Obnova and Luka did not conclude any. But be it as it may, as I already mentioned, in that period, Luka Beograd was inscribed in the land books as the holder of the right of use over the land, also over the land in Dunavska 23. And Obnova did not dispute that inscription. So if Obnova indeed considered to be the holder of the right of use, Obnova would surely dispute the inscription of Luka Beograd. Claimants also argued that Obnova constructed several buildings at Dunavska 23 between 1988 and 1992, but we were not provided with any evidence in that regard. And actually, we do not have the evidence that Obnova used the land in that period. All we have is just claimant statement, no exhibits. In any event, what is undisputed is that Obnova, if constructed, that Obnova constructed objects in Dunavska 23 without any permits, which means illegally. So this all brings us to privatization of socially owned companies such as Obnova and Luka Beograd, which commenced in late 1990s in Serbia. So the purpose of privatization was to transfer the social enterprises and their assets into private ownership. And we agree in that regard with the claimants. But what is important for our case is that prior to its privatization, in September 1999, Luka Beograd prepared a report on appraisal of its capital, and Luka Beograd in 1999 included both parcels 47 and 39 as part of its real estate property. And also Luka Beograd indicated in that same document that there is a dispute between Luka Beograd and Obnova related to 10 unidentified objects. And after the appraisal of the capital that Luka Beograd performed in 1999, Obnova obviously had no doubts that the parcels 47 and 39 are indeed part of Luka Beograd's property, and thus concluded two more lease agreements with Luka Beograd in 2000 that related to both. Now we have the lease agreements, two lease agreements. One relates to Dunavska 17-19 and another relates to Dunavska 23. And by this, Obnova just further affirmed the understanding that it is actually the lessee of that land. And this understanding, Obnova reaffirmed in its financial statements for 2002, where it was stated that Obnova does not own any land. And for the objects, Obnova designated certain value, the value of some object, but Obnova did not specify what objects that might be.
Are we to, just to go back to your earlier slide, you drew attention to the 10 objects, listed disputed objects, and the area there quoted is 2,365 square meters, and the disputed objects. And when you go to the table on the left-hand side, one would struggle to get to an area of 2,365 square meters, which suggests that there were many other Obnova parcels of property that were interested in all of this. Or am I just completely misreading the figures? I'm just trying to sort of match up the scale of the dispute with the scale of the holdings?
I'm sorry, are you just trying to connect the area of the land and the area of the objects?
Well, the objects of dispute seem to be a very substantial, the objects of dispute with Obnova appear to be a very substantial area indeed. The surface area given on the Appendix 3 table on the left seems to be considerably less. I'm just wondering if there's anything to be made of that. Maybe I'm just misunderstanding what the relationship is between these two charts.
So, to be honest, I don't know how to read these hectares and other, these are square meters for the land, for example. So we have 4 hectares. Yes, yes, that's important point. It's much bigger.
Well, no, but actually it looks as if, I presume that M2, which is the right-hand column under the surface area, I presume that that is meters squared, isn't it?
It is 4 hectares, 23 hours. I don't know what is that
I don't know.
measure, and so we can calculate that for
Well, if you
Friday.
could, I mean, I'm only asking because you seem to say to us that there is an association between these two tables. One is as it were, the declaration of the parcel numbers 39 and 47,
That's right.
and the other one is the declaration of areas of dispute. But when you actually then look at the areas themselves, it doesn't look as if these correlate. So I'm not quite sure what to make of your assertion of the relationship between these two tables.
I'm not saying that there is correlation between these two charts. I'm saying that Luka Belgrade included in his financial statements parcels 47 and 39, and that for some objects, but you don't know which object that relates to, that Luka Belgrade says, okay, we have a dispute with Obnova related to some objects.
Right, so it's just the headline
And
point of a dispute with Obnova.
I'm not saying, and I'm not sure whether these 10 objects are actually the objects which are located in Dunajska Street or not. I'm not sure.
Thank you.
I'm still confused about how you relate these two documents. In one appendix is a list of construction land and objects that are temporarily remain in the company's possession until the land is required to be brought to the dedicated purpose. In accordance with the urban plan, go to 47, it says hectares 0, and it says 91 meters. And then 39 square meters. So what does it mean?
Well, as I said, these are some measures.
No, I understand that,
yes.
but why you are putting this document here? Why do you think this document? What evidence serves this document?
This document evidence that Luka Belgrade considered that it has the right of use over these two parcels.
Or 91 meters,
Not
or
9.
39.
No, it
That's
is
what I
not.
don't understand.
It is not. Yes, I am aware of that, but it is not 91 meters. This is not square meter. 91 is not square meter. That is some other measurement. 100, one R.
If I may just clarify, 1 R is the measure of 100 times 100 meters. So it will be 10,000 square meters.
10,000.
No, it's yeah.
Again, the numbers themselves are not the critical point. I think what both I and Ms. Janau are sort of focusing on is what precisely is the reason that you are drawing these two charts to our attention, and is there a relationship between the charts? Now, my understanding, Ms. Mihaj, from your response to my question, is that you are not, in fact, asserting that there is a relationship between these two charts. You are using the chart on the left-hand side under the heading Appendix 3 simply to show that there is a reference to parcel numbers 39 and 47, which you equate with the parcels of land in issue here. And quite separately, even if on the same page, the chart on the right-hand side, or the table on the right-hand side, is simply an explicit reference to Obnova. but that the reference to the Obnova 10 objects in dispute, it does not have any correlation necessarily with a reference to the parcels number 39 and 47.
Your understanding is correct. I'm not saying that Luka Beograd meant to say that there is correlation between this land on the left side and between these objects on the right side. I'm just saying that when appraising its capital in 1999, Luka Beograd took into account that it has the right of use over the parcel 47 and the parcel 39, and that it also, Luka Beograd, also took into account that there are some 10 objects over which Obnova and Luka has a dispute. So that's it.
So this is evidence, you are saying, that Luka Belgrade considered that it continued to have an interest in Obnova property, in the leasehold property, as late as 1999.
Not in Obnova property, but that it continued to believe that it regarded that actually Luka Beograd regarded it is the one who has the right of use over these parcels.
Okay, thank you.
Couple of things. You said that the document in the left shows that there was they have the right of use. That's what you said. I understood.
Right of use.
Right of use.
As a surrogate of ownership right.
Yeah. Where I can understand that from, because it says list of construction land and objects that temporarily remain in the company's possession until the land is required to be brought to a dedicated purpose and follows. So where here?
I will have to give you the page number for that later on. I will have to find it. I don't have it.
So it's not here. It's this.
No, this is, but it is also the part of the document that you will have to read to see that these charts are actually proving that Luka Beograd regarded these objects and these lands as a part of its real estate.
Okay.
It may be that we will want to come back to this in the Q&A session next week, because there will be questions, I suspect, about what is meant by the chapeau contracts with clients who fall under long-term lease regime. So you put some focus on this, and we're just trying to understand more precisely what the documents are.
Of course. So after this appraisal of Luka Beograd's capital in 2000, as I said, Obnova and Luka Beograd concluded 2 more lease agreements that related to both Dunavska 17, 19, and 23. And after that, 3 years later, and a few months before it's
I'm sorry, Ms. Mihaj, just to stop you there, as it's a convenient point. What is your response to claimants' contention that you are inappropriately inserting the word lease into these agreements, because these are the exact same agreements as the claimant was drawing to our attention in R12, R13, et cetera, and you are consistently with your case, consistently calling them lease agreements, and the claimants were saying they are not lease agreements, they were just agreements.
Well, I'm sure that when these agreements are read, the conclusion is that they are actually lease agreements. So this is why we are referring to them as the lease agreements, because we believe that they're all provisions contained in that agreements actually suggest that their purpose was for Luka Beograd to lease the land and the objects to Obnova.
So the absence of the word lease is, in your view, not material at all, the content of the agreements you say are lease agreements?
Of course not, especially having in mind that we have the provisions like the provision that relates to payment of the fee for the use of the space that is actually the rent.
Thank you.
I would just like to mention one more document, and that is financial statements of Obnova for 2002, where Obnova does not mention any land. So Obnova does not mention that it owes any land. As you can see, the value of the land is 0. Anyway, in 2003, a few months before.
Sorry, I'm sorry. Again, you're taking us to documents which are just going to stimulate more questions. So you pointed out the sort of 0 in the in the row which is under land, forests, and plantations. In the row that's headed buildings, it's not zero.
That's right.
I'm not sure what we are to make of that in 2002, before privatization, when there was still the differentiation between buildings and land.
Of course.
So could you explain a little further?
Yes, of course. I wanted just to mention also that Obnova said that it doesn't own any land. It has these financial statements, but for the objects, it designated some amount, but without specifying which objects that amount relates to. So we do not know which objects.
Okay, I understand that. I'm still not sure myself whether we can place the weight on that entry, lands, forests, and plantations, that you seem to want to give to it.
Well, if someone consider that it has some property rights over the land, then it would be expected that it includes those land in its financial statements as the property of the subject preparing the financial statements. So Obnova obviously considered, but my point is that Obnova in 2002, Obnova obviously considered and understood that it has no property rights over any land, including Dunavska Street.
And wouldn't it follow, and I don't wish to inadvertently mangle the claimant's case, but wouldn't it follow that if the claimants or Obnova considered that it had rights to buildings on the land, this differentiation between to use and of use, that it would itemize those in the row referencing building, but as this was pre-privatization, it wouldn't reference that in the row under ownership of land.
No, I would say that that is not actually correct understanding. The social enterprises who had right of use over the land before privatization, they would have included this land in the appraisal of its capital, just like Luka did, as we saw, and they would include that land in its financial statements. Why? Because it is clear that after privatization, the right of use over the land would have turned to the ownership after privatization. But that was something that actually was appraised.
This is something that we will get into in glorious detail with the experts next week, but thank you for that.
One more sentence. If the privatization subject does not include in its appraisal of capital, in its financial statements, some real estate that over which it should have right of use, that means that that subject doesn't think that it has that right, property right. Or otherwise, it would be included in financial statements appraisal of capital.
Do you think that will hold true as well with respect to buildings? So the fact that you included buildings means that you have right of use, so you understand you have right of use with respect to the buildings. What you just said is also applicable?
Yes, sure. And I will gladly come to that topic when in a few minutes, I will address the privatization program of Obnova, when we will see that Obnova mentions the objects, but it also have annotation in privatization program explaining what alleged rights it has over such objects. Just in a few minutes. Thank you. So in 2003, in March, Obnova for the first time, filed a request for inscription of the right of use over certain objects and the land on the parcel 47 and 39. And Obnova submitted 6 mentioned construction permits that allow construction of temporary objects. And after receiving this request, Cadastre tried to contact Obnova. We can see that from the report of the Cadastre. And eventually, Cadastre managed to get in touch with Obnova's general manager, who informed the Cadastre that Obnova did not possess appropriate documentation for the inscription it requested, This can be seen from the Cadaster's report from May 2003. And since Obnova had no appropriate documentation, its request for inscription could not be accepted, which actually Obnova obviously understood very clearly, as Obnova never raised any concerns in that regard to the Cadaster. On the contrary, in its privatization program, Obnova explicitly referred to the Cadaster's report in question. So now we are coming to the privatization program of Obnova. That privatization program was prepared by the subject of privatization. In our case, that is Obnova. And when we look in the privatization program and in documentation enclosed to it, you will see that it states that Obnova had no rights over any land. So Obnova again repeats that. This is third document where Obnova itself repeats that it has no right over any land. As for the object, now I will also answer to your question, Mr. Arbitrator. Obnova's privatization program contained a notation confirming that Obnova's rights over the objects were either temporary or unsupported by any documents. And there is another fact which is also, I will say, indicative, and that is that in September 2003, when 70% of Obnova shares were sold to Mr. Veličković, they were sold for the price which is a little over 35,000 euros. And not for the millions which are requested in this case. Shortly after its privatization, Obnova again concluded 2 lease agreements for Dunavska 17, 19, and 23. And then in November 2003, based on the agreement concluded with Luka Beograd in 75, the city of Belgrade was inscribed in the Cadaster as the holder of the right of use over the parcel 47 and 39 and the objects on these 2 parcels. Again, one important fact is that Obnova did not dispute this inscription, but Luka Beograd did. So Luka Beograd did dispute this inscription because Luka Beograd obviously thought that it has some rights over that real estate. However, it was unsuccessful in disputing this inscription. 2 years after the inscription of the city, in December 2005, Mr. Obradović became the owner of 70% of Obnova's shares. And shortly thereafter, Obnova concluded yet another 2 agreements in March 2006 for both Dunavska 17, 19, and 23. And in that way, Obnova, after privatization and after assignment of the privatization agreement to Mr. Obradović, confirmed its position as lessee.
Yeah, not for now, but at some point, if you can do so shortly, after we break today or otherwise next week, I would be grateful for just a brief explanation of what Exhibit R46 is, which you reference on your slide 31 as the privatization program. But I'm for myself not entirely sure what to make of the detail and where I should be looking. So perhaps you could just come back.
Sure.
Thank you.
I will just now turn to legal significance of the lease agreements. Of course, claimants are trying to downplay the significance of the fact that Obnova was concluding lease agreements for Dunavska plot. So they are stating that these agreements are pro forma, that Obnova was using Dunavska plots without paying the rent. And we disagree with that. And we provided a number of documents that shows that actually the rent was paid. So I will just go briefly through some of the documents because I'm out of the time. So we have documents proving that Luka Beograd initiated enforcement proceedings against Obnova for non-payment of rent already in 1964. You have that document on the slides. Then in December 2002, company Petco undertook to pay the outstanding rent that Obnova owed to Luka Beograd, confirming that there was some rent to be paid. And there were subsequent court proceedings that Petco initiated against Obnova, and there was financial expertise in that proceedings, and financial experts determined that both Obnova and Petco were paying the rent to Luka Beograd, and also Obnova's director at that time testified that Petco was paying the rent to Luka Beograd on behalf of Obnova. So we have a number of documents showing that the rent was paid, and finally, Luka Beograd initiated multiple court proceedings related to the enforcement of the rent from the 2006 lease agreements. I would also like to emphasize that the fact that Obnova had to pay the rent to Luka Beograd was even known to Obnova's workers, which actually shows that the lease agreements were important for Obnova's business. And after the privatization of Obnova, that was in January 2005, Obnova's workers wrote that Obnova, I quote, owes considerable funds to Luka Beograd, and it is only a matter of the day when the account will be blocked because we have not settled the lease liabilities. So in 2005, that was confirmed by the workers of Obnova how important it was to pay the rent, And this fact is the only true testimony regarding Obnova's rights over the Naska plots. It was given by Obnova employees who had direct knowledge of the relevant events, unlike other participants in this situation. So in addition, we can also look, for example, from Obnova's initiative from March 2008, where Obnova explicitly confirmed that it used parcels 47 and 39 for its business activity on the basis of lease agreements. It explicitly said so. We are using on the basis of the lease agreements. Why wouldn't Obnova said that it is the owner or the holder of the right of use? No, it says on the basis of the lease agreements. And when it comes to the subject of the lease agreements, that was also mentioned by claimants today. So they are saying that the lease agreements does not relate to what they call Obnova's premises. Importantly, they never said to which other premises the lease agreements then relates to, if not to the premises that are subject matter of this arbitration. And let me just, that is not on the slides, but this is also something interesting. That is R34, and that is submission filed in the enforcement proceeding that Luka Beograd initiated for the rent collection related to the lease agreements from 2006. And in that submission, Obnova argued the following, I quote, when it comes the defendant's legal predecessor, socially owned company Obnova Beograd has been situated on the location in question ever since liberation of Belgrade in 1945, and it has been using this space for almost 70 years without any impediment. In other words, in that enforcement proceedings against Luka Beograd, Obnova argued the same. That was in 2013, I think. So Obnova argued exactly the same what claimants are arguing in this arbitration for the premises. So from that submission, you can see that what was the subject of the lease agreements for 2006 is the same real estate that is the subject of this arbitration. And just one more thing, 11 out of 30 lease agreements that we have in files explicitly mention Dunavska 1719, Dunavska 23, parcel 47, parcel 39, or both. 11 out of 13 lease agreements.
Sorry, your document, which is not in your slides, but is on the record, R34. So this was an objection by the enforcement debtor. Who is the enforcement debtor?
Obnova.
So
Yeah, you can see that.
So where it
So-
says judgment debtor, that's the same as enforcement
Yes,
debtor.
yes, that's right.
And then you quoted us the paragraph over the page, furthermore, the defendant's
this
legal
is,
predecessor.
Just a second. This is a second page of PDF.
Yeah. And then you say.
Furthermore, the defendant's legal predecessor, socially unaccompanied Obnova Belgrade, has been.
Situated on the location in question ever since. So isn't this exactly the claimant's case?
Yes, that is. It is
Yeah.
claimant's case. What I'm saying is the following. The claimants are arguing that the agreements from 2006 do not relate to the real estate that is the subject matter of this arbitration. But in the enforcement proceedings, when the rent payments for 2006 agreements were actually the subject matter of the case, Obnova argued the same for the real estate that was the subject matter of the enforcement proceedings. What I'm saying is that the subject matter, the real estate that was the subject matter of the enforcement proceedings is the same as the real estate that is the subject matter of this case. And these are Dunavska plots.
And where is that said on this document?
Well, as you already noted, in the enforcement proceedings, and that is R34, Obnova is arguing the same as claimant is arguing for the real estates that are the subject matter of this arbitration. They are arguing that Obnova has been using this space for around almost 70 years. So this implies that what was the subject matter of the enforcement proceedings is the same land as in this case.
Okay, so I have it. In fact, it's in the fourth paragraph on the first page where it says the land recorded on cadastral parcel number 39 and number 47.
Yes.
So
sorry, yes, that's right.
that's the response.
Yeah.
Okay, thank you.
I will now explain shortly that constructing of temporary objects on the leased land was actually usual in socialist Yugoslavia. It was nothing fact specific about Obnova. So the regulation of construction from 1948 and 1952, which were applicable at the time when the construction permits were issued to Obnova, provided that construction cannot be initiated without the construction permit. So as from 1948, construction required construction permits, issues of a construction permits. And from 1952, the legislation also required preparation of different documents for the construction of temporary objects than in case of permanent objects. And you can see that from R36, that temporary construction objects, only the main design shall be prepared. And in Obnova's case, you will see, also for the documents that we exhibited, that Obnova prepared only main designs, meaning that Obnova knew and wanted to build only temporary objects. Importantly, construction permits for construction of temporary objects that were issued to Obnova was also issued to a number of other entities at that time in socialist Yugoslavia. And you have those other permits also on the record. So you can see that allowing construction of temporary objects with the obligation to demolish and remove the objects was nothing specific in Obnova's case. It was usual practice. And also Obnova obtained the same construction permits for construction of temporary objects for some other location in Herceg Stepana Street that Obnova was also leasing, same as Dunavska plots. It was usual practice. Of course, not only that was usual practice, but it was so frequently that Serbian courts frequently dealt with this type of construction permits. And I have something to explain here. We are not saying that these construction permits are temporary construction permits. We are not saying that. At that time, the legislation allowed that you issue construction permits. And in the construction permit, the authorities were able to determine whether they allowed construction of temporary objects or not. So we are not calling them temporary construction permits. It was just, construction permits. And now the legislation provides a difference between construction permits and temporary construction permits. We have also explained that in our rejoinder. I will now turn to the question of the rights arising from the construction of temporary and illegal objects. So when it comes to rights over temporary objects, we have a plenty of core practice and legal theories in our files, which confirms that temporary objects are regarded as movable property, and that the builder of temporary object does not have the ownership right over the object as a movable thing, but only the ownership right over the material. And we really have a number of examples of court judgments confirming that, but also legal theory. And
just the difference, if I understood correctly, with a temporary construction is that it's an expedited procedure. You have to present designs and that sort of thing. Is that correct? It's an easier permission to obtain.
Yes, that is why back then, in 50s, you had to prepare only main designs and not preliminary designs and some other documentation. Yes, that was the difference. Of course, today is probably the situation is different than that. Another important question is how the status of the object as temporary or permanent should be determined. And I know that claimants are saying that materials is important for the answer to that question, but it is not. And we also have a number of court decisions saying that that the duration of the objects depends only on the content of the construction permit. And finally, the destiny of the temporary object is more than clear. It is clear from the construction permits that Obnova obtained, that were obtained by other entities. It is clear from the court decisions and legal theory, these kind of objects have to be removed after requested so by the competent authority.
And just looking at these pages, your slides 57 and 58, and caveating my comments with an appreciation that this is a translation into English. The reference to, for example, the first quotation on slide 57, that is because the subject of transaction between the claimant and defendant was a temporary object, which by its nature is a movable object. Does that mean, as a first point, that a movable object is a temporary object, and an object that cannot be moved is not a temporary object?
No, that's not what that means. It means that the temporary objects are regarded as movable objects.
Does movable, excuse me, does movable here mean required to be removed?
No, that doesn't mean that.
So I interrupted your explanation. So
just in this very simple. The decision says, the same page says by its nature.
By its nature, that's right.
And I can understand that. So you are looking at the type of object. Looking at the type of object, you decide if it's movable or movable. That's not what nature refers.
No, that's not. That's not.
This was precisely the point that I was getting at, and it again goes back to the claimant's submissions about whether something is permanent or not. And the photographs that we were shown of bricks and mortar buildings, and I want to understand better how that falls into this explanation. Temporary object by which by its nature is a movable object. A bricks and mortar building is not by its nature a movable object unless the translation is not exactly accurate when it refers to a movable object, but rather an object which may be required to be removed. But I don't know what your explanation is. It may just be a translation point. I don't know.
I will have to see the Serbian version maybe, so to see if the translation is correct. That is,
This is your slides 57
yes,
and 58, which come back again and again to the word, a temporary object is movable property, and bricks and mortar does not immediately translate into
but just a second.
You can come back to it
Yes, please.
afterwards, because otherwise we're going to subvert your time too much.
Because I think that, for example, in that case as well, the object was not the object that could be moved from one place to another easily. Even in this case, R41. But it was regarded as temporary. So actually the courts are understand that the material used for the construction of the object is fully irrelevant. Only construction permit is what is relevant.
Well, I propose that you think about it further and come back to us with a
Yes,
fuller
sure.
explanation.
Okay. And let me say something briefly about rights over illegal objects. Same as temporary objects. The builder also only acquire ownership over the material. And as Professor Jotanovic and Ivanišević explained, since 1958, the sanction for the illegal construction of objects has been their demolition and removal. So that was the legislation. '64, that's right. Can I have just a second, please? Because I think that I'm out of time.
You may be out of time with your colleagues. You're not yet out of time with the tribunal.
Yes, I know. That's what I meant. I was allowed to say a few more sentences. So let me first say something about the rights over the land in Dunavska 1719. So claimant's explanation how Obnova allegedly obtained permanent right of use over the land is very confusing. And they first argued that the socialist authorities allocated the land to Obnova. And then they state that Obnova then obtained the construction permits, and then based on them, that Obnova obtained ownership rights over the objects. And finally, they argued that by means of constructing the objects, Obnova obtained permanent right of use over the land. So it seems that they are first saying that Obnova was allocated the land to construct the objects, and then that after constructing the objects, Obnova again gained some rights over the land. So it is confusing. I'm not following this line of argumentation. What really happened actually is much more simpler, and as we saw and as exhibits show, Obnova was leasing the land in Dunavska 1719, and based on that, it obtained the construction permit which allowed for construction of temporary objects. But it also obliged Obnova to remove these objects. And in addition to these objects, Obnova also in Dunavska 1719 on the leased land constructed some illegal objects, at least the claimant suggests so. However, Obnova is obliged to remove these objects as well. And so the answer to the question what rights could have Obnova acquired over the land it leases based on construction of temporary or legal objects is thus obvious, none. And that is confirmed by the court practice and legal theory. And when it comes to rights over the land in Dunavska 23, the claimants argued that Obnova acquired ownership on the basis of acquisitive prescription. However, Obnova would need good faith possession for that kind of acquisition. And Obnova does not have good faith possession because Obnova was always aware that it is only a lessee of the said land. And the fact that there is no lease agreements for Dunavska 23 between 61 and 2000, and that in that period, Obnova had good faith possession, cannot be accepted. Why? Because no passage of time can cure the fact that when he started using the land at Dunavska 23, Obnova was aware that he had no right of use over the land, and it was using the land as the lessee. And second, Obnova actually claimants never proved that Obnova was in possession of that land between 61 and 2000. And finally, Obnova also lacks another element of required for acquisitive prescription, and that is legality, the legal basis, and only legal basis that Obnova had for using the land in Dunavska Street are the lease agreements, and they cannot be appropriate legal basis for acquisitive prescription. That is also confirmed in the court practice. And finally, I will just briefly remember the tribunal that we had 3 court proceedings that related to the land and the objects in Dunavska 1719 and Dunavska 23, that in all those cases, Obnova's requests were rejected by the final decisions. And in these 4 decisions, you will see that the court accepted the stand that was already previously endorsed in court decisions related to some other objects, to some other entities, etc. So nothing extraordinary happened in these court proceedings and decisions. Just one more sentence, I'm sorry, just one more sentence, and with that I will finish. We should not forget there is also an injunction that actually claimants themselves noted that in the court proceedings related to the ownership rights over the land and the objects in Dunavska 1719, Obnova sought a temporary injunction to prohibit the city from disposal of the objects and succeeded with that request. So that is why Obnova is still allowed to still use the premises at Dunavska Street, and of course, initiation of this arbitration is also one of the reasons. Thank you. I have to.
Before you pass to your colleagues, I mean, first of all, this is not a question, but it's just a reference back to a point that I put to Claimants Counsel for comment in due course, and I do the same to you. It would be helpful, at least to me, to hear you in due course on what role the tribunal has with regard to decisions of the Serbian courts, in particular in circumstances in which the claimant's case is not a denial of justice. Okay, so it would be helpful to hear you on that. My second question, which I would be grateful for clarification, goes to the slide that is still on the screen on slide 79. And this is the injunctive relief, is it?
Yeah, that's it.
So a motion for ordering an interim measure filed by the plaintiff is adopted so that the defendants, the City of Belgrade and the Republic of Serbia, are prohibited from disposing of the facilities. Until when? Is that pending this arbitration,
yes.
or is that pending other things?
According to the law on enforcement. Sorry. So according to the law enforcement, the city is allowed to request that this decision is set aside because this proceeding is finally resolved. This case is finally resolved. So before Serbian courts.
Right. So this just to be clear, this injunction is directly linked to these arbitral proceedings.
No, this injunction was related to the court proceedings between Obnova and the city related to these premises.
Right, and where, at what stage are those court proceedings? Have they run their course, or do they still need to run their course?
All court proceedings are ended before the second instance court, so we have final judgments rejecting Obnova's requests. And I think that in all these proceedings, Obnova filed extraordinary legal remedy revision that is still to be decided.
And then from what you've just said, let me see if I understand correctly. If that final decision in due course goes in favor of the city, then this injunctive relief will either fall away because the merits issue has been decided, or the city will have to make an application for the lifting of the injunction.
We already have final court decisions in city's favor, rejecting Obnova's claims for establishing the rights over the land and the objects in Dunavska streets. So we have final court decisions. This injunction can be set aside upon city's requests because the case is finally resolved.
So the injunction, in fact, survives, at least formally, a decision in favor of the city, pending an application by the city for the relief of the injunction.
I will have to say that usually the injunction, the decision on injunction will contain the wording which will say that the injunction will stay at place until the case is finally resolved. However, this injunction does not have that kind of.
Okay,
that part of the
that's what I was
decision.
after. It was
Yes.
the ...
Yeah, that's right.
Thank you. Unless my colleagues have any questions, and subject to your guidance, if you would like to make a start on the jurisdictional points, I'd be happy for you to do so. You've probably got another 10, 15 minutes to run, seeing as we started a little late. If you would like to take the break early and start after the coffee break on jurisdiction, you're free to do that. I note that you are about a third of the way through your slides and half the way through your time. Why don't we start? Let's start, because it looks as if there's some preliminary points that you could usefully address now.
So members of the Supreme Tribunal, I will now, together with my colleague, Dr. Jeric, explain why the tribunal does not have jurisdiction to hear this dispute, and that's both under the Cyprus-Serbia BAT and the Canada-Serbia BAT. We'll go through a number of jurisdictional objections relatively briefly, and we'll probably do it even more briefly now in view of the time, but of course, please do let us know whether there's any particular points you have questions or you want us to focus on. We're very happy to do that. Before I will address our first specific objections, let us just briefly look at the alleged investors here. So the claimants want us to make believe that they are the investors, while all facts really indicate that the true investor is Mr. Rand, who controls the Cypriot claimants. Claimants have asserted from the outset that Mr. Rand is the ultimate beneficial owner of a 70% stake in Obnova. And the stake was allegedly acquired by Mr. Rand's former associate, Mr. Obradovic, in December 2005. Claimants also assert that Mr. Rand has full control over Obnova as well as the Cypriot claimants. And according to the Cypriot claimants, Mr. Obradovic acquired the shares on behalf of Mr. Rand. But there's no evidence on the record, nothing, on the financing of his investment and of Mr. Rand's arrangement with Mr. Obradovic. It is, to be quite frank, entirely unclear who actually invested in Serbia, how, and under which circumstances. Claimants say that the previous owner of the Obnova shares transferred his interest to Mr. Obradovic by means of an assignment of the original sales agreement for Obnova, which the previous owner had concluded with Serbia's privatization agency. But the assignment agreement makes no mention of any purchase price paid by Mr. Obradovic for the shares. See on the slide a summary of the restructuring that then took place later in April 2012. And under the 2012 deal, Kalemegdan acquired shares in Obnova, we heard that again today, from Mr. Obradovic, and Kalemegdan was also wholly owned by Mr. Obradovic at the time. Now, on the next slide, you can see the alleged investment structure of the claimants. They allege that as part of this 2012 restructuring, Coropi acquired a beneficial interest in Kalemegdan. They allege that a trust was established over Mr. Obradovic's shares in Kalemegdan, with Coropi acting as a beneficiary and Mr. Obradovic as the trustee. According to claimants, Coropi is controlled by Mr. Rand and beneficially owned by his 3 children via the Ahola family trust in Guernsey. All this really begs the question. I can go on for much longer time showing all the other means of control of Mr. Rand here in this structure. But it all really begs the question why Mr. Rand is not a claimant in these proceedings. The answer is patently obvious. As a Canadian national, Mr. Rand could not benefit from any investment treaty protection under the Canada-Serbia BAT, well, until the Canada-Serbia BAT entered into force in 2016, to be precise. And that's, of course, several years after the 2013 DRP was adopted, which claimants allege constitutes the main breach of their rights under the treaties here. This is just really for context, but I think it's important to keep that in mind when we go through the jurisdictional objections and when we'll hear the evidence in the course of these proceedings next week. I will now turn to the specific jurisdictional objections. I will first set out the reasons why there's no jurisdiction under the Cyprus-Serbia BAT. That's both ratione personae and ratione materiae. We'll take these 2 arguments in turn. So we'll start with Article 13b of the Cyprus-Serbia BAT, which you can see on the screen. That sets out the requirements for the Cypriot claimants that they must fulfill to qualify as an investor. As you can see highlighted on the slide, an investor must both be incorporated or constituted according to the laws and regulations of Cyprus and have its seat in the territory of Cyprus. Now, our submission is that the Cypriot claimants do not fulfill the second requirement. If you look at the text, it's quite clear that only the first requirement, so organized in accordance with the laws and regulations of one contracting party, that only applies to the first requirement, incorporated, constituted, otherwise duly organized. The second requirement, and that is the one of a seat in the territory of that contracting party, is not subject to any Cypriot law requirement. Therefore, it's our submission that the meaning of seat must be interpreted under public international law. And that's the exact approach that has been taken, for example, by the Orascom Tribunal. You can find the quote on the slide. I will not go to the details of that in the interest of time. The approach has also been consistently followed by other tribunals, and we've included some quotes here in the slides, but you will find more references in our submission. What's important is that the claimants actually do not contest Serbia's textual analysis of Article 13b of the Cyprus-Serbia BAT. Instead, they just rely on a single award, that's a mirror award, and argue that the tribunal should just follow the tribunal's conclusion that the term seat equals registered office as a matter of Cypriot law. But this is really misplaced. As we've just seen, the mirror's tribunal's interpretation goes against the express wording of Article 13b of the Cyprus-Serbia BAT, which very clearly shows that the parties did not wish to make the seat requirement dependent on national law. This is also confirmed by the object and purpose of the Cyprus-Serbia BAT, and we've put the preamble of the BAT there on the slide, but again, in the interest of time, I will skip this point and go straight to the meaning of seat in our submission as a matter of public international law. So the mirror tribunal looked at Cyprus law because there was, in their view, no uniformly accepted meaning of the corporate seat. But this is actually, at least as of today, not correct. And even if it were correct, the fact that there would not be a uniformly accepted meaning doesn't mean you can just skip public international law and look at Cypriot law. So many tribunals have looked at the meaning of seat in a public international law that includes Tenaris, the AMF decision that you can see on the slides, W investment cases. Again, you'll find more references in our submission, but there are a number of tribunals who have looked at that, and they all, at its core, come to the same conclusion. And this is that the term seat represents a substantive requirement. It's separate from incorporation, and it means the place of effective management. The claimant's argument here that we're trying to import an effective management requirement simply really does not hold. A seat requires the effective management of a company to be at the seat. It's about the territory here. That has been repeatedly confirmed in both the case law and scholarly literature. Again, we've put some examples on the slides here. There's more in our submission. Happy to answer any questions on that, but very, very brief. You can see here the Oxford handbook saying test of the seat requires something more. There's the UNCTAD summary of international investment law saying seat of a company connotes a place where effective management takes place. And there's much more out there in terms of writings and decisions. What you can also see, and again, I will not speak to that in detail, if you take a look at the other BATs that are out there, for example, the Albania-Cyprus BAT, the Yugoslavia-Belarus BAT, on the one hand, where it's a relatively simple, straightforward investor decision, no additional requirements. On the other hand, the Cyprus-Iran BAT, Cyprus-San Marino, other BATs that we've put on the record show there was a deliberate decision to require something extra, something in addition to incorporation, registration, and the like, and that's the seat in the relevant territory. So there's clearly an intention of the contracting parties.
This is akin to the genuine link principle, is it?
I think it could be a similar criterion, but I think seat has a meaning of its own. It's not genuine link. It might be fulfilled by the same facts at the end of the day, but I think it's a separate criterion, which you can find in a lot of treaties, and actually by now, quite a bit of case law on this explaining how tribunals look at that. Yes, I mean, on this basis, I think really it's our submission, it's for the Cypriot claimants now to show that they're effectively managed from Cyprus. And the key aspect here is the place of effective management. So the location of the person or the persons who actually decide and manage the business affairs of the relevant entity. So this is the test under PAL in Serbia's submission. Now, even if we were to look at Cyprus law, in our view, that does not change. And Serbia's Cypriot law expert, Mr. Ioannidis, has already confirmed that the terms of seat and registered office are not interchangeable as a matter of Cypriot law. Again, in the interest of time, and since he will be here next week to explain that in more detail, I would skip this point for now, just to make the point. It doesn't matter in Serbia's submission. Even if you were to look at Cyprus law here, the test would not matter. It's in the end, it's still effective management, even as a matter of Cypriot law. What is more important, what I want to look at together with the tribunal now is we turn to the facts. It's clear that the Cypriot claimants have not shown that they're effectively managed from Cyprus. To the contrary, the evidence submitted by the claimants show that it's actually Mr. Rand, one of the directors of Coropi, who is a resident of Canada, and then Mr. Makicevic, director of both Coropi and Kalemegdan, who also resides outside of Cyprus. In addition, claimants also concede that the business affairs of both Coropi and Kalemegdan were at all times controlled by Mr. Rand, again, a Canadian national, not residing in Cyprus. Serbia has, for purposes of this opening presentation, picked a few of the statements from the relevant submissions that you can see on the slide here. So this is all claimant submissions. You can see Coropi is fully controlled by Mr. Rand and so forth. In their reply, then, claimants furnished additional proof that Coropi and Kalemegdan were not effectively managed in Cyprus. Mr. Rand states in his witness statement, and I quote, "I provided oversight of my investment and made all material decisions." So what we see here, it's Mr. Rand, a Canadian national, who was the sole person exercising effective management over Coropi and Kalemegdan. As the tribunal will see, this is also confirmed by Mr. Broshko, and that means that Coropi's and Kalemegdan's place of effective management is clearly not in Cyprus. So in their rejoinder on jurisdiction, then claimants have asserted for the first time that the effective management would follow from the fact that there's some reports that have been filed in Cyprus, and formally some directors' meetings are taking place in Cyprus. Again, this does not matter under the test. The question is, who is actually making the decisions? Who is calling the shots at the company? Who is effectively managing the business affairs of the company? And by claimant's own account, The person who was making all of the decisions regarding the Cypriot claimants was at all times Mr. Rand. With this, I will now turn to lack of jurisdiction, ratione materia. And it's our submission that the Cypriot claimants do not have a protected
I'm
investment.
sorry, Mr. Kelly, may I
Of
just
course.
put down a marker, and I'm not at all sure in my own mind that this is relevant, but I had in the back of my mind, just from sort of public recollection, that in the case Philip Morris against Australia, that there was an issue about Philip Morris being seated in Hong Kong. Now, I see you have on the record RL 122. You've got that down as the 17th of December 2005. Apologies, because I could have searched this up myself. I'm not quite sure whether that is the reference to the Philip Morris Australia jurisdictional decision that's on the PCA website. I think it's, in fact, there's an error that should be 2015. So it may just be something to be corrected in the electronic record. But I would be grateful at some point to hear from you briefly, it'll be next week now, on the relevance, if at all, of this award. And I'm assuming that it is relevant because you have referenced it.
Okay.
Thank you.
Of course, I know it's in the interest of time, continue for now.
Sure.
We'll come back
Yeah,
to this point.
next week.
Yes, jurisdiction, ratione materia. So the Cypriot claimants do not have a protected investment, and that's both under the Cyprus-Serbia BAT and Article 25 of the ICSID Convention. So we're taking a look at Article 1.1 of the relevant treaty here. And as you can see on the slide, Article 1.1 says an investment is every kind of asset invested by an investor of one contracting party in the territory of the other contracting party. And there's a similar wording that can be found in the investor clause, which refers to the investor making an investment in the territory of Cyprus. And for an asset to be invested, it's clear that there needs to be a positive act of investment. Again, put some sources on the record and through examples here on the slide. So it's a Komaksavia Airport in the Tokyo's case, which have confirmed the same notion for similar terms and treaties. Had it been the intention of the contracting parties, which is contrary here, to protect passive share ownership, they could have expressed that by adopting different treaty language such as owned rather than investment. This is also underlined by the fact that in addition to being invested in some form, in some way, by some positive act, an asset must be invested in the territory of Serbia. So there's clearly a requirement of showing some nexus, some act directed towards Serbia. And neither Kalemegdan nor Coropi satisfy these conditions. And that's relatively simple. There's no evidence that Kalemegdan undertook any positive act of investing in return for acquiring the Obnova shares from Mr. Obradovic. There's no evidence that has been tendered to establish that money or any in-kind contribution was ever paid for these shares, whether by Mr. Rand or by Mr. Obradovic. Kalemegdan's alleged contribution, the means of a share swap, does not remedy this. And in the absence of any consideration, there's simply no investment. This does not even change, would not even change if the funds for the original acquisition in 2005 came from Mr. Rand, but that has neither been established or let alone been pleaded by claimants here. Because any alleged contribution by Mr. Rand is not attributable to Kalemegdan, which is a separate legal entity.
Do we have any information about Kalemegdan in terms of whether or not it has any other activities apart from holding shares?
We don't, but I think that would be probably a question for
Or
claimants.
for the claimant, I know. But I'm just wondering if there's anything on the record that would establish the value of the shares.
I think there may have been a reference in the share swap document, but I think that would be for claimants to substantiate.
I mean, perhaps as it's a relevant point, the claimants could at least take note of that and come back to that next week, because it is something that interests us.
Apologies. In any event, claimants' argument here that share ownership through a passive share ownership through a corporate restructuring is sufficient to establish investment under the BAT fails. As noted by the tribunal in Kalemegdan, share ownership does not suffice in unusual circumstances based on particular facts. So non-transparent, non-arm's length transactions, such as the ones considered in both the KT Asia and the Kalemegdan decision referenced here on the slide, have elicited very close scrutiny. The tribunal in KT Asia was especially careful to distinguish the internal restructuring at hand from other normal, straightforward investment cases, noting that the ultimate beneficial owner's alleged contribution was not sufficiently linked to the claimant investors. And we're saying here too, to use the words from the Kalemegdan airport case, here too, the circumstances in which Kalemegdan invested are murky, and they stand in contrast to more commonplace share acquisitions through corporate structure. Coropi, turning to Coropi, which claimants allege is the beneficial owner of Kalemegdan, has also not shown any investment within the meaning of Article 1.1. That's for three reasons. First, Coropi did not acquire a beneficial interest in Obnova. Claimants allege that Coropi has been the beneficial owner of the Cypriot shares since April 2012. But as will be explained by Mr. Ioannidis, the evidence which they rely on, that's the two trust deeds and the letter of instruction, they raise more questions than they resolve. None of the documents prove that Coropi had or acquired a beneficial interest in Kalemegdan or Obnova. The trust deeds do not create a beneficial interest on the part of Coropi. And the letter of instructions, interestingly enough, was neither authorized nor acknowledged by the actual shareholder, Mr. Obradovic. Claimant's account of Coropi's alleged acquisition is also quite inconsistent. Despite having amended their account in this arbitration now several times, claimants still have not provided any clear evidence of how and when Coropi acquired its alleged beneficial interest in Kalemegdan. So claimant initially alleged, and you can see that on the slide, that's a quote directly from the RFA, that based on this trust deed, Coropi became the 100% beneficial owner of Kalemegdan. In the reply, they now assert that the trust was established orally and not through any written document upon Kalemegdan's incorporation. Notably silent in all of this, that's quite interesting, is Mr. Obradovic, the owner of Kalemegdan until the end of 2023. So when taken together, all these circumstances are clearly not convincing. There's no beneficial interest of Coropi. Second point is that even if there were some sort of beneficial interest, this would not be a recognized investment under Serbian law, because Serbian law does not recognize beneficial ownership of shares, particularly for the purpose of conferring or enforcing property rights. And leaving all of that aside, the third point is there's also no clear contemporaneous evidence that Coropi made a positive act of investing in the territory of Serbia. Until claimants rejoined on jurisdiction, the only supposed evidence was a reference in the trust deeds to consideration paid for Coropi's beneficial interest. Mr. Broshko now claims he paid a nominal consideration to Mr. Obradovic on Coropi's behalf in exchange for its beneficial interest in Kalemegdan. But the account is unconvincing. The timing is really curious, to say the least, as is the lack of contemporaneous evidence for this payment. Claimant's insistence that there's nothing unusual all about this is particularly unconvincing, as in December 2023, midway through this arbitration, Mr. Obradovic then suddenly transferred his shares to Coropi. But this is really too little, too late. You look like you want to ask a question.
No, I'm just anticipating that you are going to move on to a new topic, which is investment must be proven under Article 25. And if so, I think it's time that we did actually take a break, but I don't want to cut you off if you've got some last submissions on.
No, you're spot on. I have a few more sentences and then we can move on and go to the break. So still on the treaty, just to finish this point, as with Kalemegdan, claimants have in any event not shown any positive act of investing. So they have said that Coropi was involved in the day-to-day management of Obnova through the work of their directors, Mr. Broshko and Mr. Markicevic, which is really unconvincing, as they're both paid advisors or consultants of Rand Investments. And the only other positive act that we've seen being alleged was Mr. Rand's involvement in Obnova's management, of which we have seen little, if any, details or description of what actually happened. We say this is really just not enough for a proper investment. And with that, I think we can go to have a coffee.
Thank you. And I'm not sure how much time you will spend on the topic of Article 25 of the ICSID Convention. As I did with the claimants, I would invite you, and this may be an appropriate point, but just to indicate what respondents' view is of the decision in the RAND investments case against Serbia, which I appreciate was under the Canada-Serbia bit, but there is a big section in there on the analysis of Article 25. So that may short circuit some of your discussion. But I think with that, just looking at my colleagues to see whether there are any questions, then let's take a break now. And I suggest that we reconvene, as we're running a little bit behind time, that we reconvene at 20 to the hour. Okay, so that's a 22-minute break. Do you need a little bit more? You don't have to go so far to get your caffeine. Yep, 20 to the hour. Okay, thank you.
Still same on the VC.
So it's not sharing.
No.
Okay, I will go to laptop 2.
Cover. Okay.
Check 1, 2, 1, 2, 3.
That one is laptop 5 on that corner. Our corner is laptop 2. It's black, but everywhere, even on their screens.
And you routed laptop 2.
That's correct. Thumb out up if you go to laptop 5 or you're back to laptop 4. Is it 5 or okay? Still black everywhere.
Are you on return B? You should be on return B.
Yep.
It's all on me.
But
I forgot to plug the HDMI to the laptop. That's why. So let me go back to laptop 2 again.
okay. Okay, still the same issue.
It's not going to happen today, unfortunately. It would be too disruptive to your meeting. Then it's, did you put laptop 2 to data VC1?
Correct. No change.
Okay.
Would you leave it on 2 setup or return to 4?
We can return to 4, but let's test 4 before I come back.
Witness.
Okay, are we ready to make a start?
Whenever you're ready.
Should we make a start? So, Mr. Keller, just to say that with the addition of the extra 10 minutes that claimants have the benefit of, you have about an hour, 30 minutes, an hour and a half to go. Okay. So is it Mr. Keller? Yes. Yeah, you still.
I'll
To
continue.
say the reorganization of the seating is a bit confusing.
It's all betting on. Okay, no, I mean, as indicated before the break, I will now address the lack of investment under Article 25 of the ICSID Convention. And again, I'll be very brief, but very happy to answer any questions that the tribunal might want to ask. So Article 25, of course, as we all know, says that it restricts jurisdiction of ICSID to disputes arising directly out of an investment. So we've already set out the elements, hallmark criteria, however you want to call it, in these submissions. Don't want to go through that in detail. So the interesting elements here are contribution of resources and an assumption of risk, because both of these requirements are not met in respect of the Cypriot claims. And the reasons for this are very similar to the ones that I just looked at together with you for the test under the treaty. So Kalemegdan's passive ownership of shares falls short of these requirements because there's no evidence of any transfer or payment of consideration for the Obnova shares. They've also not established, the claimants, that there's any contribution that Kalemegdan made later. They claim that Kalemegdan made a contribution through its participation in the management of Obnova, but again, this is contradicted by the testimony of Mr. Rand, who insisted it was always him who has controlled Obnova in all circumstances and at all times. So Kalemegdan's acquisition does also not satisfy the criterion of risk, because the only risk that Kalemegdan might face as the owner of the Obnova shares is a risk of the loss of the value of these shares. But if there's no consideration, the inherent risk of a reduction in value of the shares does also not satisfy the risk criterion. And Coropi has also not satisfied the requirements of contribution and assumption of risk. Again, the record does not substantiate Coropi's alleged acquisition of an indirect interest in Obnova, let alone that Coropi ever made any contribution. The reference in the trust deed to consideration given, corroborated only and late in the day by Mr. Broshko, with an amount of 10 euros in dinar equivalent, is insufficient. If there's no contribution in relation to the alleged investment, there can also logically not be any finding of any assumption of risk. As I said, I will be brief. So this concludes my submissions on Article 25, and I will now move on to Article 1 and 2A of the BAT.
Before you do, I did invite you just before the break to give us the benefit of your views on the analysis of the Rand investment case on exactly this issue.
Yes, no, I think, I mean, our suggestion would be that we'll take this all together next week, Friday on Rand, because there might be other issues, I suspect, where questions in relation to the Rand decision might come up.
Okay.
Yes, Article 1 and 2A of the BAT. So that's another reason why the tribunal does not have jurisdiction over the current dispute. You can see those on the screen. So that is the express legality clause that you can find in the Cyprus-Serbia BAT, requiring investments to comply with host state law, as shown here with the quote of Article 1.1. So as a result, this tribunal is only empowered to hear any claims if the alleged investments are made in compliance with Serbian law. There's, of course, a lot of commentary and case law supporting that proposition, addressing similar situations. And again, as you can see on the slide, we put up something by Professor Schroer, who confirms, the leading commentary by Professor Schroer confirming that legality clause limits the host state's consent to compliant investment. Same has been echoed by Professor Kriebmauer and many others.
Can I just ask for a very small point of clarification? CL007 and CL007A are exactly the same document, are they? Or are there translation differences or other things like that? Because I've been working off 007. You are here quoting us 007A, just to make sure that I'm not looking at the wrong exhibit.
Well, it's the claimant's exhibit, so I don't want to speak out of turn. But I mean, I've always used the A version, assuming that there was some issue with the underlying version 7.
Can claimants clarify? I mean, I just presumed that the one was retyped and the other one was.
The correct exhibit is the one with A. It's a corrected translation.
Corrected translation, so 007, which is a retyped version, we should not be using.
We submit the correct version is the one filed under 007A.
Okay, thank you, that's helpful.
Thank you. So there's an express legality clause, and the Cypriot claimants here have not complied with Serbian law, as they have failed to make a takeover bid when Kalemegdan acquired the Obnovo shares in 2012, and that was contrary to the 2012 law on takeover. Article 6, which you can see on the slide, provides that they reach a certain threshold, the person making the acquisition must launch a takeover bid. And Kalemegdan's acquisition of roughly 70% of the voting shares clearly triggered an obligation to launch a takeover bid. This obligation would also extend to any person acting in concert with the acquirer or with the acquirers. And there's no dispute here in relation to the 2012 acquisition that Kalemegdan acted in concert with Mr. Rand, acted in concert with Coropi and Mr. Obradovic. So that means both Coropi and Mr. Rand were also obligated to launch a takeover bid. But like Kalemegdan, they did not do so. So claimant's expert, Mr. Kushinin, denies that these persons breached the law by failing to make the takeover bid. Their reasoning really betrays common sense. It rests on the unsupported assumption that they were entitled to rely on an opinion from the Securities and Exchange Commission from 2007, which said that there was no takeover bid required, where the transfer or acquisition of shares between these persons did not result in a change of control. You'll hear from Professor Lepetic, this Kushinin reasoning cannot be accepted. It's very simply because the reliance on a 2007 opinion after the law was amended in 2012 is wrong as a matter of Serbian law. So the provisions of the 2012 law takeover, which you can see on the slide here, are crystal clear as to when an acquirer is exempted from launching a takeover bid. So the new exemption that exists is limited to acquisitions among parties acting in concert only if a takeover bid has previously been made. And since this is not the case here, there was never a takeover bid, the exemption does not apply. There are also some arguments about the breach being non-fundamental. Again, in the interest of time, I will move on. Very happy to answer any questions that the tribunal may have. This means we would move to the second treaty, the Canada-Serbia BAT, and I will now explain why there's no jurisdiction whatsoever in materia under the Canada-Serbia BAT as well. The first issue, of course, again, is a legality issue. Canada-Serbia BAT does not contain an express legality requirement, but it's our submission that this is a well-established principle in international law. The tribunal has no jurisdiction over an investment that was made in violation of the host state's law. Again, there's plenty of case law and academic writing, which we addressed in our submissions, which I would not address in detail in today's opening statements. So looking at the facts, we're now looking at Mr. Broshko's acquisition. It was also made in breach of Serbian law, as again, he also did not issue a takeover bid. As Professor Lepetic has shown and will also testify to at this hearing, Mr. Broshko acted in concert with Kalemegdan, Coropi, and Mr. Rand when he acquired his 10% indirect shareholding in Obnova. As Mr. Broshko's and Kalemegdan's combined shareholding exceeds 75% of the voting shares, this acquisition also triggers the obligation to make a takeover bid under Article 6 of the law on takeover. Claimants deny here that Mr. Broshko acted in concert with the Cypriot claimants, but it's clear from the provisions of the law on takeover that they actually did act in concert. As Professor Lepetic will explain, Mr. Broshko's affiliation with Mr. Rand Investments, and the Cypriot claimants give rise to at least 3 irrebuttable legal presumptions under Serbian law that he acted in concert with them. Late in this arbitration, claimants have now amended their presentation of the facts to escape this conclusion. Despite their repeated statements to the contrary, they now insist that Mr. Broshko was never the managing director of Rand Investments, but merely an independent contractor. Even if this were true, it does not change the outcome, because the law on takeover provides that the Commission, the SEC, may take into account other circumstances to determine whether persons are acting in concert. And these circumstances are here a long-standing coordination and cooperation with Mr. Rand and the Cypriot claimants, supervising Mr. Rand's investment in Serbia, including Obnova, since the time of Kalemegdan's acquisition, always carrying out Mr. Rand's instructions, and also acquiring other shares in other investments of Mr. Rand and Kalemegdan Serbian investments in 2017. So all these circumstances, we say, speak from themselves, irrespective of a formal function of Mr. Broshko as managing director. Mr. Broshko and Mr. Rand have been working together, have been coordinating their efforts, which triggers the takeover bid obligation under Serbian law. Moving forward to yet more reasons why this tribunal does not have jurisdiction. Now, looking at jurisdiction ratione voluntatis in relation to Mr. Broshko, and that's Article 24(1)(a) of the Canada-Serbia VAT. As you can see on the screen, Serbia's consent to arbitrate with Canadian nationals, set out in Article 24(1)(a). You can see that Mr. Broshko is required to comply with the conditions precedent in Article 22. We failed to do so. Article 22(2)(e), II, and F(ii) of the Serbia-Canada VAT stipulate that whereas an investor brings a claim that concerns damages to a local enterprise, a waiver must be given by the local enterprise. And that waiver needs to broadly cover all local remedies, needs to include a waiver of the right to initiate proceedings in the future as well. And only where such a waiver is given, where the condition precedent to access arbitration under the VAT is satisfied, the tribunal can actually exercise jurisdiction. The waiver in the current case operates subject to a very narrow exception, which is not triggered. And it's undisputed here on the factual side of things that Mr. Broshko did not submit a waiver on behalf of Obnova. The waivers issued by Mr. Broshko and MLI, but not by Obnova, have no relevance in this context. And the reason for that is that the purpose of the waiver requirement is, of course, to avoid double recovery in parallel proceedings. But if Mr. Broshko were to be permitted here to bring a claim concerning Obnova's losses, but Obnova had not provided the required waiver, Obnova could still go on and bring claims for the same harm in local proceedings. And that's exactly the scenario that Article 2 of the Canada-Serbia VAT wants to prevent. Sure.
Just now, so you're thinking in terms of policy, right? So you don't have the control, don't have the consent of the controller. That effectively means you cannot file a claim. That's your position. Even if you haven't started any parallel proceedings.
Yes, I think that's very much the concept of this provision and similar provisions in treaties. They're meant to avoid the risk of parallel proceedings. They're meant to avoid the risk of double recovery.
So you don't see the necessary relationship. That would make sense when there is a control, so you can effectively decide to start parallel proceedings or decide, or you can provide a waiver. What I'm saying is, there is this legal concept that if you cannot be obliged to do the impossible.
I understand that, but I think this would be a limitation. I think that comes with the minority shareholding that they require, of course, and I think that's would potentially be the downside that you have to accept in that situation. As you know, the treaty does have an exception where the loss of control is triggered by the state, but this is not the case here. So I think it has been considered.
Okay, thank you.
My final point, yet another reason why there's no jurisdiction of this tribunal under the Canada-Serbia BAT. So that's Article 22(2)(e)(1) and F1 of the Canada-Serbia BAT. That's a separate standalone reason. That's a 3-year limitation period set out in these treaty provisions, which you can see on the slide. So our case here is really, really simple. As my colleague, Dr. Cevic, will also elaborate in more detail in the context of Serbia's abuse of process objection. I will be very brief here. So what the BAT requires, again, as a condition for the submission of claims in arbitration, that these claims are brought within 3 years of the investor gaining knowledge of the alleged breach and related harm. Mr. Broshko submitted his claims on 27 April 2022, so we have a cutoff date here of 27 April 2019. But he was, of course, aware much earlier. He alleges that his claims are based on the 2021 letter denying Obnova compensation, but that letter cannot be looked at in isolation. It's clearly, closely, intrinsically linked to 2 events which occurred several years prior, and that's the 2003 registration and, of course, the 2013 DRP. So the letter refusing compensation is grounded in, justified by the 2003 registration, and the 2013 DRP, of course, in the claimant's case, is their alleged breach, which actually triggered any potential obligation or request for compensation. And by his own admission, Mr. Broshko was well informed of the consequences of these events as early as in 2017, if not even earlier, as one of the persons supervising the investment in Serbia. And as a result, that's yet another condition for Serbia's consent to arbitrate Mr. Broshko's claim. Does not. With that, we're not finished with jurisdiction. I would hand over to Dr. Cevic, unless you have a question on these points.
No, again, it's just a marker and a reminder I put to claimants' counsel that I would be interested to hear anything that they might have to say on the case that both parties have submitted, which is Berkowitz against Costa Rica for respondent, it's RL 111. I think respondent in particular makes something of aspects of that. As I noted, I was presiding in that case, so I'm interested to hear your views if you have any on that. Thank you.
Thank you, Mr. President. I will have to cover a lot of stuff. Azione temporis objection, indivisibility objection, and finally expropriation claim. So please bear with me. First, ratione temporis. I will primarily discuss the matter under the Cyprus-Serbia BAT, but most of our arguments also apply to the Canada-Serbia BAT. And we should start with certain key events that took place before the Cyprus BAT entered into force. You're already familiar with them. One is the request of Obnova from March 2003, asking the cadastre to register its right of use over 16 objects in Dunavska 17 to 19 and 1 object in Dunavska 23. And from Obnova's privatization program, we learn that cadastre had a negative approach or negative determination about this request. And obviously, since Obnova published in its privatization program what the cadastre said, Obnova was informed about it. In November 2003, a little bit later, now already privately owned Obnova again approached another state authority, that's the municipality, asking for so-called legalization of its certain objects. And these requests were also denied on 26 November 2004. Claimants argued that they were never informed about the authority's decision, but exhibits are 110 and C317, which are contemporaneous or about that time, about 2003 and 2004, they show that indeed Obnova was informed about the decision. And finally, obviously, there is the November 2003 registration of the city of Belgrade as the holder of the right of use over the land and objects on both lots. And these decisions became final in May 2004. So as we can see, there were two administrative proceedings initiated by Obnova, asking that its right of use over the Dunavska objects be recognized by the authorities, and they were denied. And then we have this decision of the cadastre inscribing the city of Belgrade, which was publicly available, where actually this whole claim of Obnova was again rebuffed. And as you know, the Cyprus-Serbia BAT entered into force at the end of 2005. So these are the relevant facts for our ratione temporis objection. It has several aspects, and you can see them on the screen.
Sorry, Mr. Judge, just before you move to that, you referenced in your comments now exhibits the way that the court report has got them as R10 and C137.
Yes.
Those don't feature in your slides. You might just please, in due course, have a look at the transcript to make sure that you've got the correct
I think, yeah, thank you very much. Yeah, and sorry for not having them on the slide. Let me then go on to the question of retroactive application of the dispute resolution clauses in both BITs. And this objection itself has two aspects, at least under the Serbia Cyprus BIT. But there is one common aspect with the Canada BAT, and that is the question of the retroactivity of the dispute resolution clause itself. And I think it's not contentious between the parties that the dispute resolution clauses do not apply to disputes which had arisen before the BITs entered into force. However, the point of contention is whether or not the present dispute arose already in 2003, 2004. Moving on to the definition of dispute in international law, which is there for the record, it's well known from Avramati's case. We consider that all its requirements have been met by the events of 2003, 2004. We think that Obnova and respondents' authorities clearly had, quote, a disagreement on a point of law, which concerned Obnova's property rights. As I said, Obnova's property claims were denied in two administrative proceedings. And at the same time, City of Belgrade was inscribed as the holder of the right of use. And this position was also communicated to Obnova. As I said, we learn about the cadastre position, for example, from the Obnova privatization program, which was prepared by the Obnova itself, by its management. And obviously, the 2003 registration was publicly available in the cadastre. So we think that there was a clear evidence that there was, quote, stated disagreement between the parties. Now, claimants' protestations to the contrary are without merit. For example, they claim that the 2003 registration did not constitute an expression of Serbia's view on the legal status of Obnova's premises, because they say the cadastre website now, at the present time, states that the process of registration is a technical and not a legal one. Now, this only means that the cadastre is not deciding, adjudicating the property claims, but it is certainly deciding, it is certainly recording the property claims. And in that way, the registration of a property claim is an expression of the view about the property claim.
Is that correct? Or would it rather be formulated as the registration of a property claim by the cadastre is an an indication that the claim is prima facie sound and is not contested?
You could say so, but I would just remind you that this present announcement of the cadastre website is existing at the present time. But as we know, the 2003 registration of the city of Belgrade was the result of contentious administrative proceedings in which the Luka Belgrade also participated, and Luka Belgrade appealed the first instant decision, etc., etc. So the whole legal setting, I think, at that time was different.
So in this instance, the registration, in fact, followed a contested claim for registration.
Yes,
Thank
yes.
you.
And obviously, in the two administrative proceedings that were initiated by Obnova itself, it's clearly that the relevant authority acted in a manner that decided about the claim, refusing or denying the claim.
Thank you.
Now, going to the question of the existence of dispute, there is also a question of the identity of the present dispute and the dispute in 2003, 2004. And predictably, claimants argue that these are not the same disputes, and they rely on the so-called triple identity test that we know from the questions of res judicata and lis pendens. And they relied on one case, Railroad Development Corporation of Guatemala, where the tribunal stated that it found guidance in the jurisprudence or practice related to lis pendens. But in that case, and that is the only, by the way, case that they are evoking in this context, in that case, that same tribunal proceeded with the analysis that was not strict and formal at all in its application of the triple identity test. It, for example, was looking at whether the elements of the dispute in local proceedings overlapped with the elements of the dispute in the international proceeding or dispute before the tribunal, and found that they did not. So, in contrast to that, in our case, the fundamental issue, the existence of Obnova's property entitlements, is common both to the 2003 to the 2004 disputes and to the present dispute.
Can I just ask, it's a big picture question, but you're characterizing the dispute as relating exclusively to the property entitlements. Isn't it open to the claimant to say, look, we're bringing a claim for expropriation in 2013 based on the DRP? And I think it's accepted that immediately before that event, we have to assess what the property rights in fact were. But why is it retroactively applying the treaty to judge whether or not there was an expropriation in 2013? I mean, either it's a good claim or it's a bad claim. If it's a bad claim, it may be because there were no property rights. But how does that involve applying the treaty retroactively?
Well, in order to decide whether there are property rights, you will need to go back to 2003 and 2004 and reassess the decisions of the Serbian authorities that I just mentioned. So we'll have to go back and actually adjudicate the property claim and say, well, for example.
But just to be clear, it's not for us, it's not a property claim per se. It's a claim for a breach of the treaty. Undeniably, the property aspects are an important part, prerequisite to deciding the international claim, but it's not the claim itself. And I think it's quite a powerful argument that provisions like Article 12 that says it applies to investments prior to the treaty entering force, wouldn't that type of provision be rendered naught if it was simply good enough for a respondent state to say, well, we contest the fact that you have an investment, therefore you're going to have to decide things that existed prior to the treaty coming into force?
Well, there are two actual answers to that, or 2 points that you were making, and let me address the first one, and the second one I'll address later. I would say that you cannot decide about the expropriation claim, or to put it the other way, the expropriation claim itself presupposes a claim for a property right, and then that property right was taken, so the claimant is asking for compensation or restitution or whatever. So I don't see how one can actually divorce a property claim, expropriation claim from a property claim. So in that sense, the claim for property 2003 is an inherent part of the expropriation claim in 2024. So that's one part of the question. Another part of the question concerns the, if I understood it well, Article 12 of the Cyprus-Serbia BIT and the past investments and whether the treaty applies to that. I will come back to that in a second, if I may.
Can I though just follow on the question, and you can come back to it in a second as well. Even if we take your response on the first part of the question, I mean, there's a reasonably authoritative body of jurisprudence now on the issue of ancillary issues. So a court may have jurisdiction, a court of tribunal may have jurisdiction in respect of a particular point, but that does not preclude it addressing points that are not, as it were, presumptively within its jurisdiction, but are ancillary to the decision within its jurisdiction. So why, even if we take your point, why would not this tribunal, if it has jurisdiction to address the later issues, not also be able to address the earlier issues insofar as addressing the earlier issues were necessary for us to be able to address the later issues?
Well, I have to say it's a complicated question, but there is this sort of, there are two extreme points. One is just taking into consideration the issues that are outside the temporal jurisdiction in order to decide whatever. And this is especially so with regard to continuing violations, for example, because then you will just take into account what happened before, but you will decide what is going on what is going on now. And then on the other side of this spectrum is the mode or the theme that I will come back to, and that is what is really the source of disputes. And I think that in that sense, if a matter or situation that is outside the temporal jurisdiction is a source of the present dispute, then the tribunal would not be able or should not be able to address it. And that is the point of all this jurisprudence about the sources of dispute that I will discuss a little bit later.
Well, again, something for you to come back to later, but it seems to me that the issue is not quite so clear-cut because there is, quite a lot of developing jurisprudence, some of which you have quoted, which does not accept, for example, the continuing violation theory, but nonetheless does accept that a tribunal that has temporal jurisdiction is not precluded from looking at pre-temporal events. And I see, for example, that you have cited at RL 161 the Mondev decision, which my recollection is that actually addressed that head-on. Once again, these issues are all addressed in the Berkowitz decision, which I referenced earlier. So again, I don't invite you to address this now, but I do invite you to think about it further and come back to us on it.
Okay. Thank you. Now, actually coming back to the question of the identity of disputes, we propose that much better and less formal test was adopted in Lucchetti, Peru, and several other tribunals, and they follow what Lucchetti had to say about this, and quote, which was whether or not the facts or considerations that gave rise to earlier dispute continued to be central to the latter dispute. That is the line that they adopted. And we submitted both the 2003-2004 dispute and the present one that raised that central issue of the existence of property entitlements. So both disputes, again, to use the words of the Lucchetti, have the same origin and source. Now, similar situation we had in Jan de Nul case, and that is something that claimants invoked in their latest submission on jurisdiction, and I'm going to address it now because we haven't had the chance to respond. And what they say is that in Jan de Nul, the tribunal found that the intervention in the case of a new actor was a decisive factor to determine that there was a new dispute. And the new factor was this Ismailia court that was deciding about the contract in that case. And it acted after the relevant, the critical moment for the jurisdiction of the court. However, in Jan de Nul, the gist of that pronouncement was that the court was a new actor because its conduct did not coincide with the earlier impunged conduct. So it was different, the conduct of that court. And this is different from what we have in our case, where it's all about and exclusively about the property entitlements. It's not about denial of justice or something similar. It's about property entitlements and their existence or non-existence, appropriation, etc. And now, if I may, I would go on to the second aspect of the dispute resolution objection, and that concerns the particular dispute resolution clause in Cyprus-Serbia BAT. The treaty contains a further restriction, according to our view, because its Article 12 provides that, quote, the provisions of the agreement shall only apply to matters occurring after the entry into force of the present agreement, end of quote. And the dispute resolution clause in Article 9 is obviously one of such provisions of the agreement and should apply only to the matters occurring after the entry into force of the agreement.
The words that you just quoted, though, are not exactly the words of Article 12. I mean, I'm looking at
the provisions of this.
I'm looking at 7A. The provisions of this agreement shall apply to investments made by investors of one contracting party prior to as well as after the date of entry into force of this agreement, but it shall only apply to matters occurring after the entry into force of the present agreement.
That's exactly what I said. Yeah. The C7 had a wrong translation because it said it shall apply to cases occurring after. So it's different, was a little bit different, but we are in agreement that 7A is the right version. So in our view, the matter, so it's not only the disputes that was in 2003, 2004, but it's also the matters that I have just described that were at that time. So you don't actually need to decide whether there is identity of the disputes, the present one and the past one, if you decide on the basis of Article 12 and Article 9, because these events are certainly matters that occurred before the entry into force of the agreement. Now, claimants argue that this is not so, and that this provision applies only to the substantive provisions of the agreement. But we think that this cannot be reconciled with the text, because the text speaks about the provisions of this agreement. So it certainly covers Article 9, which is the dispute resolution clause, and in turn, Article 9 itself does not contain any temporal limitation. So from the textual point of view, I think the situation is clear. Now, there is another argument made by claimants, and you mentioned it was mentioned before, and that is that our interpretation allegedly would prevent the tribunal for looking into anything that occurred before the entry into force. So you would not be able to, for example, determine whether the existence of a prior investment. And we think it's not true because we think that and submit that the tribunal may take into account all relevant facts, including those relevant for establishing of existence of an investment that took place prior to the critical day. But the tribunal may not make determinations and rulings about matters occurring before its entry into force. So we think that there is a crucial difference between facts, which you might take into account, especially in order to determine past investments, and matters. And then we have given a number of examples of the use of the word matter, not only the dictionary one, but notably the use of the word matter or matters in the Charter, in the Statute of the International Court of Justice, things like that. For example, we all know the phrase matters essentially within the domestic jurisdiction. So a matter is different and much more complex than a mere fact. Then, even if we say that, or one could say that determination or making of a past investment is not a simple fact, that it's much more complex. It's not just, for example, a fact of buying a company. It will still be covered by Article 12 if we want to give effect to all its provisions. Because as you see, there are two clauses. One clause covers the application of the provisions, saying that they apply to investments after and prior to the entry into force of this agreement. But then there is another clause that I was now talking about, that the treaty shall apply only to matters occurring after the entry into force. And that means that Article 12 actually allows the tribunal to make all necessary determination to determine the existence of investments, but the tribunal should not go into other matters, because the second clause would prevent it from doing so.
Just to go back to Professor Douglas's sort of point, I mean, doesn't that though leave a respondent, and it's almost invariably going to be a respondent, with a veto on the proceedings going forward, because you will always be able to say as respondent, we contest some element of the pre-time bar conduct, and you, the tribunal, cannot address that contestation. So doesn't it give a respondent a veto?
Yeah, that argument has been made by claimants. I don't think so, because again, we have to go back to the meaning of the word matter. If we say everything is a matter, then the argument might fly. But if we say, well, there is a difference between facts and matters, then we, and everyone doing, dealing with international law knows that a matter is something which is not a dispute, then a contestation, then a situation, that's something that needs to be resolved. So it's much more complex than particular facts. So it's not really true that a respondent could just say, well, this is a matter from the past. It will have to show that there is a certain situation that actually took place before the treaty entered into force. And we believe that we have showed that such situation, such a matter existed before the treaty's entry into force.
And so an assessment by this tribunal of Nova's rights in respect of the property for purposes of evaluating whether it is able to bring a claim, you would say would not be a fact, but would be a matter which we cannot look at.
Yes, because there were all other events. So it's not simply that Obnova would come, and I will give you an example. If Obnova were to come to the tribunal and say we were, for example, we bought this property in 1997, that would be a fact. But and that's one thing. But wholly another thing is if they come and say, well, we have and register right to property. This was, and then you see that it was contested for many years, that there is someone else registered as the holder of the title, that there were two different administrative decisions rejected their property claims. So all that means that you will have to go back to the matter and decide all that. It's not just taking a fact into account.
Okay, thank you.
Okay, I think that I'm here
Just,
short of.
just very, very quickly.
Sorry.
Is it possible that parties meant disputes and not matters? Obviously, you would have picked up a translation error. I've seen a lot of clauses like this that refer to disputes. I haven't seen one that refers to matters. I'm just wondering if it's possible that that's an equivalent concept.
Well, I would say that we don't have obviously travaux that would be clear on this point, as far as I know. But I would say that we have to discern the intent of the parties also from the text of the treaty. If they use matters instead of disputes, and elsewhere they use the word disputes, that must mean something.
The treaty was, of course, drawn up in 3 authentic languages.
Yes.
I mean, English prevails, but we don't, unless I've missed it, have anything in the Serbian and Greek languages.
No, we don't. We have not have. I don't think that we have a Serbian and Greek languages on the file, but we can provide to the tribunal if necessary. Moving on quickly, there is a question of the sources of dispute. We rely there on the phosphates in Morocco and other cases of the PCIJ and ICJ. I'm not in the position to discuss that now because we don't have enough time. I'm just saying that claimants' idea that the difference between the sources of dispute and the sources of rights helps them is wrong, because in all cases that they invoked, there was agreement of the parties that before the title of jurisdiction, there was something that on which they agreed upon, which was not a source of dispute. That was a passage of Portugal between the cities in India. That was the electricity elements of electricity price in this electricity case of Bulgaria, Sofia. So what I'm saying here, we don't have that. We have a dispute, or at least a controversy that occurred before the title of jurisdiction entered into force. So I don't think that that helps them. And then we, in our submissions, refer to 2 additional cases. That's Germany v. Italy, jurisdictional immunities, and Liechtenstein v. Germany. And we discussed that in our last submission. And I think it's pretty clear that they help us. And let me just move on because we don't have time. I will just, for the record, say that we obviously have admissibility objection. The principles there are, I mean, the principle that abuse of process might be a reason to dismiss a claim is not in dispute between the parties, but the elements of the international standard are. That has already also been discussed by the parties extensively. And on the screen, you will see where the parties disagree. Now, I would just say in that regard that the main point about the restructuring is about the abuse of process is bad faith. Claimants are saying that was done for tax purposes. We haven't seen any document on it. We have only a statement of 2 claimants, or a claimant and a person behind claimants. And that should be in our submission taken with great reserve. And especially because Mr. Rand, as we know from another Rand case, keeps meticulous diary of all major events in his life. But we have seen his diary in that case. We haven't seen the diary in the present case. So there's also, raises certain suspicion.
Now, not for now, but again, I come back to a point I asked for comments on Philip Morris against Australia, in which there was very significant abuse discussion by the tribunal. So I would like you in due course to come back to Philip Morris Australia.
Okay, we would discuss perhaps that on Friday. We are ready to answer questions. And after this, I will obviously reiterate our objections, as my colleague Professor Keller said, about the 3-year limitation on the Canada Serbia BIT. And I would like to then move on to expropriation for the sake of time, because there are a couple of very important questions that we need to cover there. Our first point with expropriation is that Obnova never had property entitlements over the Dunavska plots and objects. And I will come back. I will just reiterate what my colleague Senka Mihaj said about it. Now, that is a very important question in the realm of expropriation, obviously. And another point is that it's decided under national law. And that brings me to the point that the question of properties of the Obnova's property entitlements was decided in 3 final decisions by Serbian courts. And mind you, these decisions are not under appeal. They are final decision. There is an extraordinary remedy that was filed with the Supreme Court of Serbia against these decisions, but that's an extraordinary remedy. So they are final and enforceable, the decisions themselves. And there, I would like to obviously reiterate what is in our submissions and what responds to your question of this morning to the claimants. There is a long-standing position, as you know, of international courts that they should not second-guess decisions of national courts in matters of national law, unless there is some gross miscarriage of justice or something similar. So I think that that's probably 100 years of practice or even more. So again, I think that we have 3 final decisions. We have 3 final decisions which are nothing new. They are not new practice. They are not new a position taken by Serbian courts. They are just a reiteration and repetition of what is constant practice of Serbian court in the matters in question. Now,
Sorry, 1 second. You said that they are extraordinary recourses.
Yes.
But they can overturn the decision.
Yes, they can. Yes.
They are filed in front of the Supreme Court.
They are filed before the Supreme Court of Serbia. Exactly. And it's a very limited, essentially, points of law and proceedings and gross violations of proceedings in the proceedings before the second instance. It's
like
a
a
very
cassation?
limited. Sorry?
Like a cassation of law and
Similar.
well,
Similar.
like
Yes.
but and can render a different decision.
They can. Yes. Or they can revoke the decision and remand it for reconsideration. Yes.
Thank
Now, we made an argument in our submissions about conditionality of other rights that are invoked by Obnova. So our position is that Obnova does not have property rights. It says it has. But it's also important to note that the right to conversion that they claim, or the right of use convertible to ownership, as they formulated it, this is a conditional right under Serbian law, which they failed to satisfy for a number of independent reasons. So first, they never had the right of use over the land, so they could not possibly seek conversion of the right of use into conversion. Second, the right of conversion has never been recognized by the authorities. So there is only a possibility that someone could claim or ask for conversion. Obnova never asked for conversion of its alleged right of use, even though this right existed since 2009, so 4 years before the measures in question. And if you look at Article 103 of the Law on Planning and Construction, it says a right of use may be converted into right of ownership. So it's clearly a possibility, but it's not automatic, it's not ex lege. And there is also a possibility of appeal against the decision on the request for the conversion. So that shows that, there is a possibility of negative decisions as well. Third, they never fulfilled one of the main preconditions for the conversion, and that is to be registered the holder of the right of use. And this is not some sort of petty formality. That's an important precondition set by the law, and that is confirmed by our expert, Professor Jotanovic. Fourth, independent reason why they cannot convert any alleged right of use is that there is an inherent limitation to conversion, and that limitation pertains to the land in public use or objects in the public interest that may be constructed on that land. In such case, the entity that is having the right of use cannot ask for conversion or cannot be granted conversion. And this was introduced in 2011. So that is before the investment of claimants. And it applies not only to the planning documents or designations for public use that existed in 2011, but also to the subsequent ones. And finally, conversion was not at all possible in 2003 when the 2013, sorry, when the DRP was introduced. And there is a confirmation of that fact by the Serbian court. So there is a series of reasons why Obnova could not attain official recognition of the right of use or the right of conversion over the Dunavska plots and objects. And we submitted it was in a similar position to the applicant in the ICSID Kopetsky case, well-known case, who had a conditional claim, and Obnova here also has a conditional claim, a claim that is dependent on the decision by the authorities and that is dependent on the fulfillment of a number of statutory requirements. And Obnova fails to fulfill these statutory requirements. The ECHR, the Grand Chamber, said in the Kopetsky case, quote, "The hope of recognition of a property right, which it has been impossible to exercise effectively, is not an asset." And here I can also say that the hope is not a property entitlement that could be expropriated in Obnova's case. Moving on to the second aspect of our expropriation argument, that is that the 2013 DRP was a good faith regulatory measure. And I think that there is no dispute between the parties that legitimate exercise of respondents' regulatory powers, is not an expropriation. And the elements of the international standard are on the screen. We submitted, we fulfill both of these elements. First, let me say here something about the illegality that was claimed today that of the 2013 DRP and its alleged inconsistency with the general plan from 2003. And we have a detailed argument on that in our submissions. So I will not bother you with that. That's at rejoinder at paragraphs 222 to 231. But here today, I would like to emphasize one thing, and that is important event or document because it shows the good faith of the regulatory measure in question and of the whole process of the adoption of the 2013 DRP. Now, the issue of predominant purpose of the land, which is in dispute between the parties, was considered and resolved in the procedure of the adoption of the 2013 DRP. In 2008, the City Secretariat for Urban Planning and Construction studied the issue and concluded that the proposed solution of placing the public transportation terminal on the Dunavska plots was in accordance with the 2003 general plan. So the issue was considered by the relevant authorities, and they concluded that there is no discrepancy between two-level planning documents. And obviously, again, I can just say if Obnova thought differently, Obnova could have raised this issue in the process of the adoption of the 2013 DRP, but it chose not to participate. Then I can also say that it's not true what claimants said today that the adoption of the 2013 DRP was arbitrary. We know, and it's on the record, that there were two studies discussing the location of the bus or the public transportation terminal. One was in 2006. Various factors were considered. You can see here the content, the table of contents. Another study, 2007, was prepared by the Public Transportation Company of Belgrade, also outlined certain selection criteria and concluded that Dunavska 17 to 19 was the location that fully satisfied them. Now, here, it's also important to note that the authors of this study were aware of the so-called land across the street. That's how I call it, this bus parking or whatever that is across Dunavska 17 to 19. You can see it on the screen, the last line in the box. So they were discussing the Dunavska plots. They found that the Dunavska plots were the best solution, but it says, but it's obviously they are aware that there is another plot across the street, which they didn't consider, but they are aware of it. So it's not that they are just arbitrarily forgot or just hidden that fact that there is another property across the street. Finally, the 2013 DRP itself outlined the criteria for the use, for the selection of the location, and discussed them and concluded that the Dunavska street location is the best one. So all this shows that the 2013 DRP was not an arbitrary measure, but a permissible regulatory action. A second element of the international standard for permissible regulatory actions is that they are non-discriminatory, and I think that the parties agree on the applicable legal standard, that is Saluka and other cases. Claimants argue that Obnova was treated differently from other landowners in the area without justification, as their land was not converted into a bus loop. Now, claimants forget that the international law standard is that they need to identify other investors or investments that are in a similar situation. Particularly that these investors or investments should be in the same sector, industry, and have the same rights. So I would submit to you that claimants would have to identify a person having similar purported property entitlements to what claimants argue is Obnova's situation. Having unregistered right of use over the land, unlegalized and unregistered ownership or the right of use over the objects on the land. And then claimants must show that this person was treated differently than Obnova. For example, that a planning document took their rights into account, but failed to do so in case of Obnova. Claimants fail to identify any such person. What they do is they again invoke what I like to call the land across the street, but this is not a proper comparator because the land must be an investment and its owner must be an investor in the sense of the treaty of the Cyprus-Serbia BAT. And obviously state is not an investor in the sense of that treaty. And in any case, the situation is not the same because the city of Belgrade is inscribed as the owner of this land across the street, unlike Obnova, which is not, who is not inscribed as the owner. So they are not in a similar situation. So there is no comparator. There is no similar cases that were submitted by claimants. And obviously, even if there were, as I have mentioned, there was ample justification why to make a bus terminal at the Dunavska location and not someplace else. So in conclusion, this was not the 2013 DRP was not a was a legitimate non-expropriatory measure and not an expropriation. Finally, just briefly, claimants claim indirect expropriation. Yeah, perhaps next slide, please. This is just the due process that I'm not going to discuss now. We all know the standards for indirect expropriation, very high. Various phrases have been used, such as virtually annihilated investment, complete deprivation of the value of investment, etc., etc.
I think the claimants are relying on the Santa Elena, which sets out a rather different standard, and that's been adopted in a number of other tribunals since then.
Yes, but we consider, I believe that we already dealt with that in our country memorial. We consider that Santa Elena is not applicable because it was not, it was different. The claimant there was in a different situation. So that is the first thing but I can that I can mention, but I can elaborate on that a little bit more on Friday. And finally, so to show the extent of alleged deprivation, I could just say that Obnova still uses the property. And second, if we may go to the financial statements, you can see the value of the property that they declare, and you can see that they continue to declare a relatively substantial value of the property in question from 2012 to 2021. In other words, there was no complete deprivation of the value of their investment. And with that, I will finish with expropriation. Sorry if I was a little bit fast at moments. And I will hand over to my, if you don't have any questions, to my colleague, Monica Dill.
And before you do, and this is not to detain you, but you addressed the points in passing about the tribunal's role vis-a-vis domestic court decisions. There is a case that I think is not in the record, but is very much in the public domain and which has been referred to, which touches upon this. I'm only mentioning it for transparency for both you and for the claimants, in case you want to reflect on it, and that's Eli Lilly against Canada, a 2017 decision. It's a NAFTA decision, and I think the relevant paragraphs are around about 223. So if you want to reflect on that for purposes of coming back in due course, please do. But with that, let me hand on to you, Mr.
Yeah, thank you very much.
Thank you, members of the tribunal. And with the appreciation that we are passing microphone a lot towards the end, I would like to guide you through the last part of our submission on the remaining substantive standards, together with my colleague, Sarah Lemoyne.
You have about 25 minutes.
Thank you. So, members of the tribunal, about the claimant's allegation that Serbia has breached the fair and equitable treatment standard. Claimants say that when they invested in Obnova, they expected to be able to develop Obnova's premises for residential and commercial purposes, as we have heard earlier today. And claimant's case on FET, as we know by now, has two main strands. So the 2013 DRP, which allegedly blocked this development, and this is raised only by the Cypriot claimants. And the second one, the 2021 letter, in which the Land Directorate informed Obnova that it is not entitled to compensation. And this is raised by all three claimants, including Mr. Broshko, whose investment postdates the DRP. So as we have heard, claimants' FET claim comprises allegations of expropriation, violation of legitimate expectations, arbitrariness, and discrimination, but claimant's case on all of these counts fails. So just briefly on expropriation, as my colleagues earlier have discussed, the 2013 DRP was not and could not have been expropriatory, as Obnova held no property rights to the Dunavska plots or the objects, which would be capable of being expropriated. And even if an expropriation would have occurred, this does not automatically mean a breach of the FET standard, contrary to what claimants have raised in their submissions. And claimants' authority on that, Unglaube versus Costa Rica, actually demonstrates that a finding of an FET breach may lead to a finding of an expropriation, but not necessarily the other way around. And in any case, as you have seen on the slides, the tribunal in Unglaube actually did find an expropriation, but it did not find an FET violation. And it has raised that did not find simply convincing evidence for an FET breach, which shows that there are different conditions for the two standards. And the tribunal noted, I quote, "As intelligent and experienced investors, claimants were of course required as part of their due diligence to become familiar with host state law and procedure." So this only shows, as also explained by the tribunal in Mamidoyle, that the two standards have different prerequisites. And just briefly on the minimum standard of treatments, and you can see the two FET clauses on the slide now. Claimants have not alluded to this today, but they have raised this in their submissions. They are wrong that the FET clauses in both treaties are essentially the same. The FET clause, as you can see on the slide in the Canadian BAT, contains a specific reference to the customary international law minimum standard of treatment, whereas the Cyprus Treaty does not. And under the rules of treaty interpretation, this must mean that the parties to the Canadian BAT intended for the FET clause to be limited with the minimum standards. And contrary to claimants' allegations, the minimum standard of treatment is not an outdated concept. It imposes a high threshold for establishing a breach and requires an act that is sufficiently egregious or shocking. And this was confirmed, for instance, by the tribunals in Al-Tamimi versus Oman, but also more recently by the Berkowitz versus Costa Rica decision, which the president has already mentioned. And this is one of the examples for which we refer to this particular decision. So,
Mr. Can I just take you back to your Unglaube decision, because you quoted paragraph 258. I mean, in the immediately preceding paragraph, the tribunal, in fact, takes a slightly different and more nuanced view. They say the tribunal has already ruled on some of those actions of respondent amounted to de facto expropriation. That violation of the treaty might alternatively have been explained in terms of violations of the fair and equitable treatment standard, since, as is well known, expropriation may result from a variety of potential causes. Amongst these are included situations where violations of the fair and equitable treatment standard and their consequences are so severe that they result in the taking of investors' property. So, I mean, I think to understand 258, you've got to read 257, and I'm not quite sure that it's quite as authoritative as you seem to be suggesting. I mean, you've got it in the previous slide, sorry.
right. Our point here was that claimants use this authority to say that whenever there is a finding of an expropriation, the tribunal can also find a breach of an FET just because there is an expropriation. And our point is that the tribunal in Unglaube decided in reverse. So they said that whenever there is an expropriation, the source of the expropriation might be an FET violation. So it's a reverse exercise, so to say. And the tribunal in Unglaube, we quote 258, particularly to show that even though they did find an expropriation, they did not find an FET violation, to prove that these are two different standards and not necessarily one.
So your point is simply, you can't take expropriation and read it into FET.
Correct. Correct. So moving on to the broader understanding of an FET standard in this case, claimants' portrayal of the FET in both treaties is too expansive and actually outdated. FET standard is not an insurance policy from business risks and failed due diligence. Even though the standard may not be defined, it's a very fact-specific exercise with limitations, and legitimacy of expectations is one such limit. What lies at the heart of claimants' FET case in this matter are expectations that were simply not reasonable. In our submissions, we have outlined that claimants need to prove Serbia's promises or individual assurances that are directed at them, that are precise, that are unambiguous, rather than just misplaced optimism or hope. We have also underlined that a general reference to the relevant domestic law framework is simply not sufficient to establish legitimate expectations. And in claiming an alleged legitimate expectation that they would be able to develop the Dunavska plots, claimants essentially rely on two things. First, Obnova's ownership of the objects and the right of use of the Dunavska plots, And second, the 2003 general plan for the city of Belgrade, which was described by Dr. Jeric, according to which the prevailing use of a block, including the Dunavska plot, allegedly should have been residential and commercial development. But none of this, members of the tribunal, is an individual, unambiguous, or specific assurance made by Serbia to claimants. It is not even hope or optimism. Obnova had no property entitlements, while the general plan did not exclude the possibility of placing the transportation terminal on the Dunavska plots. So this in itself should end the case on legitimate expectations. But what is more, due diligence is key to establish reliance on legitimate expectations. The investor must prove that its expectations are based on an investigation into the applicable legal and business framework. Now, when dealing with an acquisition of property, the Gavrilovic versus Croatia tribunal found, as you can see on the slide, that the investor should conduct an extensive investigation into the precise properties and plots, and in absence of such an investigation, should be denied investment protection. Now, the relevant time of ascertaining the legitimate expectations is, of course, the time of making the investment. Claimants do not seem to dispute that. Therefore, claimants would need to show the outcome of such investigations into the property rights, Serbian rules on property law, or urban plans and related compensations that they have performed before investing in Obnova. But they did not. Now, claimants' own evidence shows that none of Coropi, Kalemegdan, or Mr. Broshko, or even Mr. Rand back in 2005, performed due diligence into Obnova's property rights, various risks associated with the plots, or the likelihood that the property will be used for public purpose. And when they did learn of any such risks, they simply considered them non-issues. So, for example, Mr. Rand testifies that to the best of his knowledge, Obnova did not pay any rent. As we heard earlier, rent was being paid. He also stated that he no longer recalls whether he discussed the registration or legalization proceedings with Mr. Obradovic or anyone else in 2005. Mr. Rand, however, concedes that he was informed that the Dunavska plots were under state ownership, but anticipated that this will change. Tellingly, there is no documents or evidence whatsoever to substantiate Mr. Rand's anticipation. No market analysis, no legal advice. As you can see on the next slide, Exhibit C337 is an email exchange between Mr. Broshko, Mr. Rand, and Mr. Markicevic, who are all witnesses in these proceedings. And it evidences that the claimants were also aware of the uncertainties surrounding the conversion of Obnova's alleged right of use to the right of ownership. Finally, Mr. Markicevic, who claims to have been responsible for managing Obnova, explains that the city's 2003 registration as the owner of the plots was seen as a non-issue. Now, on the DRP, Obnova was well aware of the planned location of a public transportation terminal at the Dunavska plots at least from March 2008, long before the alleged investments were made. Therefore, its owners, nominal or beneficial, also should have been aware. And Mr. Rand admits that he had heard of it, but thought the matter went dead without investigating further. And also, the 2013 DRP could not have breached claimants' legitimate expectations, as placing the terminal on the part of the Dunavska plots as raised by Dr. Jeric was fully aligned with the earlier 2003 general plan on which the claimants rely. In any event, the rules for specific purpose of the areas are specified in detailed regulation plans, not the general plans. And this is why Obnova should have been monitoring the adoption of the DRP. But it did not, as confirmed by claimant's witness, Mr. Markicevic. The public inspection of the 2013 DRP was fully aligned with the applicable law and procedures. What is particularly striking here is that the public inspection was announced in two mainstream, widely read, even if tabloid, newspapers. It was also presented during the Belgrade City Assembly and lasted for a whole month. But Obnova simply failed to notice. Mr. Markicevic testified that the adoption of the plan surprised him and that afterwards he found that the plan was made available to the public and it was possible to submit objections against it. If this does not show lack of due diligence on the part of the claimants, nothing does. Similarly, with regard to the 2021 letter, claimants could not have held any legitimate expectations that Obnova would be compensated in relation to the DRP, as Obnova was not a registered owner of the property. We have also explained in our submissions in detail that the Land Directorate was neither competent nor authorized to decide on Obnova's request. Only the Serbian courts have such authority, and this is admitted by Serbian law experts. Quite tellingly, as we have heard also in the claimant's opening today, Mr. Broshko testifies that he simply believed Obnova would be provided with compensation or expected issues to be resolved so that Obnova could develop its land, but that he did not need to conduct any due diligence. So it looks like in 2013, Obnova simply missed on the opportunity to comment on the DRP, and claimant's case on the 2021 letter is that after the DRP was adopted, it hoped for compensation without any due diligence as to whether the request for compensation is submitted with the proper form. We submit that it would be utterly unfair to hold Serbia liable for claimant's lack of due diligence or failure to even try to achieve a fully informed understanding of Serbian property law and the regulatory framework concerning urban plans and related compensations. Now, I will not address the issues of arbitrariness and discrimination, which are also part of the FET, because they were covered by Dr. Jeric just earlier. Similarly, with regard to attribution, our points are outlined both on the slides and the previous submissions. I will not deal with that because the claimants also omitted this today. Just on the last point about the compensation letter, the Land Directorate was correct in indicating that no compensation is due, but the proper course of action would have been for Obnova to initiate court proceedings for payment of compensation, which it did not do. And this brings me to the very last point, the importance of attempt at local remedies. And we mean here local remedies concerning the DRP and the 2021 letter, so the denial of compensation. So our point here is that the role of an international tribunal under the FET is not to be an administrative review body for urban plans or related compensations. It is undisputed between the parties that such proceedings should have been issued locally, but they were not. And as using the words of Mr. Markicevic, they simply did not believe that it would be efficient. So this closes our arguments on the FET standard, and I will just pass the microphone on to Ms. Lemoyne to just briefly discuss the remaining substantive standard and to wrap up our opening.
10-minute short straw.
Thank you very much, members of the tribunal. I'll be brief as I realize I'm the only thing standing between this room and a weekend in Paris. So I'll now explain why claimants' remaining claims should be rejected. First, addressing their allegations of unreasonable and discriminatory treatments. And this applies to both the 2013 DRP and the 2021 letter from the Land Directorate. Now, in this regard, claimants invoke the MFN clause in both the Cyprus-Serbia and Canada-Serbia treaties shown here on the slide to attempt to benefit from protection against unreasonable and discriminatory measures from other treaties concluded by Serbia. But Serbia's position is that these MFN clauses do not entitle the claimants to access entirely new standards of protection. And in this regard, I can be quite brief because claimants' arguments here rest on the incorrect premise that the non-impairment standard constitutes more favorable treatment compared to the treatment that's provided under these base treaties. This is their view because they argue that the legal standard for unreasonableness is broader than the FET standard contained in these home treaties. But this is wrong. Unreasonableness has a similar meaning in the context of the non-impairment standard, as in the context of the FET standard, with which it is also associated. And you can see this overlap between claimants' description of the FET standard and the meaning of and their explanation of the unreasonableness standard earlier today. Same for non-discrimination. So if anything, the non-impairment standard, which requires proof of impairments, is stricter than the FET standard. And this negates the very premise on which claimants have based their invocation of the MFN clause. And just very briefly here, with regard to the Canada-Serbia BIT, Article 5, the MFN clause there also contains additional limiting language. It provides, and I quote, "Each party shall accord to an investor of the other party treatment no less favorable than that it accords in like circumstances to investors of a non-party." And the phrase "in like circumstances" is important here. According to the International Law Commission, this term limits the application of an MFN clause, and I quote, "to only those investors or investments that are in like circumstances with those of the comparator treaty." And other recent tribunals have adopted this position as well, and in doing so have declined to apply the MFN clause, similarly worded as to the one under the Canada-Serbia BIT, to access substantive rights in other investment treaties. But just moving on, even if claimants were permitted to rely on the MFN clause to access the non-impairment standard, their claims based on this standard must fail. And as I won't get into this, as my colleagues have already explained this today, but neither the 2013 DRP nor the 2021 letter from the Land Directorate was unreasonable or discriminatory. And they've also not shown that their investment was impaired. And this goes back to the fact that Obnova really didn't have any rights which were impaired or impacted by the 2013 DRP or the 2021 letter. I'll now briefly address the last claim regarding the alleged umbrella clause breach. And since the Cyprus-Serbia BIT doesn't contain an umbrella clause or any other rights pertaining to the same subject matter as an umbrella clause, the Cypriot claimants have again evoked the MFN clause. But again, Serbia's position is that the MFN clause does not permit the Cypriot claimants to access additional new standards of protection. And in any event, the umbrella clause that they rely on from the UK-Serbia BIT is not even engaged here. As you can see here on the slide, Article 2.2 states that, and I quote, "Each contracting party shall observe any obligation it may have entered into with regard to investments of investors of the other contracting party," end quote. So this provision very clearly applies only to obligations that Serbia has entered into with regard to investments. And this means it doesn't cover laws of general application, which are not specifically addressed to foreign investors. And this is something that has been firmly established by other tribunals, and some of which are listed here on the screen. So I'll pass over that for now. But the key point here is that the Cypriot claimants, the BIT does not, has a limited scope, or the umbrella clause has a limited scope. It's not engaged here. The Cypriot claimants' umbrella clause claim rests entirely on laws of general application. Specifically, they're alleging that the Land Directorate's denial of compensation in 2021 violated Serbia's obligations under the law of expropriation and the Serbian constitution. Again, these are laws of general application. They're not directed specifically to Obnova or any other investors. And Serbia has not otherwise assumed any specific obligation vis-a-vis Obnova or the Cypriot claimants to award compensation. So consequently, there's no basis for their umbrella clause claim. And then turning as well just to the facts, I won't repeat these as well, but again, Serbia has not breached any obligation in any to compensate Obnova in relation to the 2013 BIT. And I would like to now just very, very briefly wrap up Serbia's opening statements and outline some key points for the tribunal's decision-making and for this hearing. Due to the time constraints, I will simply refer members of this tribunal to the decision trees that are set out here in this presentation, and just note a few couple takeaway points. So the tribunal will see that the claimant's case falls apart on jurisdiction alone, and there's a number of different paths that lead to that conclusion under both the BITs. But even if the tribunal decides that these jurisdictional objections are not sufficient to dismiss claimant's case, it collapses on the merits. And as the tribunal has heard, this is ultimately a dispute concerning Obnova's property rights, which were not properly investigated by claimants when they first invested. Their half-hearted efforts to establish Obnova's alleged property rights and to convert them into ownership all failed. And this has been confirmed by the Serbian courts in 3 final and binding judgments. Claimants sort of dispute the outcome of these decisions, but they don't allege any international law obligation in that regard. And so the fact that Obnova has no property rights is sufficient to dispense with their ill-founded claims. But even if that were not the case, there's a number of other cases suffers from a number of other defects, which have been covered by my colleagues today, and that includes the lack of reasonable expectations regarding their ownership rights or alleged ownership rights or entitlements, and expectations of compensation, as well as the fact that the 2013 DRP was a legitimate regulatory measure taken on a non-discriminatory basis and in line with planning documents. Now, claimants are clearly dissatisfied with the way things have panned out. But if their investment in Obnova is to be considered a failure, then the fault lies firmly at claimants' feet, having failed to carry out a proper due diligence and comply with the applicable law when investing. And instead of challenging the 2013 DRP or requesting compensation through the Serbian courts in relation to the 2013 DRP, they're now bringing their claims in this arbitration. As we've heard, these claims are riven with contrivances and inconsistencies. They fall outside the tribunal's jurisdiction, and above all, they lack merit. So Serbia asked this tribunal to see this case for really what it is, which is an attempt to elevate a Serbian property law dispute to an international one, and to recast a bad business decision as a win. And with this, I'll conclude Serbia's opening statements and thank everyone for their attention this afternoon.
Thank you very much, Mr. Murray. That does bring us all to the end of what I think is quite a long sort of opening day. I'm not sure that anyone is going to be having, maybe apart from members of the tribunal, a relaxed weekend in Paris. Let me just turn to my colleagues and see whether there are any questions that they would like to raise. No. I have no questions of substance. I think that as it concludes the formal part of this, but let's just spend 5 minutes to identify whether there are any housekeeping issues, either that have arisen out of today's proceedings or that we will need to get to for next week. Claimants? Mr. President. Just one.
No, we have nothing. Thank you.
Then only one or perhaps two points to note from my perspective. First of all, as the tribunal will do, but we very much invite the parties to do as well, when you go through the transcript, please do identify questions that we have put to you that either you haven't answered at all or that we have indicated we would like a fuller sufficient sort of answer to come back to. We'll do the same, and we will endeavour to put those questions to you again in advance of next Friday, but you've got a little bit of time. The second point is just a practical housekeeping point that we'll get to with regards to transcripts. I mean, my appreciation, very much appreciation to the court reporter, as I see that she's been going through and trying to insert into the record as she's been preparing it references to the slides. I'm not sure that all of those references have been captured, but in any event, I think in due course, we will invite the parties when it comes to review and correction of the transcripts to go through and insert references to the slides, and indeed also to insert references to exhibits for our benefit in due course. When we come to use the transcript, it will be a much more user-friendly document and to the assistance of your arguments if we're able to identify precisely where to go to look at these things. But that's something that we'll come to next Friday in the housekeeping. So I think without more ado, have as good a weekend as you can possibly have. And I think that we are due to start on Monday at the very particular hour of 9:20. And I think the very particular hour of 9:20 is simply so that we can spend 10 minutes dealing with any housekeeping, and then we start on the clock at 9:30. But see you here. Yeah, thank you very much indeed. And my appreciation and the tribunal's appreciation to counsel, both the advocates and those who've been working alongside the advocates. I think this has been very helpful indeed, and it's always quite a heavy lift at the beginning. So appreciation. Thank you.
Thank you.